À l'ordre, tabling of documents, dépôt de documents. Introduction of government bills. Mr. Hill for Mr. Straw, seconded by Mr. O'Connor, moves for leave to introduce a bill entitled An Act to Amend the First Nations Commercial and Industrial Development Act and another act in consequence thereof. Cette motion est réputée adoptée.
Motion is deemed adopted. Mr. Hill for Mr. Straw moves that this bill be now read a first time and printed.
Deemed adopted.
First reading of this bill, première lecture de ce projet de loi.
When shall the bill be read a second time? À la prochaine.
At the next sitting of the House.
Rapport de délégation.
Reports from interparliamentary delegations.
Grenville.
Thank you very much, Mr. Speaker. Pursuant to Standing Order 34.1, I have the honour to present to the House in both official languages the following reports of the Canadian delegation of the Canada-United States Interparliamentary Group respecting its participation in the following conferences. Number 1, the Council of State Governments 64th Annual Meeting of the Midwestern Legislative Conference held in Overland Park, Kansas, August 9th to 12th, 2009. And secondly, the Canadian-American Border Trade Alliance Conference held in Washington, D.C., September 20th to 22nd, 2009. Thank you very much, Mr. Speaker.
Rapport de délégation.
Reports from interparliamentary delegations.
From committees, the Honourable Member for Selkirk Interlake.
Thank you, Mr. Speaker. I have the honour to present in both official languages the fifth report of the Standing Committee on Environment and Sustainable Development in relation to Bill C-311, an act to ensure Canada assumes its responsibility in preventing dangerous climate change. Report the bill back to the House without amendment.
The Honourable Member for Lévis-Bellechasse.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. I'd like to take this opportunity to wish you happy holidays, and I have the honour to present in both official languages the third report of the Committee on Official Languages. This has to do with a motion regarding the Publication Assistance Program and the new Canada Periodical Fund. Thank you, Mr. Speaker.
For Wellington, Halton Hills.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. I have the honour to present in both official languages the ninth report of the Standing Committee on Industry, Science and Technology regarding an Act, Bill C-309, an Act establishing the Economic Development Agency of Canada for the region of Northern Ontario. The Committee requests an extension of 30 days to study this bill properly.
Standing Order 9713A. A motion to concur in the report is deemed moved, the question deemed put, and a recorded division deemed demanded and deferred until Wednesday, January 27, 2010, immediately before the time provided for private members' business. The Honourable Member for Prince Edward Hastings.
Well, thank you, Mr. Speaker, and today I have the honour to present in both official languages the 23rd report of the Standing Committee on Public Accounts in relation to its study of Chapter 7, Acquisition of Leased Office Space of the May 2006 report of the Auditor General of Canada, Place Victoria. Pursuant to Standing Order 109 of the House of Commons, the committee requests the government table a comprehensive response to this report.
The Honourable Member for Vegreville-Wainwright.
Thank you very much, Mr. Speaker. I have the honour to present in both official languages the fifth report of the Standing Committee on Natural Resources in relation to Bill C-20, an act respecting civil liability and compensation for damage in case of a nuclear incident. The committee has studied the bill and has decided to report the bill back to the House with amendments.
The Honourable Member for St. John.
Thank you, Mr. Speaker. I have the honour to present in both official languages the ninth report of the Standing Committee on Fisheries and Oceans in relation to the operation and maintenance of small craft harbours. Also pursuant to Standing Order 109 of the House of Commons, the committee requests the government table a comprehensive response to the report.
The Honourable Member for Vancouver Centre.
Thank you, Mr. Speaker. I have the honour to present in both official languages the 9th report of the Standing Committee on the Status of Women in relation to pension security for women. The study has allowed the committee to explore questions relating to both public and private pensions and to examine the question of income security for women who have not participated in the paid workforce. Pursuant to Standing Order 109, the committee requests a response from the government. Thank you.
Présentation de rapport de
Presenting reports from committees.
introduction of private members' bills. Dépôt de projet de loi d'intérêt public émanant.
First reading of Senate public bills.
Motions. The honourable member for Winnipeg North.
Thank you, Mr. Speaker. On this day, which is United Nations Human Rights Day, I believe if you seek it, you will find unanimous consent for a motion. So I move, seconded by the honourable member from Charleswood St. James, Assiniboia, that this House calls upon the government to ratify the Convention on the Rights of Persons with Disabilities, which was tabled in the House by the government on Thursday, December 3rd, 2009, as soon as all provinces have given their consent.
The honourable member for Winnipeg North have the unanimous consent of the House to propose this motion? There's no consent. Okay, motions. Présentation.
Presenting petitions.
Honorable député de Beauce.
The honourable member for Beauce. Thank you, Mr. Speaker. I'm tabling a petition signed by people in various municipalities in my riding who are afraid that the moratorium on post office closures will not be maintained. It is very important to the economic and community well-being of our communities, and we ask the government to maintain the moratorium on post office closures. We also want a postal services increase. Thank you, Mr. Speaker.
Mr. Speaker, I rise to present a petition in support of the Universal Declaration on Animal Welfare. These residents of Halifax West and other parts of Nova Scotia who've signed this petition believe that efforts should be made to prevent animal cruelty and to reduce animal suffering. The petitioners note that over 1 billion people globally rely on animals for their livelihoods. Many more rely on animals for companionship. This petition asks the Government of Canada to support a Universal Declaration on Animal Welfare.
L'honorable député.
The honourable member for Richmond-Arthabasca. Thank you, Mr. Speaker. I'd like to table 2 petitions coming from citizens in my riding who are asking that the moratorium on post office closures be maintained. And I have here petitions from Kingsbury and other towns. There have been various resolutions on the part of municipalities in my riding asking the minister responsible for Canada Post to maintain postal services and to maintain the post offices. Thank you, Mr. Speaker.
For Sault Ste. Marie.
Thank you, Speaker. I presented a petition this morning similar to one that was previously presented, calling for support for a Universal Declaration on Animal Welfare, and it's signed by 165 people from across my riding.
The honourable member for Renfrew, Nipissing, Pembroke.
Thank you, Mr. Speaker. I have 2 petitions. The first, the petitioners are asking that since the province of Ontario is planning multiple wind farm sites, in the absence of independent science-based studies, they're asking that Parliament reject any funding applications for federal government assistance until the health and safety planning, taxes, etc., have been considered by the Ontario government. And the second petition involves the Canadian Institute for Neutron Scattering, who have put together a proposal to replace the aging NRU with a new reactor using similar technology and situated at Chalk River. Thank you.
The honourable member for Cardigan.
Thank you, Mr. Speaker. I have a petition here from a number of residents from the Cardigan riding in Prince Edward Island who are concerned about the employment insurance program in the fishery. We, the undersigned residents of the riding of Cardigan, province of Prince Edward Island, draw the attention of the House of Commons to the following: that the fishers be allowed to use the 2008 earnings to determine their 2009 eligibility and benefit rate for fishing EI to offset the lost income and the consequence it has on an overall annual income to fishermen of Eastern Canada. Therefore, your petitioners request the House of Commons to direct the Government of Canada to allow self-employed fishers to use 2008 earnings to determine their 2009 eligibility and benefit rate for fishing employment insurance. Thank you, Mr. Speaker.
Honorable Deputy de Bar-Richelieu.
The Honourable Member for Bar-Richelieu, Nicolas Bécancourt. Thank you, Mr. Speaker. I'd like to table a petition from the municipalities of Saint-Robert, Sainte-Victoire-de-Sorel, de Monceau, Le Mieux, Saint-Sylvain, and Fortierville. These petitioners are concerned about Canada Post and ask that the moratorium on closures be kept, and they would hope that the postal services be maintained. And I take this opportunity, Mr. Speaker, to give you my best wishes for the holidays on behalf of all members and especially those in my party.
And I'm pleased to present two petitions from Victoria residents and other Canadians who live on the West Coast. The first petition stems from the concern of Canadians with the loss of 6 million sockeye, the lowest return in 50 years, Mr. Speaker, and they were pleased to hear the government's announcement of an independent judicial inquiry. But I think it's worth noting, Mr. Speaker, that they specify that this inquiry should explore all the facts, consult with scientists and stakeholders, and determine what went wrong with this year's sockeye run, and present a public report with binding solutions within 6 months. The second petition, Mr. Speaker, is from residents who urge the federal government to exercise our collective prerogative to protect the health of our citizens by applying the precautionary principle to the use of cosmetic pesticides. And they are asking that the federal government enact a moratorium on these non-essential pesticides until such time as they're conclusively proven to be safe, not just in the short term, but in the long term as well. Thank you, Mr. Speaker.
Honourable Member for Souris Moose Mountain.
Thank you, Mr. Speaker. I have a petition where petitioners are calling upon Parliament to enact legislation that would recognize unborn children as separate victims when they are injured or killed during the commission of an offence against their mothers, allowing 2 charges to be laid against the offender instead of just 1. They draw to the attention of this House that under the current federal law, an unborn child is not recognized as a victim with respect to violent crimes. They draw attention to the House that 72%, the vast majority according to an Environics poll on October 2007, supports laws that protect unborn children from acts of violence against their mothers and also injure or kill the child in their womb. That in the current federal criminal law, an unborn child is not recognized as a victim with respect to violent crimes, and they wish legislation to be passed. Mr. Speaker, thank you.
The Honourable Member for Mississauga South.
Thank you, Mr. Speaker. 2 petitions. The first on a very important issue I note to this House on child pornography and victimization. These petitioners from my riding of Mississauga South want to draw to the attention of the House that the creation, use and circulation of child pornography is condemned by a clear majority of Canadians, and that the CRTC and Internet service providers have a responsibility for the content that is being transmitted to Canadians, and that anyone who uses the Internet facilities to facilitate any sex offences involving children is committing a federal offence. These petitioners therefore call upon the Parliament of Canada to protect our children by taking all necessary steps to stop the Internet as a medium for the distribution of child victimization and pornography. Briefly, the second one, Mr. Speaker, is one that the House embraced earlier, but these petitioners from my riding concerning support for a universal declaration of animal welfare, and they simply want to add their names to the number of members and Canadians who have already indicated that they support, Mr. Speaker, that the Government of Canada support a universal declaration on animal welfare. Thank you.
The Honourable Member for Vaudreuil-Soulanges. Thank you, Mr. Speaker. I'm tabling a petition on behalf of my constituents who are concerned about post office closures. They would like the government to maintain its moratorium on closures and maintain postal services because of the importance of post offices in the economic and social life of my riding, and also the economic support of the post office in general. And we'd like to oppose the bill tabled by the government, which would make legal repostage. I also have a petition supporting the bill's motion C-480. This is a bill which would follow up on the roundtable on the social responsibility of mining companies, and I have here 2 petitions to this effect. Thank you.
North.
Thank you, Mr. Speaker. I have 3 petitions. The first one has to do with concerns from constituents and others about the 14,000 men, women, and children who die every day from tuberculosis, malaria, and HIV and AIDS. They call upon this House to support Bill C-393, my private member's bill, and they are pleased that it received the support of second reading, and call upon this House to complete the process and ensure that it becomes law. The second petition, Mr. Speaker, is from constituents concerned about about animal cruelty and animal suffering, and they call upon this government to support a universal declaration on animal welfare. And finally, Mr. Speaker, also pleased to present a petition by people concerned about safety in the air and about the fact that the responsibilities delegated to aviation companies via the safety management system is a problem. They call upon the government to initiate a commission of inquiry headed by a Superior Court judge to conduct a judicial review into Canada's state of national aviation safety and government oversight of the aviation industry, to be followed by further reviews at defined intervals. Thank you, Mr. Speaker.
Honourable Member for Vegreville Wainwright.
Thank you very much, Mr. Speaker. I'm honoured to present a petition on behalf of constituents who call on Parliament to consider putting forth legislation to deal with the problem of bullying. They've noticed that bullying is an increasing problem, which, due to technologies like the Internet, email, has become a 24-hour, 7-day-a-week problem. Thank you, Mr. Speaker.
Honourable Member for Vancouver Quadra.
Thank you, Mr. Speaker. I'm pleased to rise in the House today and present a petition in support of that calls on Parliament to set a timetable to meet Canada's development assistance commitments. That calls on Parliament to increase Canada's foreign aid commitments to combat HIV, AIDS, tuberculosis, and malaria, and to make the legislative changes necessary for Canada's access to medicines regime to facilitate immediate and sustainable lower-cost generic medicines flowing to developing countries, i.e. supporting Bill C-393. Mr. Speaker, these petitions are signed by the residents of Vancouver Quadra and stem from the heroic efforts of the African grandmothers to raise children orphaned by AIDS. They are supported by the efforts of over 200 grandmother groups across Canada. Thank you, Mr. Speaker.
Honourable Deputy Drummond.
Member for Drummond. Mr. Speaker, following the closure of the Saint Charles de Drummond post office without warning, over 450 residents signed the following petition calling on the federal government and the Canadian Postal Corporation, and I quote, to review their decision to close the post office on Boulevard Saint-Jean, Drummondville, to keep a post office there until the end of the contract in October 2010, and then to proceed immediately with a tendering process in order to find a new partner.
Kona.
Thank you, Mr. Speaker. My petition is a call to adopt Canada's first air passenger Bill of Rights. The petitioners support Bill C-310, which includes compensation for overbooked flights, cancelled flights, and unreasonable tarmac delays. The legislation is inspired by European Union law. In fact, Air Canada is already operating under the European laws for their flights to Europe, so why shouldn't Air Canada customer receive better treatment in Europe than in Canada? The bill will ensure that passengers are kept informed of flight changes, whether they're delays or cancellations. The new rules will be posted in the airports, and airlines must inform passengers of their rights and the process to file for compensation. The bill deals with late and misplaced baggage. It deals with all-inclusive pricing by air companies to be included in their advertisements. Bill C-310 is not meant to punish the airlines. If they follow the rules, they won't have to pay a dime in compensation to passengers. Mr. Speaker, the petitioners call on the Government of Canada to support Bill C-310 that would introduce Canada's first air passenger Bill of Rights.
honourable member for Langley.
Thank you, Mr. Speaker. I am honored to present three petitions this morning. The first one regarding the long gun registry. It says that the long gun registry was originally budgeted to cost Canadians $2 million, but the price tag spiraled out of control to an estimated $2 billion a decade later. That the registry has not saved one single life since it was introduced. It's therefore calling upon the House of Commons to support legislation that will cancel the Canadian Long Gun Registry and to streamline the Firearms Act. The second petition, Mr. Speaker, regards medical benefits, and it says that a parent or child care giver does not qualify for long-term medical EI insurance if the illness is not necessarily permanent or life-threatening. That many times it causes a problem for parents and caregivers because they're not able to support their mortgage obligations, and they're calling upon the House of Commons to enact legislation to provide additional medical EI benefits to at least equal to maternity EI benefits. The last petition, Mr. Speaker, says that Canada is a country that respects human lives, including in the Canadian Charter of Rights and Freedoms, and that everyone has the right to life. It then says that Canada has not had law to protect the lives of the unborn children since 1988, and they're calling upon Parliament to pass legislation for the protection of human life from the time of conception until natural death. Thank you.
The Honourable Member for Chambly-Bordua. Thank you, Mr. Speaker. Mr. Speaker, I have the honour to table a petition for over 1,500 signatories from Saint-Balville-Vossidan. They're calling for the maintenance of postal services in rural areas, and they're calling on the government to authorise the Canada Postal Corporation to maintain not only the moratorium but to improve and enhance services, Mr. Speaker. Mr. Speaker, I'd like to take this opportunity to wish everyone a happy Christmas and Happy New Year in the riding of Chambly-Bordua, as well as all my colleagues here in this House.
Presenting petitions has expired. Is there agreement to continue with this for 2 months? No. There's no agreement. All right. Questions on the order paper. The Honourable Secretary Parliament.
Honourable Parliamentary Secretary, the Government Leader, House Leader.
Question will be answered today, Q 559. Furthermore, Mr. Speaker, if a revised response to question Q 481, originally tabled on December 7, 2009, and if questions number Q 560, 561, 562, 564, 565, and 566 could be made orders for returns, these returns would be tabled immediately.
Is it agreed that a revised response to question 481 and responses to questions 560, 561, 562, 564, 565, and 566 be made orders for return? Agreed? And so ordered. The Honourable Parliamentary Secretary.
Thank you, Mr. Speaker. Lastly, I ask that the remaining questions be allowed to stand.
D'accord.
Agreed.
Okay. The Honourable Parliamentary Secretary is rising on a point of order.
Thank you once again, Mr. Speaker. Mr. Speaker, I rise on a point of order concerning the content of the motion to be proposed by the Honourable Member for Vancouver South. Mr. Speaker, let me say at the outset that the government readily accepts that allotted day motions ought not to be interfered by the Speaker, except, Mr. Speaker, on the clearest and most certain procedural grounds. We believe that such grounds for intervention exist. Mr. Speaker, I want to draw to your attention to your own ruling of March 26, 2007 at pages 1873 to 1875 of Hansard. On that occasion, the issue was a supply day notice that, had it been in order and had been adopted, would have timetabled 4 bills. The motion today, Mr. Speaker, if adopted, would order the government to produce a long series of documents, and as quoted in the motion itself, in their original and uncensored form, end quote. It is our contention that this is an improper use of a supply day motion. A number of outstanding issues surround the documents listed in the motion. There are issues of statutory secrecy, military secrecy, and international agreements, all matters that this House has habitually respected when requesting papers and records. In some cases, the custodians of these records are statutorily barred from making them public. The passage of this motion would order them to violate laws which have been enacted with the consent of the House of Commons and the Senate, the two chambers that, along with the Queen, compose Parliament. It bears repeating, the House of Commons alone is not Parliament. It is 1/3 of Parliament. Statutes carry the authority of the three elements. The motion proposed by the member for Vancouver South would order persons to break the law under the authority and order of only the House of Commons. Because this is an allotted day motion, it is not subject to the usual process, which could include negotiations and amendments that a majority of the House might accept, notwithstanding their unacceptability to the opinion of the mover of the motion itself. Mr. Speaker, the traditional regress of grievances preceding the granting of supply never included requiring public officials to break the law. Yet that is what this motion would order. Will the next allotted day motion order the release of tax information, for an example, or other secret contents in government files? Where would this lead? In other words, Mr. Speaker, to use the vernacular, this could be the start of a very slippery slope. Are allotted days to become opportunities to violate the rights of Canadians through substantive motions that bypass the statute law? I suggest, Mr. Speaker, this was never seen as the function of allotted days, and request that the Speaker recognize that this motion exceeds the long-standing conventions surrounding supply day motions. Thank you, Mr. Speaker.
The Honourable Minister of Justice is rising on the same point.
Same point of order, Mr. Speaker. The government accepts the practice and procedure before parliamentary committees is governed by parliamentary convention. However, parliamentary privilege does not relieve public servants of their obligation to protect sensitive information that relates to national security, national defence, or international relations when appearing before a parliamentary committee. Now, Parliament has recognized the importance of protecting confidential information in statutes such as the Security of Information Act, the Canada Evidence Act, the Access to Information Act, the Privacy Act, and, of course, the Criminal Code. The principle of public interest immunity is also well established in the common law. There is an equally well-established parliamentary convention that committees will respect common law privileges and Crown immunity, particularly in relation to national defence, national security, or international relations, and not require the disclosure of injurious information. While Section 38 of the Canada Evidence Act may have no direct application to the committee's proceedings, the values that underline that provision are also reflected in parliamentary convention. I refer you to the authoritative text, Mango, Parliamentary Privilege in Canada, at page 163. It says, by convention, a parliamentary committee will respect Crown privilege when invoked, at least in relation to matters of national and public security, end of quote. The documents that have been provided to the committee by the government were redacted pursuant to Section 38 of the Canada Evidence Act for the purposes of the public interest hearing before the Military Police Complaints Commission. These redactions were necessary given the MPCC's decision to hold public hearings into complaints it had received. This provided the MPCC with the power to compel testimony and documents, and the hearing was therefore a proceeding under Section 38 of the Canada Evidence Act. Before it announced public hearings, the MPCC was investigating the detainee complaints and was given full access to thousands of pages of unredacted Canadian Forces Department of National Defence documents. While Section 38 of the Canada Evidence Act may not apply directly to the proceedings of the committee, the values that inform this legislation passed by Parliament are consistent with the Parliamentary Convention that injurious information should not be disclosed in a parliamentary setting. Accordingly, the process under Section 38 of the Canada Evidence Act serves as a useful surrogate to identify information that should not be disclosed to a parliamentary committee because its disclosure would be injurious to national security, national defence, or international relations. As previously noted,
Mr. Speaker, this is completely consistent with parliamentary convention. Thank you.
The honourable member for Vancouver South on the point of order.
Yes, Mr. Speaker. Nub of the matter, Mr. Speaker, is that our view of the law and the convention is different from that of the government. They have been, for the last several months, standing in this House and saying Section 38 is the reigning section. That is the section that governs non-disclosure of documents. Today they admit, through their own letter from the Department of Justice, that Section 38 actually does not apply to parliamentary proceedings. And that's been a big lie that the government has perpetrated in this chamber over the last yes, absolutely a lie that has been perpetrated in this chamber, uttered in this chamber for some time. Mr. Speaker, I will withdraw the word if that's offensive to the government. Mr. Speaker, however, I have an opinion. There are two opinions from the law clerk that indicate that Section 38 does not restrict the Parliament's right, the committee's right to receive documents. The committee may, by its own decisions, create a procedure where, if there are any documents that it receives, it considers may be injurious to the national security interest or international relations, the committee may not disclose those documents to third parties or may have a hearing that might be in camera. That is, in fact, in the opinion that I have received. I'd be happy to pass those on. They have been tabled in the committee, the opinions from the law clerk. I believe that the fact is the government is now finally realizing that Section 38 does not afford them the claims that they've been making. They now rest themselves, rely on a convention that the Parliament will at least respect, they say, citing an authority, will at least respect the Crown's decision for non-disclosure in matters of national security. I say to you, Mr. Speaker, when they say Parliament is two houses, that's a fiction they create. Yes, in terms of passing legislation, Parliament is two houses. When Section 38 was passed here in this House, there was a definition of proceeding in that legislation which was picked directly up from the criminal code. It was eliminated. It was eliminated and amended to ensure that Parliament has unfettered access to the documents that it may require to do its job. Parliament's job is to engage in oversight over the government. Government cannot claim, whether by convention or otherwise, total immunity to whatever it desires. The nub of the question here is that we don't believe that this government is blanking out documents, redacting documents in the interest of national security. They're doing so in the interest of covering their own butt. And I think that's very, very important to remember. So I say to you, Mr. Speaker, the two opinions that I have from the law clerk, which are public, and the opinion, in fact, of yesterday from the Department of Justice, goes to show that the government is on very thin ice and their claims should not be respected.
Well said. The honourable member for Winnipeg North.
Thank you, Mr. Speaker. I would like to make a few comments as well, questioning the wisdom of the government to suggest in any way, shape, or form that this supply day motion is out of order. And I want to just say, Mr. Speaker, first off, that supply day motions are one opportunity, one of the few opportunities that the government has, that the opposition has to hold the government to account. It's either question period or supply day motions. Those are the two opportunities we have to, in fact, demand accountability from the government on anything to do with its budgeting process. And those provisions are sacrosanct in our rule books. There have been, over the years, very little attempt to intervene in the choice of opposition day motions, supply day motions. So I think it's quite unusual for the government today to suggest that there's a problem with the wording of this motion. In fact, our process requires that if there's a problem with the motion, some disagreement with the actual direction the motion is taking, then the government or anyone concerned has the opportunity to vote against the motion at the end of that day. That's democracy, not to try to prevent the debate in the first place. That's truly unusual and unprecedented in this place. We have rules in this House, Mr. Speaker, that allow for members to challenge the government every step of the way. And at no point should our rules be interpreted to allow the government of the day to suppress debate. That's the antithesis of democracy. That doesn't even allow the issues to get to the table. I've listened to my colleague from the Liberal Party, whose name is on this motion, and he has clearly put on record those sections of the rule book that allow for committees and this House to call whatever documents and whatever witnesses they feel are necessary for the process. So I think that is self-explanatory. What I wanted to do in rising on this point of order was to make the case that in the true spirit of this place, the focal point of democracy in this nation, under no circumstances should the government use and try to suggest in any way, shape, or form that the rule books allow it to intervene with that debate taking place, to repress it in the first place. And I hope, Mr. Speaker, you will allow this day to proceed.
The Honourable Parliamentary Secretary to the Minister of National Defence.
Well, thank you very much, Mr. Speaker, and obviously I rise to support my colleagues in this. The opposition has talked about opinions. Well, opinions are fine, Mr. Speaker, but they have to be backed up by the rule of law. Canada operates on the rule of law, Parliament operates on the rule of law, and precedent and convention. On the first point of documents, the Government of Canada has in fact provided documents as quickly as possible, given the time constraints, the volume of the documents requested, and the requirement under the Official Languages Act to have documents translated into both official languages. In under a week, the committee was provided with relevant memos and details of Mr. Colvin, which were the most sought-after documents by the committee. As time goes by, more and more documents will be made available. On another point, the House of Commons has always recognized the limit of privilege relating to issues of national security and international affairs, as these are Crown or executive constitutional responsibilities that also require a public interest test. The Government of Canada has a responsibility to protect the public interest in these cases, and historically, committees of the House of Commons have respected the public interest test. Marleau and Montpetit assert this argument, stating, quote, "The House of Commons recognizes that it should not require the production of documents in all cases, consideration of public policy, including national security, foreign relations, and so forth, enter into the decision as to when it is appropriate to order the production of such documents," unquote. Similarly, Beauchesne notes that the Government of Canada, not the Speaker or the House of Commons, retains the right to define confidential documents, and that it is up to the government to determine whether any letters, papers, and studies are of confidential nature when deciding how to respond to a notice of motion for the production of papers. Mr. Speaker, generally speaking, government members also reject the notion that the House of Commons has a right to cabinet documents. This claim to cabinet documents obviously interferes with the constitutional roles of limits of legislative and cabinet or executive branches of government in our Constitution. So, Mr. Speaker, in our strong view, this motion is out of order, and we request your wisdom in that judgment.
The Honourable member for Mount Royal is rising on the same point.
Yes, Mr. Speaker. I just want to make a number of submissions in response to what my honourable colleagues have said. First, it has been argued that the motion is, in this sense, is asking that the law be broken. Mr. Speaker, the motion is not asking that the law be broken. On the contrary, it is asking that the government comply with the law with respect to parliamentary privileges and the production of papers relating thereto. Second, Mr. Speaker, privileges of Parliament are supreme, overriding, and not subject to ordinary statute laws such as the Canada Evidence Act or otherwise. the notion that parliamentary privileges are subject to or contingent upon ordinary statute law would not only diminish parliamentary privilege, it would undermine the authority of Parliament, its representativeness, and its protective framework regarding the authority of committees. Third, the notion that there is a convention that overrides parliamentary privilege in this regard actually runs the other way. The convention is that of the supremacy of Parliament, in that the convention seeks to underpin parliamentary privilege, not diminish it. Number 4, parliamentary privilege is subject to the Constitution in the matter of the Charter of Rights and Freedoms, Mr. Speaker, as set forth in the House of Commons and Vade 2005 Supreme Court Case 1 SCR 667. But it cannot be exercised so in the sense that it cannot be exercised so as to diminish the rights with respect to that which is protected under the Constitution. And this brings me specifically, and to my close, Mr. Speaker, in the matter that is specifically before us. This is not governed by the Vade case and the Charter, because this has the specific carve-out with respect to the overriding authority of parliamentary privilege. And I will quote here now from O'Brien and Bosque with respect to their complete discussion regarding parliamentary privilege, the authority of committees, and the protection of papers, exactly on point with respect to the motion before this House. And I quote, "The standing orders state that standing committees have the power to order the production of papers and records, another privilege rooted in the Constitution that is delegated by the House." Only if there would be an exception regarding to a matter of protecting against discrimination, as the Vade case said, would there be any issue that comes into play. Not with regard to the production of papers, Mr. Speaker, which it is clear is part of the absolute and authoritative power of the House. Let me continue. Committees usually obtain such papers simply by requesting them from their authors or owners. If a request is denied, however, and the Standing Committee believes that specific papers are essential to its work, it can use its power to order the production of papers by passing a motion to that effect. The Vade case recognizes that with regard to this particular privilege. And the key, Mr. Speaker, and I quote, "The standing orders do not delimit the power to order the production of papers and records. The result is a broad, absolute power that on the surface appears to be without restriction. There is no limit on the types of papers likely to be requested. The only prerequisite is that the papers exist in hard copy or electronic format and that they are located in Canada." And here, Mr. Speaker, on a matter also of practice, and I quote, again, from O'Brien and Bosque, "In practice, standing committees may encounter situations where the authors or officials responsible for papers refuse to provide them or are willing to provide them only after certain parts have been removed. Public servants and ministers may sometimes invoke their obligations under certain legislation, as we hear today, or with regard to a kind of national security carve-out to justify their position." And here O'Brien and Bosque conclude, and I conclude as well. These types of situations have absolutely no bearing on the power of committees to order the production of papers and records. This is clear, Mr. Speaker. The language here in O'Brien and Bosque is unequivocal. And they go on to say, "No statute or practice diminishes the fullness of that power rooted in House privileges unless there is an explicit legal provision to that effect. The House has never set a limit," I repeat, Mr. Speaker, and quoting them and concluding, "The House has never set a limit on its power to order the production of papers and records." Mr. Speaker, this is as clear as it can be from the most authoritative source on this matter. Thank you, Mr. Speaker.
L'Honourable Député.
The Honourable Member for Saint-Jean. On the same point of order, yes, thank you, Mr. Speaker. The point of order today does not surprise me at all, because since the outset, this government has taken refuge in a lack of transparency and a reluctance to disclose. the motion that we have before us today, the parliamentary secretary could perhaps have recognized that we are not asking for cabinet documents here. We are asking for documents that have been already tabled elsewhere, and it's a little bit ridiculous when you look at the study by the legislative advisor for Parliament. I would say that all of this is founded on the philosophy of British parliamentarianism. That is, what the advisor says is that the House of Commons or its committees, perforce, are the ones that have the responsibility to get to the bottom of things and to see that all the documents that would be useful to us are supplied to us. I like this, liken this to the House of Commons becoming the major inquirer, if you like, in an issue. That means that we are, in essence, they are taking this as the defenders of their kingdom. They want to protect their kingdom. In the committee that dealt with Afghanistan with General Haltons, who is a JAG for Afghanistan, he said, I can't reveal certain things because I have a conflict of privilege with respect to the entity that mandated it, that is the government. And the laws of Parliament do not apply. That's what's at the very heart of this debate. We wanted to ask the General to consult his client, the Government of Canada, and come back to us and say who has a precedence here. Is it the Parliament of Canada or is it the Evidence Act, Section 38? I believe that the government is going too far in its intent to protect the kingdom, as I have just said. And we are to be the major investigators on behalf of those people who elected us here as their representatives. That's one thing. The General, who is JAG there, said that when a law applies to parliamentary workers, the House is the only entity that can decide what law applies to it. That goes very far. This is far-reaching. The House has already dealt in part with this issue, and I think it should deal with it today more directly. If we are to be the major leaders of the inquiry here, we cannot do so unless we have the instruments that we need. The government, in defending its kingdom, has said to the witnesses, you can't speak. It's defending its kingdom. But that is quite contrary to the argument that we are the ones to be leading the inquiry here. Our responsibility as elected representatives of the people is to get to the bottom of things. And if our parliamentary rights are to be restricted through redaction, censor, or by being told you don't have access to this document, they are depriving us of our right to carry on the inquiry. Witnesses, as well as parliamentarians, have the right, as defenders of democracy, to conduct an inquiry and to conduct it in the way that we see fit. Of course, we don't have the absolute truth all the time. I agree. But we have all been struck by the legitimacy of our election to come here and represent the interests of our electorate. Therefore, we must be able to go to the very bottom of matters, of things, as we are trying to do in the text that we have before us today. But they are trying to restrict and to stifle and to smother an inquiry. Mr. Speaker, we know that something that was not correct happened. It is not normal that the right to defend the kingdom always should have precedence over inquiry. And he continues here with respect to legislation. If there were a law that would allow the minister and the government, listen carefully, to dissimulate information from Parliament, and that's what we're dealing with here today, those documents that are not disclosed, redacted documents, dilatory motions, like they're doing today to hold up the debate. At the end of the parliamentary session, when we think that this is going to be put off for a month and a half, well, if a law were there or legislation were there to allow the government or ministers to dissimulate information, the members would not be it would be unconstitutional rather, because members would not have the instruments that they need to carry out their duty. I believe that what they are doing is trying to close down, if you like, not just the Military Police Complaints Commission, but the inquiry by the Standing Committee. This strikes at the very heart of democracy. It is the power to make decisions backed by case law, by jurisprudence. Members will be denied if our rights are to be restricted, if we cannot have the opportunity to hear witnesses, if we are only given redacted documents. We go to a committee with witnesses that have had complete access to documents, and we, as the major inquirers, if you like, investigators in this matter, do not have access to those documents. This is an indication that the government is non-transparent, is isolated from the issue, and they can be decried for those reasons. I believe that your ruling should be in favor of these people here in the House who have been elected by the electorate, their constituents, to conduct inquiries and investigate. I rely on you, Mr. Speaker. I hope you will rule in the right way. But I can tell you one thing, that even though the government tries to muzzle us, to censure us, to redact what is given to us, we in the opposition are determined to get to the bottom of things. And I thank you for your attention, Mr. Speaker.
The honourable member for Sault Ste. Marie, and then the parliamentary secretary. That'll be it.
Very much, Speaker. We just wanted to, in the interest of this discussion this morning, with all due respect, remind the Chair that there is a piece in the new O'Brien-Bosk document that has come out recently that suggests that the standing orders give members a very wide scope in proposing opposition motions on supply days, and unless the motion is clearly undoubtedly irregular, i.e. where the procedural aspect is not open to reasonable argument, the Chair does not intervene. And we suggest this is such a time.
The Honourable Parliamentary Secretary to the Government House Leader, and that will be the conclusion of the argument on the procedure here.
Thank you very much, Mr. Speaker. Mr. Speaker, let's cut to the chase here. The issue, Mr. Speaker, is the attachment of a substantive motion, that is, an order for the production of papers, to an allotted day motion under the business of supply. Mr. Speaker, you know as well as I do, as well as every other member in this place, we cannot write legislation on an allotted day, nor should we bypass the normal processes for the production of papers. Thank you, Mr. Speaker.
Well, I've carefully considered all the arguments that have been advanced, and I think that I should cite to honourable members first the citations, and that has been read, in fact, by the honourable member from Mount Royal in his argument largely, on page 978 of O'Brien and Bosk. Quote again, "The standing orders do not delimit the power to order the production of papers and records. The result is a broad, absolute power that on the surface appears to be without restriction. There is no limit on the type of papers likely to be requested. The only prerequisite is that the papers exist in hard copy or electronic format and that they are located in Canada." Page 979 goes on, "No statute or practice diminishes the fullness of that power rooted in the House privileges unless there is an explicit legal provision to that effect, or unless the House adopts a specific resolution limiting the power. The House has never set a limit on its power to order the production of papers and records." And so I go back also to page 136 of O'Brien and Bosk, To further this, by virtue of the preamble in Section 18 of the Constitution Act 1867, Parliament has the ability to institute its own inquiries, to require the attendance of witnesses, and to order the production of documents, rights which are fundamental to its proper functioning. These rights are as old as Parliament itself. Mango states, and this is a quote from his work, the only limitations, which could only be self-imposed, would be that any inquiry should relate to a subject within the legislative competence of Parliament, particularly where witnesses and documents are required and the penal jurisdiction of Parliament is contemplated. This dovetails with the right of each House of Parliament to summon and compel the attendance of all persons within the limits of their jurisdictions. So in the circumstances, on the face of it, I think a motion to demand the production of papers is entirely in order. The question is whether it can be done on a supply day, as suggested by the Parliamentary Secretary in his submission. And the Chair has intervened once on supply day to prevent the supply day from being used as a vehicle for restricting debate on a bill, because it was something that was allowed for in other parts of the standing orders and so on, and then fitted in there. But I believe that this motion, which is demanding that documents be tabled in the House, is something that could reasonably be requested on a supply day. I don't see why it is. It's not a procedural motion in that sense. It's demanding the production of documents. Supply motions have called on the government to do things. They have expressed House opinions on various things in the past, and in my view, this one fits within that, and accordingly, in accordance with our practice in respect of supply days, I feel that the motion is in order and will allow it to proceed. I think it's unfortunate, if I may make this comment, that arrangements were not made in committee to settle this matter there where these requests were made, and where there might have been some agreement on which documents in which format would be tabled or made available to members, or how or produced, or however it was to be done. I don't know. But that obviously has not happened. We now have this motion here, and it seems to me the House has the power to do what a committee can do and then some, and a committee could have requested this and demanded the production of these materials. The House can also do whatever a committee can do, and accordingly, and then some. And accordingly, I feel the motion is in order, and I will allow the matter to proceed. The Honourable Government House Leaders rising on another point of order.
Yes, thank you, Mr. Speaker. I wish to give notice that with respect to the consideration of the third reading stage of Bill C-56, an act to amend the Employment Insurance Act and to make consequential amendments to other acts, at a next sitting, a Minister of the Crown shall move, pursuant to Standing Order 57, that debate be not further adjourned.
Orders of the day. Order du jour.
Government orders, business of supply, opposition motion standing in the name of Mr. Dosanjh regarding documents regarding Afghan detainees.
Since today is the final allotted day for the supply period ending December the 10th, 2009, the House will go through the usual procedures to consider and dispose of the supply bill. In view of recent practices, do honourable members agree that the bill be distributed now? Agreed? D'accord. Mr. Dosanjh, seconded by Mr. Cotler, moves that given the undisputed privileges of Parliament under Canada's Constitution, including the absolute power to require the government to produce uncensored documents when requested, and given the reality that the government has violated the rights of Parliament by invoking the Canada Evidence Act to censor documents before producing them, the House urgently requires access to the following documents in their original and uncensored form. All documents referred to in the affidavit of Richard Colvin, dated October 5, 2009. All documents within the Department of Foreign Affairs written in response to the documents referred to in the affidavit of Richard Colvin, dated October 5, 2009. All memoranda for information or memoranda for decision sent to the Minister of Foreign Affairs concerning detainees from December 18, 2005 to the present. All documents produced pursuant to all orders of the Federal Court in Amnesty International Canada and British Columbia Civil Liberties Association against the Chief of the Defence Staff for the Canadian Forces, Minister of National Defence and Attorney General of Canada. All documents produced to the Military Police Complaints Commission in the Afghanistan public interest hearings. All annual human rights reports by the Department of Foreign Affairs on Afghanistan, and accordingly the House hereby orders that these documents be produced in their original and uncensored form forthwith. Debate. The Honourable Member for Vancouver South.
Thank you. Thank you, Mr. Speaker. I will split my time with the member for Etobicoke Lakeshore. Mr. Speaker, what just happened, transpired before you had to make the decision to proceed with this motion, simply goes to show the necessity for this motion, the need for this motion to come before the House. We've reached the point where we had to bring this motion for one simple reason, Mr. Speaker. The government, the Prime Minister, the Minister simply don't have any moral credibility on this issue anymore. From the outset of this issue, they've demanded that we take them at their word, but their word has no value anymore, Mr. Speaker. From the outset of this issue, they have insisted that there was no compelling evidence of detainee abuse or torture, but day after day, week after week, the facts have continued to come out, and the facts have said otherwise. From the outset of this issue, they have attacked the patriotism and integrity of those who have demanded answers, accusing them of aiding and abetting the Taliban enemy. But now it is their patriotism and integrity that looks shabby and shallow. From the outset of this issue, they have hidden, very strong word, like cowards behind the heroism and bravery of the soldiers on the ground. But now we know that they've covered the facts on the ground in Afghanistan, and they've launched an unprecedented smear campaign against the one person, Richard Colvin, whose evidence they could not silence. We've asked for facts and gotten cynical spin. We've asked for accountability and gotten only evasion. We've asked for the truth and gotten everything but. All of this because the Prime Minister and the Minister have from the outset treated this as a partisan issue and not a moral issue, as a search for an alibi and not as a search for truth. The Prime Minister seems more concerned, Mr. Speaker, about his own reputation than he is about Canada's. And the Minister seems more concerned about keeping his ministerial limousine than about doing the right thing, Mr. Speaker. It was sad to watch his performance in the committee yesterday. He spoke with mock indignation about outrageous and insulting allegations, conveniently forgetting the outrageous and insulting allegations he so cavalierly made against Mr. Colvin, a dedicated public servant who was powerless to defend himself. He spoke with mock sadness about how we were denigrating the fine work of our soldiers on the ground in Afghanistan, an extraordinary position to take on the very day it was revealed that this government had somehow for 2 years overlooked the evidence of abuse provided by soldiers in Afghanistan who were acting in the finest Canadian traditions. Mr. Speaker, it has all become too clear that this government is simply unwilling to tell the truth. They have poisoned their own credibility, and by their bare-knuckle, ultra-partisan approach to this most serious of issues, they have poisoned the well of trust in the House and in the committee. That is why we need access to all the documents related to these issues. Unredacted documents, unfiltered documents, unspun documents, uncensored documents, Mr. Speaker. Mr. Speaker, the Minister appeared before the committee yesterday and said that there are 3 investigations that are underway, and they should be sufficient to deal with this. First, he referred to the Board of Inquiry to investigate the treatment of individuals detained by Canadian troops in April of 2006. That deals with the conduct of our soldiers on the ground. That is not the object of our inquiry in the committee. And then the second one was the Military Police Complaints Commission, which has been thwarted, if I might say, with a massive campaign of obstruction of justice from actually looking into this matter. Third is the committee he referred to, committee on which I sit, the Special Committee on Afghanistan, and that committee has been thwarted in its work by the government not producing uncensored documents in their entirety for the committee to see. Mr. Speaker, they have, obviously, that's why we need the documents. That's why it is urgent that this motion pass. The fact is, Mr. Speaker, it is now not about whether or not there was torture. There is abundant evidence of circumstantial evidence, real evidence of torture in Afghan jails at the hands of the Afghan authorities, of the detainees, whether it's the Human Rights Watch, whether it's the Afghan Independent Human Rights Commission, whether it's the UN reports, U.S. State Department, our own annual human rights reports from Afghanistan. all of them go to show that there was abundant circumstantial evidence that existed about torture in Afghanistan. And the lack of any specific knowledge of any specific incident is not a defense to the continuing ignorance or willful blindness of the government. In fact, I want to quote, Mr. Speaker, Mr. Justice O'Connor in his report of September 2006. He said, and I quote, "Canadian officials should not wait for verification or unequivocal evidence of torture in a specific case before arriving at a conclusion of a likelihood of torture." And that is a statement from Mr. Justice O'Connor, who headed the Arar inquiry. And that should guide us. And that is in keeping with the Geneva Convention, which essentially says if you have circumstantial evidence, whether or not you have knowledge, you have the responsibility to investigate and be careful that you not send people to a risk of torture where there are substantial grounds for the risk of torture. And we now know this government, from early 2006 to sometime in 2007, continued to send prisoners to a risk of torture. And that is what we need to investigate. Why did it continue? Why did the government not take any action? This is not about the conduct of our military on the ground. They have acted in the finest of traditions, as we learned from General Natenchuk yesterday. They have always done the right thing. Ultimately, there is a civil responsibility for all of the actions that happen in Afghanistan, and that responsibility rests with the Prime Minister and the Minister of National Defense. And that's why we need the documents, unfettered, uncensored, unspun, unfiltered documents, to look at their conduct, look at whether or not they acted appropriately. Mr. Speaker, you heard the arguments advanced by the government to restrict, in fact, to have this particular motion ruled out of order. They relied, in the House, they've relied on Section 38 of the Canada Evidence Act. They've relied on their excuses that they will give whatever is legally available to Parliament. Now we know, Mr. Speaker, that Parliament has the unfettered, absolute right to order the production of papers and persons in this country. And Parliament, to my knowledge, and this Parliament, in actual fact, has never fettered its own jurisdiction, has never limited its own jurisdiction. And the committee stands in the place of Parliament, and the committee has that unfettered access through these documents. And that's why, Mr. Speaker, I was very, very cautious in asking the law clerk for an opinion on the application of Section 38. And he actually sent me an opinion back on, Mr. Speaker, let me just give you, October 23rd, 2009, which was tabled at the committee, which said we have unfettered access to documents and to witnesses that come before us, and those witnesses would be extended the privilege and immunity from prosecution if they are deemed to have violated any laws. And then the government started spreading, based on some opinion they may have from the Department of Justice, saying, oh, that the law clerk's opinion is wrong. I asked the law clerk to provide me a further opinion, and he provided me a further opinion on December 7th, 2009, which has also been given to the clerk of the committee and is public. Then, Mr. Speaker, on December 9th, we get a letter from the Assistant Deputy Minister, Public Law Sector from the Department of Justice, where they finally admit that the Minister and the Prime Minister, standing in this House and in the committee, they have been misleading Canadians. They've been misleading this House. This letter finally admits that while Section 38 of the Canada Evidence Act has no application to parliamentary proceedings, suddenly we learned the truth from an honourable lawyer or a deputy minister within the Department of Justice. So their whole charade, their house of cards came down tumbling. And Mr. Speaker, thank you very, very much for allowing this to proceed. And I believe my time is ended, and I'm happy to answer questions.
Questions and comments? The Honourable Parliamentary Secretary.
Speaker, I must say that It is with a sense of deep regret that this motion has come before the floor, come before this chamber in the form that it is in. And it is with regret because in an attempt of the opposition to embarrass the government, they effectively are putting the lives of our soldiers and the future of our ability as a nation to be able to deal with international agencies like the Red Cross and other sources of information and intelligence that is so absolutely vital for our nation to be able to be a player in the world. Not only a player in the world, Mr. Speaker, but in fact, if this information were to come in an unredacted, uncensored form, it would shut down Canada's ability to be a citizen in the world and deal with people, deal with other nations. Mr. Speaker, I find this motion to be absolutely reprehensible.
The honourable member for Vancouver South.
Well, Mr. Speaker, if there is any embarrassment, it's been created by the government itself. Mr. Speaker, the fact is that the government should concede that the members of Parliament, some of whom are Privy Councillors themselves, may be as responsible as the government itself in protecting national security when they deal with the documents once disclosed. Why do they doubt the integrity of the members of the committee? That somehow the members of the committee pose a national security risk, that if given the documents, somehow they're going to reveal secrets to the entire world. I believe that there is as much wisdom on that committee as might be on the front benches of the government. I believe that we should have access to those documents, and we will deal. The committee will find a procedure, set its own procedure to ensure that we do the right thing by Canada, that we do the right thing by Canadian troops, and that we actually stand up for transparency and accountability and make sure the government is finally accountable for its actions or omissions.
Hear, hear. Questions and comments? The honourable member for St. John's East.
Thank you, Mr. Speaker. I certainly support the idea that we need to have these documents forward and that the rights of Parliament and the supremacy of Parliament must be upheld. I would, just listening to the honourable member speak, it's clear he does not want them to be tabled on the floor of the House, yet it appears that that's what the motion suggests. And I wonder if he would be willing at a later point to consider clarifying that, because, you know, while as he suggests and as the the Legislative Council, Parliamentary Council has suggested, the committee itself can find ways to ensure that the national secrecy, if necessary, is protected. But as the motion reads now, it seems to suggest that it was called for the tabling of all these documents on the floor of the House, and that seems to me potentially problematic. I hear what some members opposite are saying in terms of there may be secrets that need to be kept.
The honourable member for Vancouver South.
Mr. Speaker, I understand, as the Speaker just said, that the House can do whatever the committee can do and then some. So the House can actually protect those secrets as well as the committee can in the way it transmits those documents to the committee.
Questions and comments? The honourable member for Renfrew. Short question, please.
Thank you, Mr. Speaker. Together with my colleagues on the Defence Committee, we have special concerns about the confidentiality of what is in these papers. During a meeting of the National Defence Committee, an in-camera meeting of the National Defence Committee, the mover of this motion twittered what was being discussed to the universe. So we have great reservations about the ability of the mover or colleagues to keep what is confidential for the security of Canada confidential.
The honourable member for Vancouver South, short answer, please.
Mr. Speaker, these are the people that handed everything to Christy Blatchford.
The Conservatives.
Resuming debate, the honourable leader of the opposition.
Thank you, Mr. Speaker, and I'd be grateful, Mr. Speaker, if you let me know as my time draws to a close, since I
have an amendment to introduce to the. I want to thank the member for Vancouver South for his great work on this issue. Monsieur le Président, les événements.
Mr. Speaker, recent events confirm that Canadians can be proud of the men and women who serve in Afghanistan. We're not questioning their work. We're rather questioning the work of the government. We have confirmation that a detainee transferred by Canadian forces was mistreated in Afghanistan in 2006.
It contradicts what this government has told Canadians. The credibility of the Minister of Defence is in tatters. Canadians cannot take him at his word. This Parliament cannot trust what he says. And the issue here is trust. General Natinchik is making every effort to get at the truth, and the government is making no such effort. They continue to withhold certain documents and censor others. They have redacted with what can only be called Soviet zeal. They have intimidated witnesses and public servants.
Absolutely.
They have cast a chill over Canada's foreign service, as a growing number of former ambassadors have said publicly. We must have the truth, uncensored and unredacted. That is the privilege of Parliament and the right of the Canadian people. And that's the reason for today's motion. The government must account for an entire year of willful blindness. Les conservateurs avaient des informations crédibles.
Conservatives had credible information, even photos revealing cases of torture and abuse, but they didn't do a thing to put an end to it. Rather, they went about covering up the truth. The issue here is the Conservative government's negligence, not the behaviour of our soldiers. The questions that we need answers to will not find answers through a military inquiry.
Year of willful blindness. This is not a partisan exercise, because we are prepared on this side of the House for the committee and for the inquiry to examine the whole length of the mission in Afghanistan, beginning in 2001 under the previous Liberal government.
That's correct.
But let us remember how we got here. The sequence of events is extremely important. In December 18, 2005, during a federal election, General Rick Hillier, then CDS, signed a detainee transfer agreement with the Afghan government. The ministers opposite were sworn in on February 6, 2006, and the defense minister has admitted that, quote, he heard serious allegations of detainee abuse from the moment they took office, unquote. In March
2006, the U.S. Department of State reported that the Afghan authorities, and I quote, tortured and abused detainees on a routine basis. But despite this information, the Conservative government acted as if nothing had happened. A couple of weeks later, in the spring of 2006, the first detainees were handed over by the Canadian forces.
Richard Colvin began sending reports of detainee abuse to his superiors. On June the 2nd, 2006, the Afghan Independent Human Rights Commission reported that a third of detainees handed over by Canadian forces were abused or tortured in Afghan custody. The same day, Richard Colvin sent another memo with reports of torture in Afghan jails. Still, this government did nothing. Mr. Colvin sent 3 more reports before the end of 2006. He made additional reports in March, in April, in June, and in July 2007. 17 months, 17 memos. Still, the government did nothing. L'ambassade.
The Canadian Embassy in Kabul in 2006 had a report on human rights confirming that there was systematic torture in Afghan prisons. Once again, the government did nothing.
2006, that the detainee abuse confirmed yesterday by General Natinchik took place. It was documented and reported by soldiers in the field who did their job. Still, this government did not do its job. In November 2006, the Department of Foreign Affairs actually issued talking points playing down reports of torture. Secret memos leaked to the press confirmed that this government's priority was spinning the issue rather than preventing torture from occurring.
In February 2007, there were 3 additional allegations of prisoner abuse. That same month, the Military Police Complaints Commission started an inquiry that the government tried to block.
Blindness only ended when graphic reports of abuse surfaced in the Canadian press on April the 23rd, 2007.
And it wasn't until the 3rd of May 2007 that the government signed a new agreement for the transfer of detainees. But the problems didn't stop there. Mr. Colvin testified that inspections were infrequent due to a lack of resources. Worse still, he received directives from his superiors to stay quiet and to, in fact, not refer to cases of torture and abuse. The transfer of detainees was suspended for the first time on the 6th of November 2007 because of reports regarding torture, which were and have been suspended many times since. Nevertheless, up until yesterday, the minister and his colleagues claimed that there was not a single detainee handed over by the Canadian authorities that was abused in Canadian prisons. We now know that that's not true.
Taken us through, Mr. Speaker, speaks for itself. For over a year, the government had credible reports from multiple sources, independent, credible Canadian sources, that Afghan detainees were being tortured in Afghan detention centers. These reports came from Canadian diplomats and Canadian soldiers in the field, and the government opposite did nothing. They must account for that year of what can only be called willful blindness. Their refusal to get to the truth is costing us our credibility as a nation on human rights and engages in a threat to the honor of Canada in the field, that honor which our troops so bravely defend every day. We need the truth. We need it now. Canadians deserve better. And now, therefore, Mr. Speaker, I would like to move the following amendment, that the motion be amended by adding immediately before the word accordingly the following. All documents referred to by the Chief of Defence Staff in his December 9th, 2009 press conference and all other relevant documents. Merci, Monsieur le Président. Thank you, Mr. Speaker.
It is my duty to inform honourable members that an amendment to an opposition motion may be moved only with the consent of the sponsor of the motion. Therefore, I ask the honourable member for Vancouver South if he consents to this amendment being moved.
I do, Mr. Speaker.
Mr. Ignatieff, seconded by Mr. Goodale.
Mr. Ignatieff, seconded by Mr. Goodale, moves that the motion be amended by adding immediately before the word accordingly the following: all documents referred to by the Chief of Defence Staff in his December 9, 2009 press conference and all other relevant documents. And the debate is now on the amendment. Questions and comments? The honourable member for Ottawa Centre.
Thank you, Mr. Speaker, and welcome the amendment. Just to get some clarity here, and I think the Leader of the Opposition enumerated very well the concerns that we've all had, and certainly we moved at committee to have documents released, and of course we didn't get what we asked for, and so we welcome this idea. So just a question around the importance of hearing directly from the notes that were written from the field. We established yesterday from the Chief of Defence Staff that, in fact, there was more information. And so I want to ask the Leader of the Opposition if we were able to get that information. Is he asking that that information be shared with Parliament in an uncensored form? First question, and a supplement to that would be, if we're able to get that information forthwith, is he hoping that we get it by tomorrow? What is the timeline that he is hoping we get that by?
The Honourable Leader of the Opposition.
Mr. Speaker, I thank the honourable member for his question. It must follow from the nature of the motion that we put forward that those documents must be uncensored. That's the answer to the first question. And secondly, it is our assumption that we are talking about immediate delivery of those documents. That is tomorrow. Thank you.
Questions and comments? Resuming debate, the Honourable Minister of Justice.
Thank you very much, Mr. Speaker. I stand today to express my opposition to the motion as amended now before this House. I'm convinced that it would be a serious mistake for the government to produce the many documents referred to in the motion tabled by the honourable member for Vancouver South. Producing verbatim copies of these documents would jeopardize not only the security of Canadians serving in Afghanistan, but also Canada's relationships with other countries. Furthermore, the release of unedited versions of these documents would be clearly inconsistent with parliamentary convention related to the protection of sensitive information. Now, the Parliament of Canada has established important rules under the Canada Evidence Act in relation to the handling or disclosure of information concerning international relations, national defence, or national security. The values underlying Parliament's intention to protect the national security of Canada from harm by the unauthorized disclosure of sensitive information must inform the actions of ministers and officials. Parliament exercises significant powers, yet Parliament also appreciates the importance of protecting confidential information. This is evident in statutes such as the Security of Information Act, the Canada Evidence Act, the Access to Information Act, the Privacy Act, and of course the Criminal Code. The principle of public interest immunity is also well established in the common law. These principles also find expression in parliamentary convention. The government's position on the matter is clear. We must make every effort to protect sensitive information that, if disclosed, could compromise Canada's security, national defence, and international relations. The government's position on cooperating with the parliamentary committee is also clear. We will continue to support the work of committees and provide any and all information that does not compromise the national interest. The government rejects the notion, however, that parliamentary privilege somehow relieves public servants appearing before committee of their obligation to protect sensitive information that relates to national security, national defence, or international relations. As I'm sure the members of this House appreciate, there is a well-established parliamentary convention that committees will respect common law privileges and Crown immunity, particularly in relation to national defence, national security, or international relations, and not require the disclosure of injurious information. The authoritative text, Parliamentary Privilege in Canada, by Joseph Mengel, makes this point clearly on page 163. With respect to federal public servants who are witnesses before committees of either House, the theory of the compellability of witnesses may come into conflict with the principle of ministerial responsibility. By convention, a parliamentary committee will respect Crown privilege when invoked, at least in relation to matters of national and public security. To link this statement with the motion now before us, members of this House must acknowledge that important issues of national security are at stake and should therefore abide by parliamentary convention and respect the government's actions to protect sensitive information. In essence, parliamentary convention must govern committee practices and procedures. Further support for this conclusion is provided by a 1991 report of the Standing Committee on Privileges and Elections, published as part of the Journals of the House. And to quote from that, the House of Commons recognizes that it should not require the production of documents in all cases, considerations of public policy, including national security, foreign relations, and so forth, enter into the decision as to when it is appropriate to order the production of such documents. Mr. Speaker, this House must exercise its powers responsibly. In some cases, the only responsible option is for this House and its committees to refrain from pressing the theoretical extent of their powers. The government's concerns for national security informed an earlier decision to redact documents submitted to the Military Police Complaints Commission, also known as the MPCC. The decision reflects the fact that the MPCC operates in a significantly different legal environment than parliamentary committees. On the subject of the extent of the redactions, no other tenable option existed once the MPCC decided to hold public hearings. The decision provided the MPCC with the power to compel testimony and to order the production of documents, and the hearing therefore met the definition of a proceeding under Section 38 of the Canada Evidence Act. It is important to note that before the MPCC announced its intention to hold public hearings, government officials provided it full access to thousands of pages of unedited documents produced by Canadian forces and the Department of National Defence. The decision to redact documents is not taken lightly and reflects the absolute need to protect sensitive information. Pursuant to Section 38, officials redacted the documents. Copies of these edited documents were later provided to the Special Committee on the Canadian mission to Afghanistan. While the Section 38 of the Canada Evidence Act may not apply directly to the proceedings of the Special Committee, the values that inform that legislation passed by Parliament are consistent with the Parliamentary Convention that harmful information should not be disclosed in a parliamentary setting. Accordingly, the process under Section 38 of the Canada Evidence Act serves as a useful surrogate to identify information that should not be disclosed to the Special Committee due to concerns related to national security, national defence, or international relations. The government fully supports the Special Committee and believes that it plays an important role in Canada's democracy. And respect for legal duties and acts enacted by Parliament is also essential to the health of our democracy. Ultimately, however, restricting access to particular information is justified by a more important goal, one that serves the best interests of Canadians. The Supreme Court has acknowledged that the government must, on occasion, withhold sensitive information. In the Regina versus Thompson decision, the Supreme Court stated clearly that all government must maintain some degree of security and confidentiality in order to function. End of quote. It also confirmed that an act of Parliament will apply to the House of Commons expressly, as in the case of the Official Languages Act, or implicitly, as in the case of the Canadian Human Rights Act. In that case that the House heard about a little earlier, the House of Commons versus Vade, which is a 2005 Supreme Court of Canada case, the Supreme Court rejected the argument that the Canadian Human Rights Act had no application to the House of Commons because it did not so expressly provide. The Supreme Court held that the argument was, quote, out of step with modern principles of statutory interpretation accepted in Canada, end of quote, and that the proper approach was to construe the words of the Act in their entire context, having regard to the scheme, object, and remedial purpose of the Act. Mr. Speaker, although our debate today focuses on a point of parliamentary privilege, we must never forget that it also directly affects the lives of Canadians serving on the front lines of a deadly conflict a half-world away. As members of Parliament, we must never lose sight of the fact that men and women continue to put their lives at risk to defend our country and all that it represents. And we must not sacrifice the safety of these brave souls on the altar of parliamentary privilege. Yet this is precisely what the motion before us today proposes to do.
Exactly.
To understand what's at stake, one must recall that Afghanistan's Taliban government played a central role in aiding and abetting a series of terrorist attacks against Canadians and Canada's allies. 7 years ago, Canada deployed troops in support of the invasion led by the United States to oust the Taliban and diminish the capacity of terrorists in Afghanistan to strike targets in the West. While the mission has evolved somewhat over the years, thousands of Canadians continue to serve in Afghanistan as part of an international effort to root out insurgents and to promote peace, prosperity, and justice. And last year, the members of this House voted overwhelmingly in favor of extending the mission through 2010. In recent weeks, Mr. Speaker, top officials from the Canadian Forces and several federal departments have provided evidence about the legal status of detainees and about the practices and procedures Canadian officials follow to ensure that they honor international laws and conventions. On November 4th, for instance, Canada's Judge Advocate General, Brigadier General Kenneth Watkins, stated that, and I quote, "The policies and procedures put in place by the Canadian forces in Afghanistan and the legal test which must be satisfied before detainees can be transferred are all meant to ensure compliance with these international legal obligations." End of quote. During the same session, the committee heard testimony about the series of increasingly rigorous agreements and practices implemented by Canada expressly to prevent the abuse of detainees. A December 2005 agreement between the militaries of Canada and Afghanistan, signed under the Liberal government, empowered the International Committee of the Red Cross to monitor and report on the status of detainees. A more robust follow-up agreement signed in 2007 enlisted a second independent monitor, the Afghanistan International Human Rights Commission, and it restricted the movement of detainees captured by Canadians. In addition to these measures, Canadian officials continue to monitor the treatment of detainees captured by our soldiers. When these officials found credible evidence of abuse, Canada temporarily halted the transfer of prisoners to Afghan officials in November 2007. The transfer resumed a few months later once those concerns had been addressed. Mr. Speaker, the release of at least some of this information would clearly undermine the safety of Canadian officials working in Afghanistan. Information about when and how Canadian officials visit particular prisons, for instance, would be of great value to the insurgents and to the terrorists. They could use this knowledge to attack our monitors and free the detainees. One can only imagine how the enemy would interpret and exploit other top-secret information. It would be a grave mistake to underestimate the terrorists. They are both sophisticated and brazen. Among the more than 100 Canadians to die at their hands are 3 civilian aid workers and 1 senior diplomat. We cannot lose sight of the fact that our soldiers are not the only ones engaged in this dangerous mission, and the Government of Canada must do its utmost to protect everyone it assigns to Afghanistan. It is this duty to protect, Mr. Speaker, that inspires my opposition to the motion before us today. The Government of Canada must not abandon this duty in response to the committee's investigation into the conduct of Canadian officials responsible for prisoners captured in Afghanistan. There can be no doubt that this government has in fact cooperated with the committee. The government has ordered senior military personnel, diplomats, and other officials to appear, often on short notice and often traveling vast distances. Their candid testimony has enabled committee members to gain critical knowledge about the capture and transfer of detainees. All of these witnesses recognize, however, that they must not disclose information that might compromise Canada's security or international relations. As dutiful, honourable public officials, these witnesses respect the laws passed by Canada and the policies implemented by governments that protect confidential information. The allegation that the Government of Canada seeks to obstruct or interfere with the committee's work by denying access to documents is completely untrue. The committee has requested a considerable number of documents, and government officials continue to work hard to satisfy this request. The process will take some time because many of the papers contain top-secret information. Parliamentary committees are essential and valuable components, of course, of Canada's democratic system. Canadians appreciate the analysis and perspective that committees can bring to the issues of the day. But Canadians expect committees and Parliament itself to exercise those powers responsibly and reasonably and in accordance with parliamentary convention. And Canadians do not accept that the relatively narrow interests of a single committee are more important than the safety of our men and women serving in Afghanistan. Given these realities, restraint and caution must be our guide. The government must not release information under any circumstances that could jeopardize national security and international relations. I encourage my honourable colleagues to vote down the motion that is before us today. Thank you, Mr. Speaker.
Questions and comments? The Honourable Member for Charlottetown.
Thank you, Mr. Speaker. Mr. Speaker, let me say at the outset, I find this whole debate somewhat disturbing. You made a ruling earlier, Mr. Speaker, that the law is very clear, that Parliament has the unfettered right to seek the production of persons, papers and records. And if there's any statute, if there's going to be bound by statute, that statute has to expressly make reference or restrict that fundamental right. And up until now, Mr. Speaker, we've heard answers and comments from the Minister and the Parliamentary Secretary of Defence saying that this was all covered by Section 38 of the Evidence Act. We've had one opinion from the Parliamentary Legal Council. We've had a second legal opinion from the Parliamentary Legal Council. Now I understand yesterday it was disclosed that the solicitors, the lawyers working for the Department of Justice, working for the previous Speaker, agree with that opinion. And it seems to me, Mr. Speaker, that this whole House has been misled for the last 6 months. My question to the member across, to the Minister, do you agree, sir, through you, Mr. Speaker, that that premise has been misleading this House? And secondly, if so, do you not agree that the conventions of this House dictate that the Minister should resign?
The Honourable Minister of Justice.
Thank you, Mr. Speaker. The government has been very clear. There was a question of redacted documents and the documents that were placed before the Military Police Complaints Commission. And it was very clear that the proceedings under that, before that body, were a hearing within the parameter of the Canada Evidence Act and, of course, Section 38 that applies with respect to the protection of those documents apply. So that's why there were a number of redacted documents. Now, those documents, of course, were made available to the committee and others, but it was on the basis that they were presented to the Military Police Complaints Commission that redaction took place, and it was clearly within the ambit of the Canadian Evidence Act. the Canada Evidence Act. Mr. Speaker, with respect to the behavior and the constraints or lack of constraints for parliamentary committee, so the point that has been consistently made is that the interests of national security have to guide us at all times in our roles as parliamentarians in this. And just as I quoted the Supreme Court of Canada in the House of Commons versus Vade decision that made it clear that indeed Parliament and the House of Commons was subject to the Canadian Human Rights Act, even though there was no express provision in any bill that in fact it does apply to Parliament. But when the Supreme Court of Canada had a look at it, they came to the logical conclusion that to hold otherwise would mean that we would be out of step with the modern principles of statutory interpretation accepted in Canada. And a quote, that's the Supreme Court of Canada. So indeed, just as the Canadian Human Rights Act applied for very good reasons, the very good reasons that were made, and that's the point that we are bringing before this House and that has been made by my ministerial colleagues, that the protection of Canadians serving abroad, the national security of these interests have to guide us in all our actions, just as the Canadian Human Rights Act guides Parliament with respect to its activities, with respect to its employees. Surely the national security is of importance to all members of Parliament, and any attempt that might compromise that or expose these individuals. And as I pointed out, not just members of the armed forces, there are civilians working there on behalf of the government. Any attempt that might expose them to danger or to tip off the terrorists for whom they are targets, something must be resisted, and that concept must be completely understood by all parliamentarians in the exercise of their responsibilities.
Questions and comments? The Honourable Member for Elmwood-Transcona.
Thank you, Mr. Speaker. And we are dealing today with the Liberal opposition motion regarding the Afghan detainees. And, you know, we know the government's been hiding from this situation now for the last 4 years. In fact, the Liberals, to give them credit, have agreed that the public inquiry that should be called should include their time in office as well. They've been fairly open about that. So the question that I have to the government member is, why did the government leak Mr. Colvin's memos to the media, and why is it obstructing the parliamentary committee's request for documents? And if that government has nothing to hide, then why did it obstruct the Military Police Complaints Commission, and why won't they get a public inquiry underway right away?
The Honourable Minister of Justice.
Mr. Speaker, the government has been completely cooperative with the Military Police Complaints Commission, the MPCC. They have provided innumerable documents to that body and have done everything possible to comply with the work of that body within its mandate. That's very, very clear. I mean, one of the very interesting comments the member said is that the Liberal Party would like a public inquiry to include their time of office. I say to them, step forward. If they know of any mess that they have covered up or any mess that they know of during their time of office, I suggest to them, say, step forward. They don't have to wait until there's any sort of a public inquiry. Do what we are doing. We're cooperating, making documents available, cooperating with the committee, with the MPCC. So if the NDP says that the Liberals would welcome some sort of an examination of their time in office and how they handle these, we already know, how ineffective and how challenging was the arrangements they had with respect to prisoner transfer, and it took a Conservative government to correct that and tighten that up. We know that for sure, Mr. Speaker. But I asked them to say, step forward, give us all the information they know or they were covering up for their time in office.
Questions and comments? The Honourable Member for Renfrew, Nipissing, Pembroke.
Thank you, Mr. Speaker. Would the Ministry of Justice tell us why the mover of today's motion is completely irresponsible to ask the government officials to break the law in the Canada Evidence Act in an attempt to further their own political gain? After all, wasn't it the Liberals who put in place, the former government put in place the Canada Evidence Act after the tragedy of 9/11?
The Honourable Minister of Justice.
Mr. Speaker. The honourable member has covered a number of points, and for me to speculate on the motives of the individual who made this motion, I can only say that they should adopt the same approach that we are taking, that the national security and the protection and the safety of those individuals serving in Afghanistan, indeed serving abroad, have to be the utmost concern of everyone, be it a committee of Parliament, the Military Police Complaints Commission, Mr. Speaker. This has to be our ultimate goal, and this is the point that I think I've made very clearly, and so have my ministerial colleagues, that we have a responsibility to individuals who assist in the safety of our individuals who serve abroad. Again, it's not just members of the armed forces, civilians as well. We want to make sure they're protected, disclosing, for instance, information as to when and how often they visit the detainees. That information like that, Mr. Speaker, would, in my opinion, jeopardize their safety if the terrorists get the log on something like that. Something like that could be very, very dangerous. And so this is our motive, Mr. Speaker, in all our actions in this area.
Questions and comments? The honourable member for Wascana.
Mr. Speaker, thank you. The minister's proposition today seems to be that properly informing Parliament and honestly and fully answering questions about crucial issues like our mission in Afghanistan is somehow inconsistent with protecting the public interest or safeguarding national security or ensuring the most safe and secure conditions for our troops and others in the field in Afghanistan and maintaining good international relations. He says there's a fundamental inconsistency between properly informing Parliament and safeguarding those other things. But I would ask the Minister, why is the government the only party that's in a position to safeguard those other things? Why is it not possible for the House of Commons, which the Speaker made a ruling on earlier today, having all the powers to do so, why is it not possible for the House of Commons and for Parliament to protect any sensitive information just as well, perhaps better, than the government can do?
The Honourable Minister of Justice, short answer, please.
It doesn't outline any particular procedure for that. I mean, the way it happens now is there are experts. These are public servants with expertise in this area, who work with other public servants who have no other motive, Mr. Speaker, than the best interest of this country and the protection of our men and women in uniform. No other motive than that when they make recommendations with respect to the redacting of documents. And to say to the, as the honourable member has suggested, say just dump all the papers. I wouldn't be even confined to that. I suppose tax records, anything else that they want. What we have said, Mr. Speaker, is that the process in place with unbiased experts, Mr. Speaker, that work within the public service of Canada who give advice on that, that is the proper procedure, and that's the procedure that's been taking place up to this point, Mr. Speaker.
Reprise du débat.
Resuming debate. The honourable member for Saint-Jean. Yes, thank you, Mr. Speaker. Mr. Speaker, the opposition motion that we have before us today is a replica of the motion that was adopted with respect to Afghanistan November 23rd last, asking the government to table a certain amount of documents. The motion is now before the House. The members at the Afghanistan Committee have done everything within their power to try to deal with the issue. We've faced a great number of obstacles. I believe that the motion that would be approved by the Parliament of Canada would bring to bear pressure on a government that is non-transparent. I would like to deal with the issue of lack of transparency and isolation on the part of the government. Just to recapitulate the facts, in 2005, 2006, all of this started at that time when the members of the opposition in this House asked the government questions with respect to the treatment of Afghan detainees. When I refer to that period, I'm referring also to the Liberal government of the day, as well as the Conservative government today. We were told that there was no torture. National laws apply. As the years went by, there was a news agency that conducted an inquiry, a serious one, and said that it was quite the opposite. Now, we have to get down to the bottom of things. There is the Military Police Complaints Commission that decided to conduct an inquiry on the matter. What they did and what happened there, just somewhat like the Afghanistan Committee, they had to face major obstacles, roadblocks put in their way by the government, intimidation of witnesses, muzzling, and also a lack of documents. And so what happened was the commission to which I refer, the Military Police Complaints Commission, had to stop its work.
It had to stop because the government did not want to allow certain witnesses to appear before it and did not want to disclose certain documents. So we decided, on the Afghanistan Committee, we decided that we would take up their work, the work of the Commission. And we have to deal with the same behavior on the part of the government. The government's having a harder time this time because now they have to deal with the opposition every day at question period. And there's also journalists who are relaying information to the public. And we haven't seen the last of this, Madam Speaker, where I've been in the lobby. I was in the lobby before my speech, and the situation is changing from minute to minute. And we want to really work at this quickly because the end of the session is creeping up on us. And when the House rises tomorrow, this will be put off till January. If they think that this is going to happen, the Conservatives are wrong because we want to get to the bottom of things. So here's a government that is not transparent and that is isolated because the government has its theory and just about everyone else has the opposite theory, including international organizations that are stationed in Afghanistan and who have proved regularly that there is torture. And this is rather conclusive. And I would say that the Geneva Convention speaks not only of torture, but also talks about other conditions. It talks about the risk of torture. So now we can say, yes, everyone acknowledges except the government, but that there is the risk of torture, and that there is torture because the Chief of Staff, General Natanchuk, came and said that he'd heard of this, and we know that there's more than what he was made aware of. And the people of Canada and Quebec are dealing with a huge cover-up operation, and I think the government will have to pay a political price for this. So what the motion before us is like the one of December 23rd, and I'd like to talk about the obstacles we've had to deal with in the Standing Committee. We asked for documents. We asked that they be produced by December 2nd. But as of today, of the 6 documents we asked for, we've only received 2. And these 2 were heavily redacted. And here in the House are certain things I can't say, but we have reports that have come out of the first series, of the first group of documents that were tabled by Mr. Colvin. And there are entire pages that are entirely blacked out, which led me to say to the Minister of Defense when he appeared before the committee that this kind of page was an easy one to translate because it wasn't there wasn't anything that anyone could see, and this prevents members from one of our major responsibilities, which is to investigate certain situations, and these include now what was said by the General Natanchuk yesterday. We're told the Conservatives talk about danger for soldiers, but there are witnesses. who appeared before the committee who did have access to unredacted documents. So put yourself in our place, Madam Speaker. You have people there who have had access to all of these documents, unredacted, and they even boast about it. They say, we have the documents, but you're members, you get the redacted documents, so you don't have the truth. We cannot accept that such heavily redacted documents can help us. How can we ask proper questions of witnesses? How can we take full cognizance of the situation if we don't have access to these documents? And we feel that their production was intentionally delayed. They're delayed, and it's not because the House will rise tomorrow that everything's going to end until we come back in January. We, the Afghanistan Committee, will continue sitting so that we can make sure that we get to the bottom of this issue. Now, there was a point of order earlier, and I think it's important, and colleagues mentioned this earlier. One of the first witnesses who came and appeared before the Afghanistan Committee regarding Afghan detainees was General Watkin. Now, what was supposed to have happened, and what happened at the committee, happened at the Afghanistan Committee. The General started to say, I have a certain I have a certain relationship with my clients, or there are things I cannot disclose. So we started saying, well, what is a parliamentarian's right vis-a-vis the right of an advocate general who's defending the government? And what about this privileged relationship with his client, which is the government of Canada? So we brought up very important points. We, members of Parliament, we are the major investigators. The House of Commons is where we decide to get to the bottom of things, because we have the legitimacy of having been elected, and we have a responsibility in our respective files to get to the bottom of things when things aren't clear. That's what parliamentary democracy is. But the government, which is in the British tradition called the protector and defender of the realm. So, who has the greatest right? Well, it's parliamentarians. And legislative advisors tell us, jurists tell us, that we have to fulfill our duties as parliamentarians in the way stipulated in the Constitution, and the House is the only entity that can decide how the law applies to it. This is very serious, Madam Speaker. So when people come up with the some section of the Canada Evidence Act, we can, according to our law clerks and legislative people, we can go beyond this. If an act allows a minister or the government to hide information from Parliament, it would give the government the possibility of taking advantage of the law to get away from its responsibility to be accountable to the House. And this would be unconstitutional and against the fundamental principles of our parliamentary system. This is a parliamentary principle which cannot be obviated. So when we ask for unredacted documents, we should get unredacted documents. When we ask for documents within a certain period, these documents should be disclosed in that period of time and not weeks later. Because here we are, December 10th, and the documents which were supposed to have been tabled by the 2nd of December have not. So here we have the primacy of Parliament, otherwise democracy does not work. And otherwise, the government could say, I'm not going to make these documents available. Otherwise, the minister, and I'm quoting what the law clerk says, there is parliamentarians' rights are not being respected. There's also parliamentary immunity, which is being compromised. And this cannot be subverted by people who say every 5 minutes that they have other things that they have to be responsible for. And now there are people who may disagree with us, but we, in what we say here and in what we say in committee, we need immunity to say what we want to say, to have the freedom to say what we want. There has to be immunity. There has to be primacy of parliamentary rights. And a senior official from the Department of Foreign Affairs said to Richard Colvin, before he appeared before the committee, and I'd remind you that Mr. Colvin appeared before the committee. When he did, we'd already asked the Advocate General that he consult with his client and that he let us know how he interpreted our request. And it was the witness who came, and this is what the senior official from Foreign Affairs said. As the Government of Canada does not share the opinion of the legal expert, well, we had asked expressly for the opinion of the Advocate General, but they didn't. And I'll continue, Madam Speaker. They say that they didn't share the legal expert's opinion, and that we hope that as officials, as bureaucrats, and they're talking about Richard Colvin, as an official of the government, you will behave according to the way the government wished. What they were saying to Richard Colvin was to shut up and to comply with what the government wanted, to hell with parliamentary rights. And we were asked to communicate with the Advocate General, and this sort of thing is called depriving a witness of his immunity and intimidating a witness, because the government could say to a witness, here's what you're going to say, and that's what they say here. So how can we get to the bottom of things in these conditions? It's very clear that a witness was intimidated, and it's very clear that the government tried to prevent the committee from proceeding with its deliberations. So we have intimidation of a witness. And there's another point I'd like to make before my time is up. There's also the minister's accountability. There was the Minister of Foreign Affairs, Minister of National Defense, and the President Government Whip, who is the former Minister of National Defense, came and explained to us how important national security was, how important the Evidence Act was. And with respect to the delays in getting the documents to us, they say, well, it's not our problem, it's the officials, these documents have to be translated. It's 16 years I've been hearing this. It's one of the best ways to get around a committee is by saying, we don't have the documents, they're not ready, we can't go forward. But that's their responsibility, and what those three ministers said and what the government is doing is they are abdicating their responsibility and getting officials from the department, the various departments, to decide whether there are dangers to security. But they aren't the ones who should be deciding about redaction, because where's ministers' accountability in all of this? And they say, look, it's not us. It's not my department. And the other says, it's not my department. We even heard it might be the armed forces. So who's accountable here? Who's responsible? When one becomes a minister, there is a duty to be accountable to the people. And we will not accept that ministers try to abdicate their responsibility, to weasel out of their responsibility, and to not be accountable to the people of Canada and Quebec. This is important because we're sick and tired of hearing these things. intimidating witnesses. There was a official at the Department of Foreign Affairs who was saying things to Mr. Colvin, but who does he have to answer to? I think it may be the Minister of Foreign Affairs. We also saw ministers blaming their officials. They'd say, look, it's not us. Documents at the Department of National Defense, well, there are thousands. I don't know what, I haven't seen the ones you're talking about. So these people are failing in their duty to be accountable. They should be acting in a way that is professional, transparent, and they should be aware of what's going on in their department. It's not true that a minister who gets all these questions can go back to his office and say, no problem. When you are asked to be accountable, you call people in to find out what's going on. If you don't do that, you're failing in your responsibility. It's certainly not up to the opposition. We are trying to get to the bottom of things. We're trying to find out what's going on. But the ones who are accountable are the ministers of the Crown, and they have to be up to the task, and they have to act with accountability. And this is why we have to bring this motion. This motion had to be made in order to get documents. So we've been denied access to documents concerning the military police. We've been denied access to the Committee on documents asked for by the Committee on Afghanistan, and documents requested now by the Parliament of Canada. We have to ask this government, this minority government, they're not a majority. This means that there are a lot more people who trust in the motion before us today than in the government. That's the sad reality. We have been entrusted to act in such a way that in these situations we find out what's going on. But they said they basically told a witness, you're going to say this and this and not this other thing. So who's done this? They say it's an official who's done it, but Madam Speaker, I'm sorry, it's the minister who is ultimately responsible. So you won't be surprised to learn that we're going to support the motion before us today. And things won't stop there, Madam Speaker. We want the government to know that they're going to they may throw up all the roadblocks they want, but we're here to represent democracy. They're the defenders of the realm, and that's fine. Let them defend their realm. But this House of Cards is going to collapse, and we will be supporting the Liberal motion. Questions and comments? The Honourable Member for Notre-Dame-Lachine. Thank you, Madam Speaker, and I'd like to thank my colleague, the member of the Bloc Québécois. I'd like to thank him for his support and the support of his party. I would like to emphasize one point because the member mentioned the fact that this is a minority government and should not have acted as it did. In 2004, the Liberals were in government and were a majority government until the elections of June 2004. And if the House remembers, the Public Accounts Committee had begun sitting on the Auditor General's report on the sponsorship question. The committee, and I was vice chair of the committee, I tabled a motion demanding that the government make available all cabinet documents relative to the sponsorship issue. We wanted all documents, and the government, which was a majority government, acceded to the committee's request. And this was the first time in the history of Confederation that a government disclosed the documents and reports of a cabinet committee and there was no obstacle thrown up before us. So I would ask the member, what does he think, with the example before us, what does he think of the behavior of the present Conservative government? The Honourable Member for Saint-Jean. Well, I agree with my colleague, and my colleague in the bloc sits on the committee with you, and she said that they didn't have to push on, they didn't have to bring forward a motion in the House to get the documents. But I'd also like to get back to what you said, to what the member said when she said that that government was a majority government and this government is a minority government. What I'd like to ask is, just imagine if this government were a majority government. Just imagine the kind of situation we'd be in. Because what we're seeing today is only a small part of what we'd have to deal with if this government were a majority one. The Honourable Member for Edmonton Centre.
Madam Speaker, and with respect to opinions, which is what we've gotten from various legal experts and people in the legal profession, an expert is someone who agrees with you. That makes him an expert. Also, it's interesting to see the member of the bloc so concerned about the protection of the Constitution of Canada when, in fact, they want to break up the country. But I have a simple question for my colleague. With respect to the inadvertent release of information, the kind of information they're asking for, what's he going to say to the family of a soldier or the family of an aid worker who's been killed because of release of information or because of an international organization that we had previously been able to trust, or they'd previously been able to trust us with information, and then withholding that information? What's he going to say to that family?
The Honourable Member for Saint-Jean. Well, on the matter of the Constitution, Madam Speaker, quite clearly we can't progress in a constitutional vacuum. Even if we look at the current structures of the Canadian Confederation and Constitution, we have to honour the current framework, which is the Canadian Constitution. If Quebec were to become sovereign, it would have its own constitution, and it's the underpinning of a democracy at the end of the day, a constitution. So for the time being, respect the Canadian Constitution. Now, as to the government's arguments, they always say, oh, you're endangering soldiers, or you're Taliban dupes, or we hear that often, but that's not the issue at stake. There are many, all they have to do is provide us information that we request. So when information is revealed to members of Parliament, we'll be responsible enough to broadcast it. We understand that there are operational constraints, but I'm tired of the government still using the same arguments. They say that we're manipulated by the Taliban, we're Taliban sympathisers, and that we're endangering our families, our soldiers and their families. But what does endanger the families and soldiers is when the government makes big mistakes like they've just did, and when they are not legally bound to respect certain obligations, such as the proper treatment of detainees. Questions and comments.
St. John's East.
Thank you, Madam Speaker, and I appreciate the comments of my colleague from Saint-Jean. And his party have supported our call for a public inquiry and for the resignation of the minister, neither of which the government has agreed to yet. So the committee work that's going on right now seems to be the only method, and it should go forward. So this motion helps that. One thing that has come out in the committee is that from David Mulrooney, he said very clearly, he was the most senior diplomat involved, was that in May of 2007 or thereafter, we started to develop a database of people who we had detained. Now, that's the closest that the government has come to admitting that prior to that they really didn't keep a very good track of who they were detaining and what was happening to them. Is that piece of information give rise to a greater need for us to know exactly what was known prior to that time by this government?
The Honourable Member for Saint-Jean. My colleague's right, Madam Speaker. In many documents, that we've seen, the government didn't have a proper database of the detainees handed over to Afghan authorities. So how can the government complain that there was no torture? Now, once a detainee is handed over to the Taliban, then they're out of sight and out of mind to an extent for a number of months. So quite clearly there are detainees that have been handed over, and we've never heard anything about them ever since. Now, there are very critical and negative reports of all the non-government organisations, such as Red Cross, Human Rights Watch, or the Independent Afghan Commission on Human Rights. And these groups have said that torture is widespread. To remind you, Madam Speaker, that the Geneva Convention doesn't just say you can't hand over detainees if there's a risk of torture, if there is going to be torture, but even if there's going to be a risk of torture, then they shouldn't be handed over. And the Chief of Defence Staff yesterday has confirmed that there was one case, and we believe that there were far more than just one case.
Member for Mississauga South.
Thank you, Madam Speaker. And I guess as Canadians follow the story, they're confused a little bit about why parliamentarians who represent all of the people in the country are unable to have access to the documents. And I think they've all heard about the Parliament's unfettered right to call for persons, papers, or records. And we've had many examples, and there have been challenges in the courts. There is another way, and I'm wondering why the committee didn't seek to have the government swear in to the Privy Council those members of the committee who were not already Privy Councillors, which would in fact give them the possibility of in-camera viewing of the unredacted documents, which would have been eminently a good approach, simply because the government and witnesses had declared that there was nothing in the materials that would indicate anything about torture. Were there other options considered by the committee?
The Honourable Member for Saint-Jean. 1 minute to respond. Thank you, Madam Speaker. I tell my colleague that perhaps that would have been one way of doing it. I admit that the committee still hadn't considered that way of proceeding, but what we did consider was listening to witnesses, and when a witness got to the point where he or she said, this is a secret, there's different security levels, top secret, etc. So when the witness was about to reveal a secret, at that point we would move in camera, and those not entitled to stay would leave the room, and those entitled to hear would stay. Now, sometimes it's tough when there are journalists waiting at the door who say, well, what was just said? But we'd be bound by the in-camera provision. And I appreciate what the colleague's advice, and if any other colleagues have good advice, we're all ears.
Well, member for St. John's East.
Thank you, Madam Speaker, and I'm pleased to have an opportunity to join in the debate on this Opposition Day motion calling for papers and documents to be presented in an uncensored form to the House. Before I talk a little about that, I want to just emphasize what this whole issue is all about. This is about Canada meeting its obligations under international humanitarian law. And I just want to quote Brigadier General Ken Watkin, who appeared before the Afghanistan Committee several weeks ago, and he was the one who laid it out that transferring prisoners to a situation where there's a real risk of torture or abuse is contrary to international humanitarian law, or the law of armed conflict. And that's precisely what the situation is that we're concerned about, and what Canada had done in the period after they started taking prisoners. And I should have said, Madam Speaker, I'm sharing my time with the member for Ottawa Centre. So I will only have the first half of the 20-minute period. So the important point here is that the inquiry by the House of Commons Committee on Afghanistan is in furtherance of trying to find out what in fact, this government did in order to meet its obligations. And what have we heard from the government? We've heard a defence based on, well, regardless of what happened, there is no proof that any particular prisoner passed over by the Canadian forces was subject to torture or abuse. And this has been said in the House many, many times. On 4 occasions on November 23rd by the Minister of Defence. There has never been a single proven allegation of abuse involving a prisoner transferred by the Canadian forces. Not one. 4 times that was said on November the 23rd. The Minister of Foreign Affairs and International Trade said on December the 1st, let me be perfectly clear, there has never been a proven allegation of abuse involving a transferred Taliban prisoner by Canadian forces. On December the 4th, the Minister of Transport, there has not been a single proven allegation of abuse of a Canadian transferred prisoner. Well, we know that that's not true. We know that that's patently false. The government has been providing false information to this House. So what are we to do about it? Our party has called for a public inquiry based on the revelations of our diplomat Richard Colvin, who, starting in May of 2006, was writing memos and letters, 6 of them in 2006 alone, referring to the problems and passing them on. We haven't seen those memorandums yet. We haven't seen them. In fact, we've seen one. We've seen one, and this is an indication of why there's a need for uncensored documents. We've seen one dated December the 4th, 2006. The subject line is Afghanistan detainee issues, and it refers to earlier memoranda of July 25th, 2006, October the 6th, 2006, and November 24th, 2006. And this was given to the committee. But it was given to the committee with nothing on it, all blacked out for pages and pages on end. 3 pages of the entire text of that memorandum was blacked out with nothing being disclosed to the committee. And the reply directed to an ambassador also entirely, and they were redacted, seems to be the favourite word, censored, deprived the committee and the public of knowing what in fact Mr. Colvin was saying and talking about under the heading Afghanistan detainees. We need to know. We need to know. If there's nothing to hide, then the committee can find a way, as has been suggested, at looking at these documents, whether it be in a meeting that's in camera, or whether there's a Privy Council or opportunity or option is chosen, whatever way is needed to make sure whatever issues of national security are concerned. But the fact of the matter is this information needs to be made public and known. General Natinchik yesterday confirmed what has been reported in the press, that yes, indeed, Canadian detainees passed over were abused. They took them back. Another individual they didn't pass over because they had overheard. The interpreter overheard the Afghan police force individuals talking about killing this individual. This confirms Mr. Colvin's concerns and others about extrajudicial killings. This confirms the notion that the soldiers knew in the summer of 2006 that there were a potential for prisoner abuse, a real risk of abuse or torture. The soldiers knew. In fact, not only did they know that, they took pictures, and they said they were taking pictures before they passed them over because they were concerned that they might be abused, as had happened before. So that knowledge was live, on the ground, in the field in Afghanistan at that time. And yet this government continued to order prisoners to be passed over to the Afghan authorities. That's the problem here, and we need to get to the bottom of it. The government doesn't want to have a public inquiry, which we called for, and which this House called for on December the 1st on our Opposition Day motion, supported by the Bloc Québécois and the Liberals. They still refused to have a public inquiry, and they refused our request when the full extent of the lack of forthrightness by the Minister of Defence and his misleading of the House on these issues, our request for him to resign and our insistence that he take responsibility as Minister for misleading the House. Both of those have been refused. So we still have a committee at work, and we do have the supremacy of Parliament. We can't have a situation where, as the Minister of Justice suggests, that some individuals using their discretion are saying, no, the members of Parliament can't find out about what's going on, and that's their position. But that's the wrong position, Madam Speaker, and this has been very clear in the documents and the authorities. The claims of Crown privilege do not diminish or derogate from the power of a House to require attendance, testimony, and production of documents. There's a very comprehensive study published called The Power of Parliamentary Houses to Send for Papers, Persons and Records by Derek Lee, MP, a member of this House, and a lawyer, who compiled all of the authorities that relate to the publication or to the ability of a House and committees to get documents. And there is provisions for a request by the government for the committees not to take the parliamentary powers to the extent. And Mango writes, for example, with respect to federal public servants or witness before committees, the theory of the compellability of witness to answer questions generally may come in conflict with the principle of ministerial responsibility for the public servant question. By convention, a parliamentary committee will respect Crown privilege when invoked, at least in relation to matters of national and public security. In the final analysis, however, witnesses must rely on the collective common sense of the members of the committee and their good graces, because certainly the Crown has the right to claim privileges, but the supremacy of Parliament is incontestable. Incontestable. So while they may claim it, the power of the Parliament is predominant and overrides that, and this is a perfect example of where that needs to be the case, because we have a Parliament here. The majority of the members of the Parliament sit in opposition to the government. The government is seeking to use means to prevent the Parliament from exercising its power of being supreme through its committee. And this is an example of an important constitutional matter. The supremacy of Parliament over the executive. Obviously, there may need to be means to ensure that there is a way that if there are something that is genuinely should not be disclosed, that it not be disclosed to the public. But being disclosed to the public and being disclosed to members of Parliament are two different things. And I think that members of Parliament understand and know that. We support this motion, Madam Speaker. We think it's time that Parliament ensured that its privileges were respected and that they can be counted on, and members of Parliament can be counted on to do their job and act in the public interest. Thank you, Madam Speaker.
In comments, the Honourable Parliamentary Secretary to the Minister of International Cooperation.
Mr. Speaker, or Madam Speaker, I would like to ask the member a very direct question. Much of the information that has been blacked out, redacted, that has happened in order to protect confidential sources that the Government of Canada receives the information from. It is also done to protect the lives of Canadians who are serving there, either in the military or in other ways in Afghanistan. Therefore, much of the information, even if he should be able to see that information, in fairness to our ability as a nation to be able to act in the world as a member of the world community, and certainly to protect the lives of the Canadians who are there doing their thing on behalf of Canada, he would not be able to speak about publicly. What is he going to do with this information? I find it rather curious that he wants a wholesale exposure of all of this information. There is absolutely nothing in the motion that restricts us from having a wholesale exposure of this vital information.
The Honourable Member for St. John's.
Thank you, Madam Speaker. The motion speaks to making it available to the House. You know, this is a copy of the documents that the committee got so far with all kinds of censorship. But, you know, they talk about national secrets and all of that. But contained in these documents is redactions of the number of detainees who were detained on a particular day in 2006. That's blacked out. How is that in any way concerned with the national security today, 3.5 years later, whether they detain 2 people or 3 or 4 of this, or that level of detail is redacted, blacked out in such a way as to make the committee feel that we don't really trust the people who are crossing all this out. We don't think that the information that needs to be available is available. And the business of protecting lives, I think that that's rhetoric that the government is using to try and hide behind. The members of Parliament have to be trusted to be able to see this, to be able to exercise their judgment about what the government knew and should have known at what relevant time.
Questions and comments? The Honourable Member for Ottawa Centre.
Thank you, Madam Speaker, and I want to thank my colleague from St. John's for his intervention. One of the things that we know as we've studied this file, and it goes back to 2006 for our party, was that other countries were doing different things when it came to detainee transfers. And it relates to what the discussion is today, because there was much more transparency in the case of the UK, and still is, and of course with the Dutch. What they do, Madam Speaker, is they actually, in the case of the Dutch, every time there is a transfer of a detainee, their parliament is informed. And we have this government censoring documents just on that, on the numbers of detainees that are transferred, as my colleague from St. John said, even back to 2006. It seems like a little bizarre when you have our government saying it can't allow that information to be put out when our allies are doing that. In fact, our allies were saying to us back in 2006, you need to get a better process. So just wonder what he thinks about our redaction and censoring versus our allies' sharing of information.
The Honourable Member for St. John's East.
Thank you, Madam Speaker. Well, clearly, as the member for Ottawa Centre knows, the government has built up a wall of secrecy around this that's unbelievable and unnecessary. As pointed out, the Dutch Parliament is told the number of detained, number of people captured each day as they're captured. So it obviously is not regarded as national security in any general sense. This government doesn't want to make it known because they have this wall of secrecy, this idea that no one should know what's going on. That's been the real problem. And an inquiry, a full public inquiry, would actually lay out for the governments of the future and this current government what we have to do in order to comply with our international human rights obligations. That's something that we need to know. We don't really have faith that this government has got it right, because they can't even get it right in terms of letting us know what's going on. They haven't been providing the information that we need. They've been giving false information to Parliament, and this has been an ongoing situation. So we need to have the answers. A start would be this committee doing its work. The full answer should be a public inquiry.
Resuming debate, the Honourable Member for Ottawa Centre.
Thank you, Madam Speaker. And I want to start off by sharing with members of the House some of the information that we have had access to. I think one of the concerns we have, and I think the debate today, is around access to information, so that we can actually get to the bottom of what was happening and perhaps is happening with regards to the transfer of detainees from Canadian forces to Afghan authorities. Madam Speaker, one of the things that has been available to members of Parliament and the public is testimony from the federal court. And I'm going to be just reading into the record some of the evidence that was provided during a testimony cross-examination of Kerry Bucket, of course, a government official. And the questions are around what was happening on the ground in terms of investigation and follow-up. And one of the challenges in this debate has been trying to figure out who's responsible for what. And that was most of the thrust of Mr. Colvin's messages, was trying to figure out, what the roles of each of the institutions were, Canadian Forces, DFATE, etc. In this testimony that is available, and it's not censored, there is a question from the lawyer to Ms. Bucket saying, in the next bullet it says, referring to a detainee, he was hit on the feet with a cable and a big wire and forced to stand for 2 days, but that's all he showed. the Canadian officials and a mark on the back in his ankle, which he said was from the cable. And Ms. Buck refers to, yes, that's the allegation. Has that allegation been investigated, do you know? And this is where it's important. What Ms. Buck says is that they really aren't responsible for investigating. Now, Madam Speaker, we've heard time and time again from this government is that there's not one scintilla of evidence that a detainee who was passed on from Canadian forces to Afghan officials was tortured. The problem, Madam Speaker, and we see this in testimony here that I'm reading to the record, is that there was no follow-up because the role was this. The Canadian forces passed on detainees to the Afghan officials. After that, there was no investigation of allegations. In fact, it was reliant upon the Afghan Independent Human Rights Commission to do that and the Red Cross. Now, here's where it gets interesting, Madam Speaker. When we have testimony where it says, and I won't go through it all, but talking about marks and individuals having allegations about being beaten, etc., there is an attempt to find out, well, who is responsible? If there are allegations, the government agrees there's allegations, and they claim that none of these allegations were ever proven. But you have to begs the question, if there are allegations, who is following up? And if it wasn't Canadian officials, then obviously Canada won't know what is happening. Then the question is, well, who was doing it? Well, we find out, Madam Speaker, is that there was no connection between the Canadian government and the follow-up to any investigations. I'll just give you a little bit of the record to underline what I'm saying. Ms. Buck says allegations are allegations. Some are valid, some will not be valid. At least she acknowledges that some of the allegations would be true. And the question is, but don't we make any of our own independent assessment of the potential strength of the allegation? The question posed to Ms. Buck. Here's the answer, Madam Speaker. We don't, she says. We don't. It's not our role. It's not our role. And the question then is, it's not our role to determine whether there might be some kind of risk that detainees are being tortured. Answer, no. It's not our role to determine risk, but it is not our role to determine credibility of the allegations, to determine veracity of the allegations. We don't investigate those allegations. We record them. Now, the problem with that, Madam Speaker, is the following. If we look at the evidence that we have available, we have the ICRC, and now there's been articles written about this, having met with Canadian officials saying, you've got a problem with the transfer process. They were not referring to the fact that detainees are passed over. It's what happens to them after and the follow-up and the investigative procedure. We have Ms. Buck saying, for the record, we don't do that. Mr. Colvin is saying at the same time, there is a problem we have, and he says in one of the memos that we did get, it was highly redacted and goes to April 2007, the Red Cross's position is that each nation has international legal obligations regarding the transfer of detainees. What that means is not simply that we have a legal obligation to say we've handed them over, but to follow up. And this is where there has been a black hole, Madam Speaker. The government has always said we're not, there's no proof of any detainees being tortured. That was blown out of the water yesterday. But they continued down this path of basically saying, once we hand them over, we're not responsible. Now, some of the memos here indicate there was a debate, and this is reading the tea leaves, between DFATE, Canadian forces, as to who's responsible once those detainees are handed over. This is a memo that I'm reading again. It was redacted, but it says here, this is Mr. Colvin's, one of his memos. It says, however, I'd like to note that the ambassador remains strongly of the view that initial notification should be of handing over detainees should be by Canadian forces, and that secondly, notification of the Red Cross and the Afghan Independent Human Rights Commission should be sent as soon as an Afghan detainee is detained by Canadian forces, not only in connection with his transfer to the government of Afghanistan custody, this would serve two important purposes. One is that it would underline DND's ownership of detention, and DFATE would assume responsibility for follow-up once a detainee is transferred to the government of Afghanistan. So here we have the debate Mr. Colvin has laid out, that who's responsible? Is it Canadian Forces? Is it DFATE? The generals and Mr. Hillier, etc., all said, well, once they're handed over, it's not our role anymore. The soldiers who were writing in the field, and we heard from the Chief of Defence Staff yesterday, said they were worried about handing them over because of what would happen. And they said not only what would happen to this one particular detainee, but it had happened before. So they did due diligence, they did their job, they took pictures, they wrote notes. But what we have here is the gap, that there was no process to follow up. And the debate is saying, look, whose role is it after a detainee has been handed over? Why were they concerned, Madam Speaker? Because, and we've gone over this many times, the Red Cross, the Afghan Independent Human Rights Commission, the State Department, our own human rights reports done by DFATE said there was problems with torture in Afghan jails. There was extrajudicial killings. The soldiers knew that. We had evidence yesterday from the Chief of Defence Staff who said, in the notes that were handed over, overhearing Afghan officials saying they were going to kill one of the detainees. So the problem was obvious to everyone. The issue was, what did the government do about it? In this memo, one of the ones we got that wasn't highly redacted says there's a debate. Who's responsible? Colvin's note says initially it is the Canadian Forces. After that, it's the DFATE officials. What we have, though, from Ms. Buck, what I already read into the record, is she's saying we're not responsible for investigating after. There is a huge hole here. Under international law, we're obligated to follow up if there is a risk or a probability. That's very clear. So the question is, and what we're needing from government, is all of the evidence. It leads us to my final statement on this, and I'll sum up, is how can we trust this government with the present detainee transfer agreement, which I have concerns about, if we're not able, in terms of investigation, etc., if we know before they weren't investigating when they knew there was torture and there is international law obligations. And from all the data we've gotten and the redacted censored documents we have, there was a debate and a concern within departments by the Red Cross and others. And, Madam Speaker, they seem to have ignored it. So finally, we call on the government not only to bring forward these documents so we can have an actual overview of this without all the censoring, but we need to obviously have an inquiry on this. If they aren't able to do that, then they've lost the trust of this Parliament to actually be upfront and remain concerned about the present agreement. Thank you, Madam Speaker.
Questions and comments? The Honourable Member for Edmonton Centre.
Thank you very much, Madam Speaker. And this member continually confuses the timelines here, and I'm sure he does that for his own reasons. But he talks about the ICRC and the AIHRC and how they weren't passing information. That was the arrangement that we had with them. We were trusting them to do that. When we found out they weren't, we made changes. And that's what he's completely missing, completely ignoring. The ICRC has refuted the story about dealing with Canadian officials. They said they just don't operate that way. They said they had an excellent relationship with Canada. They said they would never go public unless there was a problem. They never went public. So, Madam Speaker, he's not situating the time frame when anything was happening. Sure, there were discussions. They started in 2006. They carried on through 2007, into 2007, when we actually made changes based on all the information we got from all the sources. So I'd really ask the member to quit misleading the House, quit misrepresenting the situation by concentrating on what was happening in 2006 and not talking about what was carrying on in 2007 and is working very well today, notwithstanding that one Taliban got hit with a shoe.
The Honourable Member for Ottawa Centre.
Well, I appreciate that sometimes rhetoric gets the better of us, but for the Parliamentary Secretary to say that there was some concerns about a prisoner only getting hit by a shoe undermines the actual notation by one of our soldiers. one of our soldiers, reportedly the ones that they support, was very clear about the fact that they were concerned about extrajudicial killings and torture, and wasn't concerned about being hit by a shoe. But put that aside, which is a big aside, the ICRC was saying on 3 different occasions, meetings with ministers and officials, you're not doing your job. What the ICRC also said is that we don't tell the Canadian forces and officials what's been happening. We only tell the host country. We can't. We're not mandated to. And there was one of the ministers had to step aside and apologize because that wasn't clear. In November of 20th, 2006, put the time frame in for the parliamentary secretary, we had officials drafting talking points based on the concerns of the ICRC. Talking points. You know what the concerns were? The concerns were handing over detainees to probable torture. Instead of fixing the problem, this government was more concerned about talking points, spinning, and trying to get the public on side rather than to fix the problem. So 2006, that was happening. The member should know that. I know he does. And this wasn't about someone being hit by a shoe, Madam Speaker. The field notes of that soldier were clear. There was beatings by police, and that's why the soldiers made sure to rescue that prisoner and did the right thing. I think it does a disservice to our men and women in the field to say it was something else.
Questions and comments? The honourable member for Elmwood Transcona has just time for a very short question.
Thank you, Madam Speaker. It's a very secret defensive government. I asked an hour ago, government member, why did the government leak Mr. Colvin's memos to the media, and why is it obstructing the Parliamentary Committee's request for documents? Absolutely no answer to that direct question. I asked him if the government has nothing to hide, why did it obstruct the Military Police Complaints Commission? And he did say there that the government was making documents available to the Military Police Complaints Commission, which I'm not sure is the case, but I asked the member if he'd want to elaborate a bit on that. But once again, we've got an obstructionist, defensive government here who, when asked a pointed, direct question, skates around the issue, filibusters the question, and doesn't answer it.
The honourable member for Ottawa Centre has.
Thank you, Madam Speaker. I will answer quickly. What we've laid out here is, instead of the government doing what, quite frankly, the Chief of Defence Staff did yesterday, when you have a problem in front of you, instead of trying to just lay talking points over it and trying to build a wall of secrecy around, deal with it. The Military Police Complaints Commission hasn't been able to do its job because it wasn't getting the information it needed to do its job. We aren't able to do our job in committee because the government keeps on withholding information, or the information that it does we get from the government is entirely blacked out. So what we have is a pattern of this government of trying to deny the facts, withhold evidence, and block any kind of inquiry that will get to the bottom of what all of us are concerned about, hopefully the government as well, is what is happening in the field. What is happening to are we living up to international law? Those are real concerns. They affect the men and women in the field. They affect our reputation.
Resuming a debate, the honourable member for Richmond Hill.
Thank you very much, Madam Speaker. I'm pleased to debate this motion today, and I want to start out by outlining where I'm going to be going. I look at the context of how we got here. I want to talk about the government obstruction, the rights of a committee, the importance of this issue to Canadians, and clearly why we need a public inquiry. There's no question, Madam Speaker, that this is a very serious issue. As a parliamentarian, I need to be able to have access to information in order to carry out my responsibilities, which of course is oversight of government. The issue we're debating today, of course, has nothing to do with the actions of our forces on the ground. They're doing an outstanding job. We know that. We know that the men and women are performing first class in the field, having been there on 2 occasions. I know that for a fact. I know that our diplomats and our military are discharging their responsibility. The question is the government discharging its responsibility not only to Parliament, but to Canadians? And this needs to be emphasized, that again, as a parliamentarian and as part of this special committee, which was set up as oversight with regard to the work that we are doing in Afghanistan, we need to be able to inform Canadians. You cannot inform Canadians unless you have information that's readily available. It's also about Canada's international obligations in terms of the Geneva Convention, the issues on human rights. And again, our soldiers are following the absolute letter when it comes to that. The issue is clearly what the government knew, if and when there were abuses, when Canadian detainees were transferred to Afghan authorities, whether they be Afghan police, Madam Speaker, or whether they be the Afghan National Army. There is need for accountability. Government has to be accountable, and ultimately in this country it's accountable to Parliament. Parliamentarians, if they have any role, it is the role of oversight. If they have meaning, and this of course is important, I think, on both sides of the aisle, because they must have the ability to have oversight, to call for documents, to call witnesses, and to be able to ask the questions, sometimes uncomfortable for government, but they have to ask the questions in order to get the answers. And wherever that goes, that's obviously important. I give you the example that we have, at the moment, a number of allegations that are out there. And these allegations are difficult to deal with if you don't have the documents. We've had witnesses before the Special Standing Committee, Madam Speaker, who've obviously seen the documents, but they've seen them unredacted. They've seen them without the black marks all over them. And I know I'm not allowed to use props, Madam Speaker, so I won't, but I will tell you, and I know that you probably have seen them yourself on television, where there's pages that are simply black. And we don't know what the date is or who's involved. Certain words are out. And therefore, as a member of that committee, as the vice chairman of that committee, I can't really determine very much if all I see is blacked out documents. I mean, when we talk about climate change, it's amazing the number of trees we have cut down in order to produce what? We've produced simple documents that don't tell members anything. But again, some committee members certainly are aware that the witnesses, many of those witnesses who came before the committee, had access to the documents unfettered. That, I think, is very disturbing, that witnesses would be able to look at the documents, but somehow members of the committee cannot. And therefore, the purpose of today's motion is to deal with this issue. And I'm going to get in later on to the rights of the committee and, of course, the legal issue that we're dealing with, Madam Speaker. When we say, is the government covering up? Is the government covering up torture? Well, one would conclude that that might be a logical assumption if, in fact, they're not prepared to provide the evidence that the committee members need. And one would assume, unless by chance, Madam Speaker, that one side of the committee, that is the government members, have seen everything and we haven't, that it would be of course of value to all members of the committee to be able to have the documents unfettered. But apparently, members on the other side believe that they can do the work without having that. This country has a long tradition for human rights. It has a long tradition in the world and on the issue of protecting the individual. Our central foreign policy has traditionally been on the issue of human rights and the protection of the individual, the right to protect. And therefore, Madam Speaker, it is absolutely critical that when there are allegations going back as far as 2006, that we be able to investigate in a manner, again, under the parliamentary motion of March 2008, which gave that committee that oversight on the very issue that we're talking about. A public inquiry, then, is where we're eventually going to be talking, Madam Speaker, but in terms of the specifics of this committee has heard witnesses, and we've heard different views. We've heard from Mr. Colvin, a respected diplomat. We've heard from 3 respected generals. We've heard from Mr. Mulrooney, our current ambassador in China. The issue is that we have heard testimony
and there is conflicting testimony. And obviously, if these individuals have access to documents which may shed light on being able to find where the truth is, we can't do that unless the documents are produced. The government has, from the very beginning, said, well, there has been no credible cases of abuse. And that has been the line in this House from day one, that we don't have any credible evidence. Well, how can they be absolutely certain? And yesterday, of course, the Chief of the Defence Staff, General Tinchuk, who is a great Canadian and a very honourable individual, had come before the committee, before the Defence Committee on Tuesday, and indicated that, to the best of his knowledge, that the individual in question in the Noonan report was in fact not a Canadian detainee who was transferred over to the Afghan National Police. Now, the General took the extraordinary step yesterday of convening a press conference to indicate very clearly that new information had come to light and that, in fact, it was a Canadian detainee who was transferred. The question, of course, then, is what information came to light, and why does this committee, the Special Standing Committee on Afghanistan, not have that information? Clearly, the General has information which led him to say, no, what I had said on Tuesday was not correct, and on Wednesday, I have new information. Everybody seems to have information, Madam Speaker, except the very members of the committee who are charged with the responsibility of dealing with this issue. And therefore, that is why we are saying not only is there a cover-up, but the need for a full public inquiry. Without a full public inquiry, it seems that we are simply a Hollywood backdrop here, Madam Speaker. We're not able to get the kind of information that we need. I can't believe that members on the other side are not as frustrated as those of us in the opposition. The government cannot, in my view, Madam Speaker, and I'm sure many of my colleagues would agree, deny any further that there is no credible evidence. No credible evidence. Because when Colonel Noonan did his report, they took photos of the individual before they turned him over, and there was, of course, very clear that there was no signs of any abuse, and they took detailed notes. Later, we found that there was. So the Canadian soldiers did their job. We're asking the government to do its job by providing the information that we need. And again, General Tinchuk received information. He has now indicated that this was a Canadian detainee who was turned over. We need to know on what basis that he decided to come out and say, in fact, that this, in fact, was the case. Without that information, again, it's difficult for us to do very much. Now, I realize that maybe the government's motive or the government's intent is that the committee not be able to do its work successfully. I know the government would like this to go away. I know the government would like us to say, well, Christmas is coming, and this will be off the front pages, and we won't worry about this, and when we convene at the end of January, we'll move on to something else. But this is the fundamental issue for Canadians. This is the issue of our role in the world, our role in terms of human rights. And it is not something that we can slough off. It's not something we can say because we're going to have a Christmas break that we won't worry about it and everything will be fine. We need to know what the government knew. And again, nothing to do with the performance of our soldiers on the ground. And when I keep hearing that from the other side saying, oh, well, you don't support the soldiers, there isn't a member in this House that doesn't support our troops. But the issue is we don't have confidence in the government ability to provide the truth if, in fact, they're not willing to give us information. We've got two binders of information which is basically useless because, again, it is redacted to the point that nobody could take it seriously. And again, it's not easy to read a line and then this is blocked out, and then a few words later it's blocked out, and a few more is blocked out. I mean, there's pages in there that are completely blacked out. I mean, who are they kidding? Now, when we come to the situation now, the government has denied the request the committee put forth November 25th, which is we want the uncensored documents. That's what you said on November 25th. We said we need to see these documents. Now, there's concern about whether or not this information, in fact, should be in the hands of Parliament. Well, we've heard, in fact, from Rob Walsh, well-respected law clerk, parliamentary counsel, who has written his view. And his view is that Section 38 does not apply, and that, in fact, in this case, we, as parliamentarians, the supremacy of Parliament predominates. And therefore, we should be able, and there are ways clearly for a committee to operate to have, they view sensitive documents, although obviously it's not sensitive to certain journalists who have unfettered access. It's obviously not sensitive for certain members who have come before the committee, certain witnesses who have had access to the full documents, but apparently elected members of Parliament who have a responsibility for oversight cannot be trusted with this information. Now, as a member of the Privy Council, I have that title, which is a very something that I cherish, but unfortunately I don't anymore have ability for this, for access to these documents. But the reality is that either we are serious about this issue, and we are serious about getting to the truth, and we are serious about our international image, and we are serious about human rights, or we're not. And if we're not, then the role of the committee is called into question. Because, you know, we have a parliamentary motion from March 2008 which was extremely clear about the issue of oversight, and particularly on the issue dealing with anything to do with detainees. So this, to me, Madam Speaker, is absolutely fundamental. We have a report from the House of Commons Public Accounts Committee that was recently tabled, I'm sure you're aware, which outlines the constitutional right of Parliament to demand information and how supremacy triumphs all laws. And that, again, in the letter dated December 7th to my colleague, who is our defense critic from Vancouver South, he indicated very clearly that, in fact, it triumphs and that we should have that access. And so, you know, this wasn't something written on the back of an envelope. It was a very detailed letter which outlined what we have. And let me just quote something from that letter. Government's obligation to provide to the committee the information it needs to carry out this function. The law of parliamentary privilege provides that this relationship operates unencumbered by legal constraints that might otherwise seem applicable. And therefore, Madam Speaker, we need to have this information. We need to be able to judge for ourselves. He goes on in this letter to outline the following. Sections 37, 38 of the Canada Evidence Act do not provide that they apply to the House or its committees, and therefore cannot be read as applying to committee proceedings or overriding the committee's exclusive authority with respect to those proceedings. And finally, because if that may not be clear enough on the other side, I know it's clear enough on this side, but if not, let me just add this. In keeping with the principles of responsible government, no part of government's responsibilities can be, by law, be categorically excluded or removed from its constitutional accountability to the House and its committees. Otherwise, it would soon become only partial accountability, and perhaps, after some years, no accountability at all. Now that, to me, Madam Speaker, would be very troublesome. That, in fact, if they were not accountable at all, then the function, certainly of the opposition, and we are very fortunate that in this country we have a very functional, a very lively, and a very probing opposition from all three parties. It's to keep government on its toes. You know, we look at cases in some countries around the world where the opposition is viewed as more of a pain. And I'm sure that members of the government see us as a pain from time to time, but the right of this opposition is to, in fact, keep them on their toes. Now, the right to order the production of documents is a matter of law. That's what we asked
November 25th, we said we want to see these documents unfettered. And Mr. Walsh again says the committee asked for information. It gets it. It gets it. Unfortunately, it's now December the 10th. We don't have that information. The government should be following these rules and must provide the documents that are requested. Now, this is clearly troubling, and we saw this morning a poll that indicates that Canadians are quite troubled. You know, we're not just talking on behalf of ourselves. Canadians get it. Canadians understand the importance of this issue and what it means for Canada internationally. And therefore, at a policy level, responsibility lies with government. It's up to this government to be able to provide the information. I'm sure if my friends on the other side were over here, and I know this for a fact because I have sat over there, that they would be howling. They would be screaming, saying that we are obstructing the ability of a committee to do its work. Well, in fact, they are obstructing. As the government, they know that we do not have the access we need. And obviously, protecting the rights of the detainees was part of that resolution. It's also, in terms of NATO, our international responsibilities say we have to do that. We can't knowingly turn a blind eye. And my great fear, Madam Speaker, is that, in fact, the government wants to turn a blind eye and move on. And really, this is unacceptable. One of the things that we are doing in Afghanistan, either working with the Justice Ministry or the Afghan Human Rights Commission, is to enhance human rights. It's to talk about and see the application of the rule of law. If we are, in fact, no better than the Taliban, then, you know, we are not doing our job. Well, in fact, we are much better. In fact, what we are doing is we are saying to the Afghan government, in order for you to deal with these kind of issues, this is what you need to know, this is how you apply it, and I've seen it for myself when I was in Kandahar and Kabul, the type of in-depth instructions that Afghan police and Afghan soldiers get. And unfortunately, there have been abuses, and this one, even one credible case, which we now have back in June of 2006, means there could be others. But up until the other day, the government said there were none. In fact, they were so clear that they accused us of all sorts of things. Well, the reality is, Madam Speaker, that one is too many, and that obviously is of great concern, and why we therefore need, Madam Speaker, a public inquiry. Only a public inquiry where the judge will get to the bottom of this, because they will have the ability to get all of the information they need in order to conduct it. We saw what happened to the Military Complaints Commission, and we saw Police Commission, and we saw that that has been shut down. We have seen that, in fact, this government has called public inquiries on other things, but on something as fundamental to Canadians, fundamental in terms of human rights, fundamental in terms of the rule of law, the government is stonewalling and saying no. Well, I would suggest after yesterday, there is no more excuses. There are no more deceptions, and there are no more stonewalling. We need it. In fact, we have a resolution that the New Democratic Party put forth that we endorsed as a majority in this House, calling for that. So I would suggest, Madam Speaker, that we will not get the facts as long as this government continues to obstruct, and therefore a public inquiry is needed. It's needed to clear the air, and it's certainly needed for Canadians. Thank you, Madam Speaker.
Questions and comments. The Honourable Member for Renfrew, Pembroke, Nipissing.
Thank you, Madam Speaker. Now, the member opposite referred to an incident that happened in June 2006 under the rules governing transfers of prisoners that was put into place by the former government, his own government. Once this situation, once an indication was that there could be a problem, the new government, the Conservative government, set to work right away to make a more robust set of rules. Indeed, yesterday, the Chief of Defence Staff, upon learning that the situation was different, it took him 3 years to get the truth, he immediately ordered an investigation so that the chain of command would be able to get information that's required far more quickly. So my question is, now that we have the more robust rules in place, we're looking at why it took information to get so long up the chain. What is it that the member opposite hopes to accomplish in making these documents unredacted by the Justice Department public? That is, aside from making public information that may jeopardize the lives of our soldiers.
The honourable member for Richmond Hill.
Well, first of all, Madam Speaker, I'd point out that the original agreement, which was signed back in December of 2005 in the middle of the federal election, was confirmed both by the generals who came before the committee and by David Mulrooney that, in fact, we didn't know exactly what we were getting into. And therefore, when it became clear on the ground that things were worse than we expected, this government decided to enhance the agreement. But obviously there was a problem, because if there wasn't a problem, why would you have to enhance an agreement? So clearly there must have been issues on the ground that led this government to decide we had to have a more robust transfer agreement. That's the first thing. The second thing, Madam Speaker, is that the issue of security on the ground, or national security. They say that we are going to put our troops in jeopardy. Well, in fact, again, both as Mr. Walsh has pointed out and others, there are ways to deal with that so that information does not necessarily have to be out in the public domain. Nobody's suggesting it has to be out of the public domain. What we're suggesting is that as a committee, we need to have information. And that information needs to be here. I'm sure, Madam Speaker, you would know that if there was a public inquiry, that information would be anyways. But we've got reporters that have it. She doesn't seem to be too worried about that. We have generals who reviewed it and others who reviewed it. Apparently that's not a problem. But it is apparently a problem for elected members of Parliament who are supposed to be conducting, based on the resolution which the government supported in March of 2008, to be able to do their job. But there was an enhanced agreement because obviously there were issues on the ground. And the example that we saw yesterday and the comments from Jonathan Tinchuk, I think, underline that and why we need to get to the bottom of it.
Questions and comments. The honourable member for Elmwood-Transcona.
Well, thank you, Madam Speaker. I want to thank the member for an excellent presentation. It's absolutely outrageous that duly elected members of Parliament on this committee cannot get access to these documents when, you know, reporters are getting access. That is just unbelievable. It would happen in a democracy such as this. And as the member said, that there was no credible cases up until yesterday. I think the government was simply hoping and praying that, in fact, the days would go by and they would get through Christmas without having this development of yesterday happening. They've been just trying to hold on, I think, basically involving themselves in crisis control here, trying to hold on for 2 more days so they can get through the Christmas period and into January. I asked earlier a government member as to why members of Parliament were being denied documents and why did the government leak Colvin's memos to the media, and as to why the government continued to obstruct the committee's request for documents. And the member answered everything but. It was basically a filibuster to the question. He nibbled around the edges but never dealt with any part of those 2 questions that I asked him. Would the member like to suggest why that would be?
Honourable member for Richmond Hill.
Thank you, Madam Speaker. I thank my colleague for his comments and question. I think, Madam Speaker, the fact that the government member didn't answer it, I think speaks volumes. The reality is that we know that information is out there in the public domain and that certain individuals have that information. The fact is that when a reporter gets information and writes a story which is favorable, that obviously, in this case, helping the government, if members of Parliament have that information, and again, we're not asking this information for select members of this committee. It's for all members of the committee, both on the government side and our side. If we are going to do the job, we need to have that information. And therefore, I would point out to my colleague then that the reason it's out there is that obviously certain people can be trusted, but apparently we cannot, and that means that we are not able to do the job that we have been entrusted to by Canadians.
The Honourable Parliamentary Secretary to the Minister of Public Safety.
Thank you, Madam Speaker.
I've listened to my colleagues across the floor, both in the House and in committee, rail on and on about documents that they believe that they should have or could have had or might have had and are concerned that they haven't got them. I wonder now, they've been so outspoken about this issue, Madam Speaker, that if the other side now are prepared to release all of the documents from the former government from 2002 until they left office in 2006 to the committee, and so that we can understand. Many of the issues that they've been bringing forward are in reports going back into the 80s, 90s, and the early 2000s, issues that they should have known about. I'd like to know how they made their decision to do very little for our troops.
That makes sense.
Well, a member for Richmond Hill.
Well, first of all, Madam Speaker, we did not do very little for our troops. And in fact, if the member may recall, in 2005, in the budget of the day, we brought in $15 billion, the largest expenditure in Canadian history dealing in peacetime. In peace, now, Madam.
Please, order, please. The member from Richmond Hill has the floor. We'd like to hear his answer.
Thank you, Madam Speaker. We haven't become Zimbabwe yet, Madam Speaker. When somebody asks a question, I would assume that it's only respectful to ask for some silence on the other side so we can give the answer. Otherwise, if the question is of no value, don't ask it. The reality is in 2005, we put $15 billion on the military. We then had, at that time, General Hillier was given the responsibility of dealing with the armed forces and rebuilding it. As you know, we came through a very dark period of $42.5 billion deficit in which we had to make certain choices. And when we had the money, Madam Speaker, we immediately put it to deal with the armed forces, and that, of course, was 2005. Now, the issue of the documents, Madam Speaker, is the fact that on November 25th, the Special Standing Committee asked for documents. They were very clear on what they wanted. That member was there, and the member knows that, again, the government has failed to produce the unedited version that we need. And maybe, whether it's any value or not, we won't know that, will we, unless we see the documents.
Very quick last question, the honourable member for Mississauga South.
Well, Madam Speaker, there's no question that Parliament has the constitutional right to call for persons, papers and records, and that authority is delegated to all our committees under Section 108.1 of the Standing Orders. Madam Speaker, the question for me is maybe just probing as to Mr. Colville had the documents. Did we ask Mr. Colville for the Colvin, and the generals also had the unredacted documents available to them when they testified. Did we ask the generals, and if not, why not? And I guess it's a matter of when the request for the government to provide the documents was issued. The government indicated and the generals had indicated that there was no information in the redacted form that would lead to determining that there was some torture. That appears not to be the case. Cannot the committee ask the government again for the unredacted documents then?
Well, member for Richmond Hill has 30 seconds to respond.
Well, in fact, Madam Speaker, I thank my colleague for the question, and in fact, we have a motion of privilege, in fact, because we have not received these documents. And the reality is, Madam Speaker, that the information that we need has been seen by others, and therefore the motion of privilege is to, in fact, deal with that issue before the House to get a ruling because, again, we cannot do our job if we don't have all of the facts before us.
Resuming debate, the Honourable Minister of Defence. Thank you, Madam Speaker.
To rise and take part in this important debate to discuss an issue that has been widely discussed in this place, in committee, and certainly throughout the country. And I'll be sharing my time, I should indicate, Madam Chair, with the Parliamentary Secretary to the Department of Defence, the Honourable Member from Edmonton Centre. I'm joining in this debate, Madam Chair, Madam President, to state clearly once again that the disclosure of the documents sought, the government information and legal proceedings, and what Canadians would receive is done through a process that falls under the responsibility of the Department of Justice and a process that is independent from politics. We've heard earlier in the day from the Attorney General, the Department of, I should say, the Minister of Justice, and he stated in a very articulate and straightforward way the process in which redactions are done. He clearly indicated it is a nonpartisan, independent public service that, at his department, that makes these determinations. And I want to as well put on the record, Madam Chair, and wish to restate the fact that everyone should understand, Canadians should understand, that the reputation of the military is completely intact. There is nothing that has been done here. There is nothing that would indicate other than the fact that they have acted honorably in conducting themselves on this mission as they have consistently throughout our country's history. Madam Speaker, Canadian men and women, civilian and military, have done an outstanding job. They've been working selflessly, and as we speak, they continue to do so in bringing security and peace and efforts to improve Afghanistan, a country that has been under siege for decades. And they do so at great risk to themselves and to their families. And certainly at this time of year, our thoughts and prayers are with them in that regard. Madam Speaker, while they're putting their lives on the line along with colleagues from other nations, 60 nations, including our NATO partners, they're doing so to help people, to build Afghanistan to a stable society, a democratic country. This is a Herculean task. It's a country where we want to see Afghans one day have a semblance of normal life. That is, to enjoy some of the same rights and privileges that we have, and we are so lucky and fortunate to enjoy in Canada. Stability, education, basic health care, employment, and the prospect of a better future. Madam President, through our whole-of-government mission, the least the government can do is make sure that our dedicated men and women in uniform, along with the many civilians who are there building that country, can do their difficult work as safely as possible. That means providing the right protective equipment, and that's something that our government has prided itself in. We've provided that equipment: tanks, helicopters, UAVs, road clearance materials to detect the deadly improvised explosive devices, or IEDs, that have taken so many lives. I met a young captain on the elevator at the Department of Defense this morning, Madam Speaker, who told me that he and his crew had diffused or disabled over 800 of these devices in the past month. Incredible, heroic work that is being done that has surely saved and preserved life inside Afghanistan. But, Madam Speaker, the Government of Canada has a fundamental obligation to ensure the lives of civilians and Canadian Forces personnel in Afghanistan are not put in further jeopardy, not given an additional risk by somehow releasing information that may be part of operational security or that would somehow affect our relations with our allies, international organizations, or confidential sources that often provide us with information to help prevent or preempt enemy attacks. Madam Speaker, government's primary obligation is to protect and promote the lives of its citizens, including our men and women who are deployed. Special care is also being taken to avoid a situation by a careful review of thousands of documents, pages which might contain information that could be helpful to the enemy. Government should do this with the greatest care, the greatest responsibility. And it is done by officials who are specially trained with an eye to that detail. And it is done independent of the political branch of government. As I've stated before, Madam Speaker, Section 38 of the Canada Evidence Act applies to all proceedings before bodies with the power to compel the production of information where international relations, national defense, or national security interests would be at risk. And we'll continue to provide all legally available information when issues come forward and when documents are asked or requested. And we have produced documents, and we'll do so in accordance with the law. Les dispositions de la comme la loi sur la preuve.
The statutes, such as the Canada Evidence Act, the Access to Information Act, the Privacy Act, the Information Protection Act, that Parliament adopted in order to prevent the public disclosure of sensitive information which may be injurious, are in fact justified. Indeed, this legislation protects our nation's security, the safety of Canadian citizens, and the safety of our representatives as well as members of the Canadian Forces who work in places of high risk in order to uphold our values. It's quite clear that all members will agree how important it is to put in place necessary safeguards, and that is why Parliament recognises this necessity.
Aspects of this understand the importance of such protections. Madam Speaker, to place this argument in a better context, to take it out of the parliamentary and sometimes partisan atmosphere we work in, let me share a quote from the case of Singh versus the Attorney General of Canada. In this case, Mr. Justice Andrew Mackay, no relation, speaking to the federal court, stated, quote, Canada's international relations, in particular relations with our allies, rely on the exchange of information for common benefit. There is a public interest in maintaining the confidence of foreign governments so that Canada's agencies, particularly those concerned with security, will continue to receive timely information from others that may be relevant to Canada's interests. Confidential information, by definition, is information that is passed along in confidence, that it will not be disclosed without permission of the provider or the source. If Canada does not enjoy the confidence of its allies, our international relations and security may well suffer. The public has a very high level of interest in maintaining that confidence. He went on to say, with respect to national security, Mr. Justice McKay, to effectively provide a defence against terrorism and to participate in a global effort to constrain it, it is imperative for Canada to maintain as highly confidential the investigative services and interests of our security services, the sources of their information, the technologies and techniques they employ, the identities of their employers, and particularly their informants. Canada's security agencies must maintain the confidences and the cooperation of foreign agencies that they have shared confidential information with. Our service is in that expectation that it will not be divulged. The public interest served by maintaining security in the national security context is weighty. In the balance of public interest here at play, that interest would only be outweighed by a clear and compelling case for disclosure. Madam Speaker, surely every clear-thinking member of this House, certainly those that have served in Cabinet, even now in opposition, must agree with those sentiments. Another clear example is the case as recent as October of this year, when the Chief Justice of the Federal Court, Justice Alan Lufty, ruled on an access to information request. The applicant sought specific information related to persons detained by Canadian forces in Afghanistan. Their names, identification numbers, operational detail, circumstances of capture, and the like. Chief Justice stated, I quote, I find that the information and issue, including the nature of the operations and the location, date, time, and other circumstances surrounding the capture of detainees, on the record before me, I am satisfied that the disclosure of this information in 2007 could have been of assistance to the enemy of the Canadian forces in Afghanistan, could have caused harm to members of the Canadian forces and others in that country, and could reasonably have been expected to be injurious to the defence of Canada and its allies. Within the meaning of Section 15 of the Act, the determination made in 2007 by the National Defence not to disclose this information was made on reasonable grounds. Madam Speaker, this is impartial advice from our courts. This is additional information that should be recognized and taken into consideration in this debate. As parliamentarians, we must recognize our responsibilities and the necessity of safeguarding sensitive information. And the process under Section 38 of the Evidence Act serves as a useful surrogate to identify information that should not be disclosed. Simply put, there is no mechanism to ensure the protection of information injurious to our national security, national defence, international relations, and information disclosed in the committee context. And so for that reason, this is why, Madam Speaker, we'll continue to follow the process, the laws in place, to ensure first and foremost the security of our men and women in uniform and civilians serving so valiantly in Afghanistan and other places around the world. I would hope that members would take this matter seriously and not pass this motion in the interest of their lives and the lives of their families. Thank you, Madam Chair.
Comments? The honourable member for Vancouver South.
Thank you, Mr. Speaker. I don't believe the Minister was referring to the Parliament seeking information in that last case that he referred to. Must have been an institution or an organisation other than Parliament. Parliament is in a class by itself. Parliament is not an ordinary entity. It is not an entity like any other organisation, and the same concerns can't be expressed about parliamentary committees or Parliament itself. Parliament is absolutely supreme, and Parliament is the body that oversees the work of the government, ultimately. Mr. Speaker, I have a question of the Minister. It's with respect to the redacted field notes that were given to the BC Civil Liberties or other organizations in the specific case that General Natinchik referred to yesterday. And I understand that from those field notes, the information with respect to the detainee being abused and other detainees being abused before, because the now released documents indicate that the field notes refer to as abuse having happened many times before. Can the Minister tell us if General Natinchik can say yesterday that the release of that information would not have harmed the Canadian soldiers or the troops? Can the Minister say now that the reduction was appropriate when it was done?
The Honourable Minister.
Well, I don't know whether the honourable member was in the chamber, but I know he refuses to accept the reality, even having served in cabinet, that it is arm's-length, independent persons within the Attorney General's department that make these redactions. So somehow trying to suggest that it is politicized is simply incorrect, Madam Speaker. But to come back to the fundamental issue at hand as to Parliament's supremacy, clearly the government is going to follow the law. And the law is, as we all know, passed by Parliament. That is Political Science 101. So clearly we are complying with the law, complying, in fact, Madam Speaker, with the law that was enhanced around issues of security by the government of the member opposite. In the wake of 9/11, there were improvements made to the Canada Evidence Act, including Section 38, specifically designed to protect the things that have been the subject of this discussion, that is, protecting confidential information, ensuring operational security, ensuring that we're enabled to protect that information. And as far as the honourable member who's now tweeting outright, orally in the chamber, we know that he has a record of having tweeted in committee. So, you know, it's quite shameful that this member would suggest that information is impeccably protected in committees when he himself is guilty of having leaked information that could have been injurious.
Questions and comments? The honourable member for St. John's East.
Thank you, Mr. Speaker. If we accept what the Defence Minister says, that these redactions are being carried out by independent arm's-length people in the various departments, are we to suggest that they have supremacy over Parliament? Is that what the Minister's suggestion, that independent people have supremacy over Parliament? In fact, the same people who are doing redactions for the documents that go to the MPCC, and their counsel, who are also independent arm's length, are questioning the redactions and say that they are unnecessary. Even a cursory examination suggests that they are unnecessarily broad. And they spend 14 pages detailing why they're going too far in taking things out. Is that the kind of people who we think are, or you're suggesting, are supreme over Parliament itself?
The Honourable Minister of National Defence.
Well, you know, Madam Speaker, even the tone of the honourable member's question is quite offensive. He's now suggesting that those people, those non-partisan public servants who are doing this important work, are somehow unworthy or unable to do this important task. This is exactly what they're trained to do. Now, I know the honourable member and his party don't support the mission. They have a very questionable record of having supported attempts that this government has made to improve the security of our men and women in uniform by giving them the protective equipment they need to do that job. He and his party have consistently voted against that, and he shows such courage here, 12,000 miles from the mission, in the comforts of this place, Madam Speaker. He should take off his comfortable shoes and walk a mile in the soldier's boots outside the wire.
Resuming debate, the Honourable Member for Edmonton Centre.
Well, thank you, Madam Speaker. As will come as no surprise, I cannot support the motion before the House today. Madam Speaker, there are good reasons why the government has taken the measures it has with regard to documents, and that is safety. The safety of our men and women in uniform, their civilian colleagues, other government agencies and departments, as well as the protection of our partners and allies. Unfortunately, Madam Speaker, it may be too easy to demand the provision of written documents as if their disclosure had no impact beyond these chambers. The Canadian Force is working alongside over 60 other nations and international organizations as part of the UN-mandated, NATO-led mission, are playing a leadership role in delivering real results as an integral part of Canada's whole-of-government team in Afghanistan. Madam Speaker, several years ago when our troops first deployed to Afghanistan, we knew there would be many challenges. After all, Afghanistan had suffered decades of war and misrule. The government lacked the capacity to deliver the most basic services. Still today, the insurgency remains ruthless. The Taliban attacks with roadside bombs, vehicle bombs, suicide bombs. They threaten, they intimidate, and the results can be devastating. Sadly, we've paid a heavy price for progress in Afghanistan. To date, Canada has lost 133 selfless men and women in uniform, 1 diplomat, and 2 aid workers. Our injured and fallen come from places like Mill Cove, Montreal, Fredericton, Conception Bay, Thunder Bay, Victoria, Iqaluit, and Edmonton. And they made a substantial difference in places like Panjwai, Daman, Spin-Boldak, Gorak, Kakrez, and Kandahar City. Madam Speaker, they left behind a legacy of hope and confidence for the Afghan people, a legacy held high by our more than 2,800 men and women still serving in theatre. It is their valor, their dedication, and their selflessness that really made a difference. That has established and reinforced the reputation of our Canadian forces as one of the best militaries in the world. We hold them to the highest standards of professional conduct, and through their blood, sweat, and tears, they never let us down. In Afghanistan, they're defending the basic values we all believe in and stand for day in and day out in this very chamber. Things like freedom, democracy, rule of law. Values that generations of Canadians who have proudly worn the maple leaf have fought and died for. Hear, hear. Despite the dangers, the devotion of our men and women in uniform has allowed us to deliver on our pledge to the international community, on our promise to the Afghan people. We are offering them dignity, security, and justice, and a better future. The Canadian Forces are providing essential protection that is fundamental to creating the secure environment necessary for governance, humanitarian development, and the training of a military and police force to occur. And we are partnering with Afghans to do so because it's their country. It has been clear from the start that a well-trained and well-equipped Afghan National Security Force is essential if the Afghan government is to assume increasing responsibility for its own security and development. Thanks to the Canadian Forces, the Afghan National Security Forces are growing. They're growing in confidence, in capacity, and in capability. We have seen some of our greatest success through our operational mentoring and liaison teams. Currently, Canadian men and women in uniform in our omelettes are mentoring 5 Afghan Army battalions and their headquarters. They also have civilian and military police trainers and mentors supporting the Afghan National Police reform. From a fledgling force a few years ago, ill-equipped and lacking proper training, the Afghan National Army has, with the support of the Canadian Forces, matured into a credible force. The progress they've made is impressive. Afghan forces are now conducting more than 2/3 of the combat operations in and around Kandahar City. And, Madam Speaker, progress is empowering Afghans. It is allowing them to move beyond ongoing security concerns, to rebuild their schools, their roads, and their sense of pride in their country. And while progress may appear slow, it is taking hold and touching the lives of Afghans every day.
Exactly.
The ultimate goal is to help create a better governed, more peaceful, and more secure Afghanistan for Afghans, a goal that the Canadian Forces, indeed the entire whole-of-government effort, is helping to make a reality. And that leads me to our responsibility back here at home, Madam Speaker. First, let me say, contrary to a couple of comments across the floor earlier today, this government did not leak any documents to any media. The Government of Canada has an obligation and a moral duty to see that the lives of Canadian Forces personnel in Afghanistan are not put at additional risk by the release of information that may be of an operational security nature. We are required by law to protect sensitive information relating to international relations, national defense, or national security, whether in written or oral form. Madam Speaker, I'm sure you can agree that this isn't about politics. It's about protecting Canadian lives. It's about protecting the lives of our partners and allies. It's about protecting the relationships with our partners in Afghanistan who are so crucial in helping us conduct our mission.
Exactly.
The responsibility of protecting or disclosing sensitive information lies with independent, nonpartisan public servants. It's these public servants who review suggested redactions provided by the respective departments. It is their duty to balance the public interest in disclosure against the public interest in non-disclosure. And there is no political interference in this process. In the end, we're working to preserve hard-won trust and respect of our allies. And we're making sure that good people's lives are not put at additional risk by the potential release of information that may be of a sensitive nature. And Madam Speaker, what if irresponsible actions of this House make us fail in that duty? We need to think about that. Canadian soldiers and civilians, Afghans working for us, some of them in the most perilous situations. Translators, Afghans who translate for us are the most endangered people in the entire country. And you can be sure, Madam Speaker, that al-Qaeda and the Taliban are listening in to what's going on in Canada every single day. They're probably listening in today. They may be murderers and terrorists, but they're not stupid, and they do know how to conduct operations. They are paying attention. And Madam Speaker, if we violate the trust of our own men and women in uniform and our allies and the people who count on us, who is ever going to trust us again? If our Canadian soldiers or people who trust us die because we've divulged information or because we can't get information from organizations like the Red Cross or others to protect them, then I hope that the folks across the way would stand up and take credit for that. Madam Speaker, I know that Canadians understand the great sacrifice and commitment of our forces in Afghanistan, the noble work they do to solidify our vision of Canada that it holds its own on the international stage, and the fact that our armed forces are one of the best and most respected in the world. We have every reason to be proud of the role our troops are playing in routing the insurgency and planting the seeds of development and good governance and the seeds for a positive Afghan future. After all they have sacrificed and achieved for Canada, our brave men and women deserve our continued vigilance so that they can continue to accomplish the goals that we have set for them. Madam Speaker, we're embarking on a very dangerous process today. I spent 31 years in regular force uniform, another 5 years as an honorary colonel, and I can tell you the men and women of the Canadian Forces do know who their friends are in this Parliament, and it is the people on this side of the floor, because I speak to them every day, Madam Speaker. You know, I don't expect any better. I don't expect.
Order, please. Order in the House.
You're not the only game in this town. You never were.
Order, please.
You're not gonna be.
Order, please. I would like to call the House to order.
No, sir. We don't talk like that around here.
I would like to call the House to order.
Not on my watch. No, sir.
The honourable member for Scarborough Rouge River will have to leave the House if he cannot maintain decorum.
I'm not leaving the House.
In the interests of Canadians, in the public interest, I think all members of this House would like to debate facts honourably and respectfully, and I would ask all members to remember that as they speak and as they listen. The honourable Parliamentary Secretary has 2 minutes left.
Thank you, Madam Speaker. All I can do is repeat what people tell me. But, Madam Speaker, we are embarking on a dangerous process here today, one that, if we're not careful, will endanger the lives of Canadian men and women and the lives of people who depend on us for their freedom, people like the people of Afghanistan, the Afghans who have worked with us with great courage to make their country better. We cannot afford to let them down, Madam Speaker, by playing politics in this place. You know, and I don't frankly expect all that much from the two parties further to my right, who I have no doubt have great affection and care for soldiers as individuals, but who have not shown any regard for the institution of the Canadian Forces. I do expect better from the Liberal Party of Canada, because Liberals and Conservatives over the years, throughout history, have, when it comes to the big ticket items of national unity and doing the right thing on the international stage, we have always spoken with the same voice. And that's the voice of freedom, it's a voice of courage, it's a voice of doing the right thing for Canadian men and women here and abroad, and people like the people of Holland. People like the people of Holland in 1944 and 45, who I spent time with this summer, and certainly the people of Afghanistan in that region, who are counting on us, Madam Speaker. I urge members to take the responsibility of those people and our people seriously. Do not pass this motion. It is very dangerous and will harm Canadians and harm our allies.
Questions and comments? The honourable member for Charlottetown.
Thank you, Madam Speaker. Madam Speaker, the member across talked a lot about the the brave men and women that are in Afghanistan, and I agree with what he's saying. But they're there, Madam Speaker, for certain purposes, to protect the values that are near and dear to us, the values such as democracy, our Constitution, the rule of law. And one of the linchpins that's in our Constitution is the right of Parliament, the right of this institution to send for persons, papers and records. And that, Madam Speaker, is as old as Parliament itself. And the Speaker gave a very clear ruling this morning that cannot be lessened or affected by statute law. And that's exactly what that member and the Minister of Defence have been arguing for the last 6 months. Now, we have a legal opinion from the Parliamentary Law Council. We have a second legal opinion. And we also were disclosed this morning that the Department of Justice are of the very same view. So why, my question is to the member of Cross, why, in light of the advice from the Minister of Justice, from the advice of the Speaker, from the advice of our Parliamentary Legal Counsel, why is he continuing to argue that Section...
The Honourable Parliamentary Secretary to the Minister of National Defence.
Madam Speaker, I never mentioned Section 38. What I mentioned was responsibility for doing the right thing to the Canadian men and women, to the people that count on us to do the right thing for them.
Right on.
What I was talking about is responsibility not to divulge information in this House or insist on information being brought to this House, which frankly, Mr. Speaker, would be put at risk by being exposed to as many people and avenues for leakage as it would in this House. We've already seen leakage from committees. We've seen Twittering. Mr. Speaker, it is not in Canada's best interest to have unfettered access to all information in this House. That is simply irresponsible, is dangerous to the Canadian men and women, is dangerous to our allies, is dangerous to Canada's reputation as a strong partner in the world today.
Right.
Where are we at? Are we doing questions and comments? Member for Ottawa Centre is rising on a question or comment.
Yes, thank you, Mr. Speaker. And one of the things that is important is reference is that the Parliament gets all the facts. Earlier, the Parliamentary Secretary, in questions and answers, asked if we were concerned about one of the prisoners being hit by a shoe. We know the evidence that was brought forward by the Chief of Defence Staff yesterday was one of our soldiers was able to save one of the prisoners from going to torture. Now, this evidence was provided by the Chief of Defence Staff. So my question to you, Mr. Speaker, through you, Mr. Speaker, is does the Parliamentary Secretary believe in the evidence that was provided by one of our soldiers about torture, or does he think that the detainee was just being hit by a shoe as if it was some commonplace thing? Does he believe our soldiers, or is he going to believe his own rhetoric?
Honourable Parliamentary Secretary to the Minister of National Defence.
Well, Mr. Speaker, thanks very much, and I thank my honourable colleague for the question. Of course we believe the Chief of the Defence Staff. He speaks with credibility, with integrity. When he gave information to the Defence Committee on Tuesday, he, as it turns out, made an error in that statement. He corrected that yesterday. Of course we believe him. The simple facts are that the one case that he was talking about was, in fact, an Afghan detainee being hit with a shoe by the Afghan National Police. The Canadian Forces did the right thing. They rescued him. They cleaned him up. They turned him over to more reliable people to look after him. So, of course, we believe the military, Mr. Speaker. And the Chief of the National Defence, when he corrects information, we believe him then. He's operating with the best information possible, just as we are, Mr. Speaker, just as we've always done. And every time we've had proper information, Mr. Speaker, we have acted and we have made things better, and we will continue to do that.
You're going to... Order. À l'ordre. Pursuant to order made Monday, December the 7th, 2009, the House will now resolve itself into Committee of the Whole to welcome torchbearers carrying the Olympic flame. Je quitte maintenant l'autel.
I'm now leaving the Speaker's seat to allow the House to become the Committee of the Whole.
À l'ordre. I would like to draw to the attention, order, à l'ordre.
Order.
I'd like to draw to the attention of all honourable members the presence in the gallery of some of our Canadian Olympic and Paralympic champions. I ask members to hold their applause until I have named them all. Order. Alexandra Orlando, Angus Mortimer, James Cartwright, Sarah Boudens, Jason Dunkerley, Chelsea Lariviere, Karen Coburn, Kurt Harnett, Don Jackson, Sue Holloway. Welcome.
Order. It's also my pleasure to announce for the first time in the history of Canada and of the Olympic Games that the Parliament will be hosting in a couple of minutes the Olympic torch. The Olympic torch was lit on the 22nd of October in the ruins in Greece, which was the ancestral place of the Games. The Olympic Stadium in Athens, and the flame was handed over to the organisers in Canada.
Columbia on October the 30th. The Olympic flame has visited many communities across our country. By the end of the relay, it will have covered 45,000 kilometres and touched every Canadian coast and most communities. Today we are proud to welcome the Olympic flame and torch here in the House of Commons. Carrying the Vancouver 2010 Olympic torch is 1948 Samoritz Olympic gold medal figure skating champion, Ms. Barbara Ann Scott. Accompanying Ms. Scott is the attendant to the flame, Ms. Marie Wise, from Snuneymuxw First Nation in Nanaimo, British Columbia, and Mr. John Furlong, Chief Executive Officer for the Vancouver Organizing Committee for the 2010 Olympic and Paralympic Winter Games. I now invite them to enter the House. Ici, la flamme continue.
From here, the Flame and Torch will continue its voyage throughout the country, and on the 12th of February, the Flame will reach the Cyprus Stadium.
I offer the Vancouver Organizing Committee our sincere congratulations in these final weeks before the arrival of the world's finest athletes in British Columbia, and our best wishes to our Canadian athletes for success in the 21st Winter Olympic Games, Canada's Games. Thank you very much for being here. Rise and report. That's all. Order? I thought I had to extend it. Oh, it's not. À l'ordre.
Order.
Today, December 7, 2009, the House will now proceed to statements by members. Déclaration des députés. The Honourable Member for Miramichi.
Thank you, Mr. Speaker. I rise in the House today to pay tribute to Charles and William Delano. 50 years ago, on December 16th, brothers Charles and William Delano of Miramichi, New Brunswick, 2 volunteer firemen, were killed and 2 others were badly injured when an explosion from within a blazing 2-story concrete building sent most of the front wall hurtling down on them. Both brothers had been active volunteer firefighters for 15 years. I wish to take this opportunity to remember the fallen firefighters and to pay tribute to all the firefighters who put their lives on the line. Every Christmas, firefighters across this country encourage people to think about fire safety in their home. May we all have a safe and Merry Christmas. Thank you, Mr. Speaker.
The Honourable Member for York West.
Thank you, Mr. Speaker. Much has been made about the need for a greater degree of physical activity amongst our youth. If we are to fend off higher instances of heart disease and diabetes, doctors know that our children must set aside video games and fatty foods in favour of a healthier, more active lifestyle. In the City of Toronto, ice time availability has become an issue of growing concern. As the popularity of girls' hockey increases, coupled with the already large numbers enrolled in boys and recreational hockey, teams are finding it to be increasingly difficult to get on the ice. Despite the rhetoric espoused by this government, they have not been there for the young players in my city. It has been a generation since a new arena has been built in Toronto, and the population growth has outstripped ice time availability. People are wondering why this Prime Minister saw fit to spend millions on partisan advertising but failed to expand Toronto's arenas.
Exactly.
By continuing to put their own needs ahead of others, this government is skating on very thin ice.
Honourable Député.
The Honourable Member for Louis-Hébert. Mr. Speaker, the Olympic torch, which is a symbol of the Olympic ideal, is on Parliament Hill. It represents peace, fraternity, and light. On this occasion, the Bloc Québécois would like to reassert its support for the many athletes who, through their perseverance, strength, and determination, will take part in the 21st Winter Olympics. We would like also to support many of them who have written to the Prime Minister to ask him to fight climate change in an ambitious and vigorous way. To all those, I wish the best of chances for the Olympic Games at Vancouver. The Honourable Member for Algoma, Manitoulin, Kapuskasing.
Pay tribute to Sharon Sproul,
who is a founding member of the Espanola Little Theatre, which celebrated its 50th anniversary this year. Sharon is a celebrated actress, having won regional, provincial, and international awards for her stage work. She has been a long-serving executive member of the Espanola Little Theatre, Quanta, and was elected to the Theatre Ontario Board. With all her accomplishments, it is little wonder she has been named to the Wall of Fame in Espanola, was a recipient of the Governor-General's 125th Anniversary Commemorative Medal, received the Theatre Ontario Michael Spence Award, was the 1997 Espanola Citizen of the Year Award, and named one of Canada's 100 Remarkable Women by Chatelaine magazine in 2004. It is clear that Espanola and Northern Ontario are richer for Sharon's contributions and that she deserves the many accolades that have come her way.
The Honourable Member for Calgary North East.
Mr. Speaker, I'm proud to stand here to recognize the outstanding achievement of my constituent, Gurpreet Mann of Calgary Northeast. In October 2009, a new Canadian, Mr. Mann, represented Canada in shot put at the World Masters game in Australia as one of 260 Team Canada members. Inspired by his family and friends, Mr. Mann earned a silver medal for Canada after competing with over 20 athletes. Mr. Speaker, on behalf of Shori family, my constituents, and the whole South Asian community, I congratulate Mr. Mann for his remarkable achievement. I also thank Team Canada for being a hard-working and humble inspiration to all Canadians as we prepare for the exciting 2010 Vancouver Olympics. I now invite all members of this House to rise and join me in applauding Gurpreet Mann and Team Canada for their hard work and excellent sportsmanship in representing Canada on the international stage.
Well, the Honourable Member, the Honourable Member for Halifax West.
Mr. Speaker, the Halifax Herald has kept Nova Scotians well informed for generations. This family-owned newspaper has been a champion for our business community and a voice of the people. Recently, Sarah Dennis became president and CEO of the Halifax Herald Limited, and I couldn't think of a better person to fill this position. Sarah's dedication to the paper and to maintaining an independent voice are to be applauded. I wish her and the Herald every success, and I invite colleagues to join me.
The Honourable Member for Fleetwood, Port Kells.
Mr. Speaker, Canadians are getting ready for the Christmas festivities. It's time for generosity, giving and helping the less fortunate. But, Mr. Speaker, the spirit of the season is often bruised by unnecessary political correctness. Attempts are made to ban nativity scenes, holiday trees replace Christmas trees, the 12 days of giving replace 12 days of Christmas, and reference to God, Christ, and the Lord are cast aside, leaving us with just a meaningless, consumer-oriented holiday. Mr. Speaker, I am a Sikh and I'm not offended when Christians celebrate Christmas. Rather, I wish Christians Merry Christmas and they wish me a happy Gurpurb or happy Vaisakhi. Cultural tolerance or ethnic equality should never mean diluting someone's faith. It's time we move from tolerance to acceptance. We should respect each other's beliefs. Let's not deprive Christians of Christianity. Let's all of us celebrate. So Merry Christmas to everyone.
The Honourable Member for Quebec. Mr. Speaker, the Chief of Defence Staff has admitted that there was at least one case of torture of Afghan prisoners, which contravenes the Geneva Convention. But the government continues to deny its responsibility. The government has cut funding for organisms such as Kairos, which intervene directly in the field to promote human rights. The Prime Minister is coming up with more ideological reasons, and these organizations have been promoting democracy and good governance. We in the Bloc Québécois reassert on this International Day of Human Rights our determination to put pressure on the government so that it will restore its credibility here and abroad by respecting its commitments. The Honourable Member for Lévis-Bellechasse. Mr. Speaker, the implementation of the Economic Action Plan by the Conservative government shows just how much we've been taking initiative and listening to concerns of the people in Quebec. Yesterday, we saw once again Bloc Québécois members stand, and yet they went to the barricades and sat on their hands instead of standing up, as the conservative members from Quebec did, to defend the rights of Quebecers. This is why we are acting for businesses and workers hit by the global slump. There are positive, constructive signs. The Canadian economy is rebounding, Mr. Speaker. We are helping in various sectors to help both Canada and Quebec to come out of this stronger than ever. The Honourable Member for Vancouver Quadra.
Across Canada, we're proud to witness the historic occasion of the first ever Olympic flame in the House of Commons. The Olympic flame has a sacred history and symbolizes principles of peace, friendship, and respect. In less than 65 days, visitors from around the world will flock to Vancouver for the experience of a lifetime. After years of hard work by athletes and so many others, Canadians will unite to celebrate sport and excellence at the 2010 Winter Olympic and Paralympic Games. The journey to the Olympics started 12 years ago when the Chrétien Liberal government worked with successive BC governments to design a successful 2010 bid in Games. Congratulations to all who have worked so hard in preparation for this historic event. I particularly salute the courage and dedication of the disabled young people who have worked their way to becoming world-class elite athletes and Paralympians, because they, in the words of Winston Churchill, never, never, never gave up. I encourage every Canadian to attend or to tune into Olympic and Paralympic events and cheer our athletes on. Go for the gold, Canada!
The Honourable Member for Oxford. Sorry.
It was this Conservative government that took action to preserve Canada's share of the North American auto industry. We provided $700 million to the Accounts Receivable Insurance Program for auto parts suppliers, $250 million to the Automotive Innovation Fund for Research and Development, and $12 billion to Canadian Secured Credit Facility to improve credit access for consumers to purchase and lease new vehicles.
Fantastic.
Mr. Speaker, because of these actions, we see a bright future for the auto industry. Stats Canada tells us that 52,000 jobs have been saved as a direct result of our efforts. Well, Mr. Speaker, add another 800 jobs to that total. Today, Toyota announced they will hire 800 workers at the company's automotive assembly plant today in Woodstock. A major shot in the arm to Woodstock and a boost to my riding of Oxford. Mr. Speaker, I invite this House to join me in applauding the efforts of our government and the Minister of Industry in supporting Canada's auto industry.
Well done.
The Honourable Member for Acadie Bathurst. Mr. Speaker, I would like to pay tribute to a great man who died December 6th, Ed Levert. Mr. Levert arrived in Bathurst from Sudbury in 1966, and he set up the union at the Nigadoo mine. He's always cared about the labour movement and was a union representative for the steel workers. He worked to establish safety standards and compensation for workplace accidents. He became the advocate for people who'd been hurt at work. Until quite recently, Mr. Levert was the president of the New Brunswick Seniors Council, which fought to defend their interests. I had the opportunity to work with Mr. Levert when he worked at when we both worked at the Brunswick mine. He was greatly admired. On behalf of the NDP and on my own behalf, I would like to offer my most sincere condolences to his wife Jackie and to their children.
For Abbotsford.
Mr. Speaker, last night the Liberal leader's unelected senators gave drug dealers an early Christmas present. Canadians were shocked to learn that Liberal senators have gutted a bill which imposes tougher sentences on criminals who operate marijuana grow-ops and who sell drugs to our children. In doing so, these Liberals defied the will of this democratically elected House. What's just as shocking is that NDP MPs had earlier voted to oppose any tougher sentences on the most dangerous and violent drug dealers in the country. Mr. Speaker, Canadians have been demanding stiffer prison sentences for those who sell drugs to our children and who use violence while profiting from drug crime. Yet the Liberal leader refuses to listen. We have called upon him to control his senators, but he refuses to act. Mr. Speaker, yet again, the Liberals have showed that they can't be trusted to protect Canadians, and yet again, the Liberal leader has shown that he isn't in it for Canadians. He's just in it for himself.
The Honourable Member for Gatineau. Mr. Speaker, yesterday in committee, the Conservatives and the NDP showed what recognition of the Quebec nation means to them. Absolutely nothing. One big zero, in effect. The Conservatives and the NDP refused that the National Capital Commission consult the Government of Quebec in setting up a plan for the National Capital Region, leaving all of this to non-elected people. They refused to recognize the prerogative of the Quebec government in taking care of its own territory. They refused to recognize that the Quebec nation has the right to choose what is good for it. Nevertheless, on several occasions, Quebec has criticized the methods in which the NCC intervenes in the Outaouais without consulting and in a closed-door process. Just like the Conservatives, the NDP has shown us that recognition of the Quebec nation is for them nothing but an empty shell. Honourable Member for Moncton. Moncton Riverview Dieppe. Mr. Speaker, today on December 10th is the Day of Human Rights. All human beings are born free and are equal in dignity and rights. These famous words established 60 years ago the fundamental importance of human rights.
Every one of us can make a difference, Mr. Speaker, like our leader who introduced Bill C-471 and said that equal pay for work of equal value is a basic human right that should never be subject to negotiation.
Mr. Speaker, we have to unite to end discrimination.
Are in it for all Canadians and in it to end discrimination.
Honourable Member for South Surrey, White Rock, Cloverdale. Order.
Mr. Speaker, in 2009, our government set out a bold economic action plan to help combat the global downturn. This spurred infrastructure projects across the country. We reduced taxes on families and businesses and implemented measures such as the home renovation tax credit and the first-time home buyers tax credit. And we did all this while the Liberal leader hoped the economy would get worse. But we shouldn't be surprised. This was the trend all year long. We worked for Canadians while the Liberal leader worked for an unnecessary election. We improved infrastructure while the Liberal leader complained about signs. We got tough on crime while the Liberal leader hid behind his senators. And we stood up for the Canadian Armed Forces while the Liberal leader politicized their mission and fundraised off their backs. Mr. Speaker, the lesson in 2009 is clear. The Liberal leader is simply not in it for Canadians.
Order. Oral questions. Questions orales.
Oral questions.
Leader of the Opposition.
Mr. Speaker, for over a year, there were credible reports on torture in Afghanistan, and this government didn't do a thing. It was a year of voluntary blindness, if you will, and the Prime Minister was responsible. When will he act in a responsible fashion, and why is he still refusing to launch an independent public judicial inquiry on this matter, the Right Honourable Prime Minister? Mr. Speaker, it's quite clear that the Canadian Forces and the Department of Foreign Affairs took the necessary steps 4 years ago, 3 years ago, and 2.5 years ago. The Department of Foreign Affairs negotiated a new agreement with the Afghan government. The Honourable Leader of the Opposition.
Monsieur le Président.
Mr. Speaker, when they covered things up, they hid evidence, they intimidated and bullied witnesses, they sullied the reputations of officials, they censored documents. Even today in the House, the government tried to prevent Parliament from debating this issue. The Prime Minister is responsible for this behaviour. What does he have to hide? The Right Honourable Prime Minister. Mr. Speaker, on the contrary, if the Leader of the Opposition has no evidence of his allegations against the Canadian Forces, he should admit it, Mr. Speaker. The Honourable Leader of the Opposition.
There are no allegations against Canadian Forces. It's the conduct of this government that's in question. The government has withheld evidence. It has intimidated witnesses. It's censored documents. This morning they even tried to prevent Parliament from debating the issue. The Prime Minister is responsible for this conduct. He's responsible for a year of willful blindness. What does he have to hide?
The Right Honourable Prime Minister.
Once again, Mr. Speaker, the reason, of course, the Leader of the Opposition says that he doesn't point the finger, he now tries to say he doesn't point the finger at the Canadian Forces or diplomats, is, of course, Mr. Speaker, because they have always respected their obligations. Mr. Speaker, these people have been operating in extremely difficult conditions in Afghanistan. Whenever, Mr. Speaker, they've been faced with difficulties, they've taken the appropriate action. Systems have been changed 2, 3, 4 years ago, Mr. Speaker. This issue has long since been dealt with.
The Honourable Member for Vancouver South.
Speaker, the government can't claim that it only just learned about the specific incident of detainee abuse from General Natinchik yesterday. Colonel Noonan's affidavit of 2007, General Deschamps' testimony under oath of 2008 were both in the public domain, while the government chose to ignore them and stymied the work of the Military Police Complaints Commission. Now that we know that detainee abuse actually took place not just once but many times as per the field notes, will this government now provide the committee with uncensored documents and call a public inquiry forthwith?
The Honourable Minister of National Defence.
Speaker, I think it's clear to everyone, including the member opposite, that General Natinchik acted properly by correcting a certain point yesterday, as the Canadian Forces have on each and every occasion. When there's been credible evidence, we've acted. Our diplomats, our soldiers continue to perform marvelously in a theatre in a difficult operation, Mr. Speaker. This government stands foursquare behind them. I ask the member opposite to do the same.
The Honourable Member for Vancouver South.
Mr. Speaker, hiding behind the uniform of brave men and women is the last refuge of any, and I would not use that word. Mr. Speaker, the government is not the sole protector of national security. Parliament can protect the national interest as well, if not better. The Parliamentary Law Clerk and the Department of Justice have stated that Section 38 of Canada Evidence Act does not apply to parliamentary proceedings. Will the government now produce the uncensored documents and will do the right thing by Canadian troops and by Canadians and call a public inquiry?
The Honourable Minister of Justice. Order.
The Honourable Member hasn't been listening to the arguments and hasn't been looking at the advice that's been provided. I can tell you, Mr. Speaker, that one of the experts that we have quoted and we're relying on is Professor Joseph Mangal. When discussing parliamentary privilege, he says, by convention, a parliamentary committee will respect Crown privilege when invoked, at least in relation to matters of national and public security. What's so difficult about that to understand for the Honourable Member?
The Honourable Member for Laurier-Sainte-Marie. Order. Mr. Speaker, in a report written by a commander who was in Afghanistan in June 2006, it states that photographs were taken of detainees before handing them over to the Afghan authorities in order to have evidence of mistreatment because, and I quote the report, it has happened in the past, unquote. How can we trust a defence minister who has covered up the truth and gone to great lengths to hide the facts? The fact that Canada handed over prisoners knowing full well that they would be tortured. What is the Prime Minister waiting for? Why doesn't he demand for his minister's resignation? The Right Honourable Prime Minister. Mr. Speaker, this incident has been known for some time, Mr. Speaker. It was a case of the Canadian Forces taking action to prevent the abuse of a prisoner. It's quite clear that the Canadian Forces are living up to their responsibilities. The Honourable Member for Laurier-Sainte-Marie. Mr. Speaker, they say one incident, and yet the report said that it has happened in the past. They told us that it was known for quite some time, and yet on Tuesday they said the very opposite in the House. You have to have some nerve to say that kind of thing. The Prime Minister is making a mockery of the public, of the military, and of this House, Mr. Speaker. It doesn't make sense. The Minister has been asked questions for months, and he didn't even have the intelligence to ask questions, to investigate this. Not credible, Mr. Speaker. He needs to shoulder his responsibilities and be worthy of his position. The Right Honourable Prime Minister. Order, please. Mr. Speaker, in fact, the Canadian Forces did not take part in abuse or authorise abuse or support any case of abuse. On the contrary, it was a clear case of the Canadian Forces intervening in order to prevent the abuse of a detainee. That is how the Canadian Forces work, and we're very proud of our Canadian Forces. The Honourable Member for Saint-Jean. Order. Mr. Speaker, from the beginning, ministers and high-ranking army officers rebutted our questions by stating that there was not a single case of torture of a prisoner handed over to the Afghan authorities by Canada that was proven. Thanks to a report which mysteriously reappeared this week, we know that this was not true. The Chief of Defence Staff has launched an inquiry in order to determine what occurred. Doesn't the Prime Minister believe that a public inquiry would be preferable to an internal inquiry conducted by the Army, with the Army being both judge and defendant? The Honourable Minister of National Defence.
As everyone knows, the Chief of Defence Staff brought forward information that clarified this issue yesterday, and members, including the member opposite, have indicated that they accept the General's word, they accept him to be an honourable person. I'm surprised, quite frankly, and it's quite perverse to suggest that he wouldn't support the military process to look into this issue. That, again, really portrays something quite obvious, Mr. Speaker. We support the forces, their success, and the success of our country. He can't say the same.
The Honourable Minister for Saint-Jean. Mr. Speaker, the Defence Minister recognised that the Afghan authorities engaged in torture, but not of prisoners handed over by Canada. We now know that that's not true. At least one prisoner handed over to the Canadian Forces was indeed tortured in 2006. The Minister has lost all credibility and is clearly trying to cover something up. Will the Prime Minister demand his resignation and open a public inquiry immediately? The Honourable Minister of National Defence.
Speaker, that the member speaks of yesterday was clarified by the Chief of the Defence Staff. He and the members of the Canadian Forces, from the highest ranks to those on the ground in Afghanistan, continue to distinguish our country, Mr. Speaker. Their incredible work is something we applaud. We certainly think of them this time of year as everyone gets prepared to spend time with their families, Mr. Speaker. This incident, of course, it demonstrates again the professionalism, the hard work, and the accomplishments of the Canadian Forces. In each and every occasion, Mr. Speaker, they act with the highest integrity.
The Honourable Member for Toronto Danforth.
Mr. Speaker, it's high time that this government take action with respect to the scandal of the transfer of detainees. We have an international reputation which is being hurt right now, and some sections of the Geneva Convention are being flouted. Light must be shed on this matter, and it must be done here. Otherwise, others will follow suit. If they have nothing to hide, why doesn't this government launch an inquiry immediately? The Right Honourable Prime Minister. Mr. Speaker, the facts are clear in this matter. The Canadian Forces and the Department of Foreign Affairs have met their international obligations, Mr. Speaker. They reacted appropriately in a difficult situation, and Mr. Speaker, there was a new agreement entered into with the Afghan government 2.5 years ago. The Honourable Member for Toronto Danforth.
Canadians Canadians are tired of this nonsense. They believe Richard Colvin. And the Chief of Defence Staff vindicated him when he spoke of that 2006 report, which the government officials thought was important enough that they turned it over to Amnesty International 2 years ago, Mr. Speaker. But the minister didn't care. He didn't read it. He didn't even want to act. It's time for this government to call for to take the step that's required, and that's to ask the minister to step down and start the inquiry independently.
Right Honourable Prime Minister. Order.
Well, of course, once again, by his own admission, Mr. Speaker, the leader of the NDP speaks of facts that have been on the public record for a couple of years. And what do those facts indicate? Those facts indicate, Mr. Speaker, that the Canadian Forces, when faced with a case of abuse, took immediate action to deal with that. Mr. Speaker, that should hardly be used as a reason to attack the forces, should be used as a reason to praise them.
The Honourable Member. The Honourable Member for Toronto, Danforth.
You know, Mr. Speaker, the Prime Minister must know that it's Human Rights Day today, and these types of answers and denials and cover-ups don't look good on Canada. In fact, what's worse, on this 61st anniversary of the Universal Declaration of Human Rights, our government has refused to sign. It says it's tough on crime, but it's looking soft on torture right now because it won't ratify the United Nations optional protocol against torture. Why won't this government stand up against torture and ratify the UN declaration against it?
The Right Honourable Prime Minister.
Mr. Speaker, of course, these matters are under review, but the leader of the NDP should know, Mr. Speaker, that the facts are absolutely clear, and he knows what those facts are, and he should stop distorting those facts. Members of the Canadian Forces, the Canadian Department of Foreign Affairs, have conducted themselves with extraordinary valor in a very difficult situation in Afghanistan. Whenever faced with difficult situations, they have responded and taken corrective action, and they should be praised for those actions.
The Honourable Member for Notre-Dame-de-Grâce-la-Chine. Mr. Speaker, the Minister has repeated that no allegation of mistreatment has been proven, and yet the report published yesterday indicates that the Canadian Forces, and I quote, photographed the individual before handing him over to ensure, in the case where the Afghan police did assault him, as it happened in the past, they would have visual evidence of the mistreatment. How many cases of mistreatment has the member hidden and tried to push under the rug? The Honourable Minister of National Defence.
The Chief of Defence Staff has clarified the issue and once again demonstrating the professionalism of our forces from top to bottom through the ranks. But more than that, Mr. Speaker, over 2.5 years ago we improved upon the failed arrangement in place left by the government opposite. We then went on, of course, to increase monitoring and mentoring within the prison system, working with police, with prison guards, investing in the physical infrastructure of Afghan jails, Mr. Speaker. Those are concrete actions. Those are demonstrations of actions, Mr. Speaker, that have made a real difference in Afghanistan. And again, a real lasting legacy of our...
Honourable Member for Notre-Dame-de-Grâce-la-Chine. Mr. Speaker, the Minister of Defence said, and I quote, the truth is that there was no credible evidence allowing us to confirm that a prisoner was tortured, and yet the evidence shows that since 2006 our soldiers took photos of the detainees because they knew that the Afghan police had tortured or mistreated prisoners in the past. How many of these cases of mistreatment or torture has the government covered up? When will there be a public inquiry so that we can at last learn the truth in this matter? The Honourable Minister of National Defence.
She's talking about normal procedures carried out by the professional and very capable members of the Canadian Forces in the field. And what they continue to do, Mr. Speaker, is work hard to mentor, to train, to leave a lasting legacy, Mr. Speaker, that will serve that country and, in fact, enhance our country's reputation. Of course, Mr. Speaker, this particular instance, this mission is something that has been difficult, has been challenging, but great strides have been made to improve their justice system, their human rights. That has been done on the backs, the hard work, the blood, sweat and tears and sacrifice of the Canadian Forces and our diplomatic corps.
The Honourable Member for Ajax Pickering.
The Defence Minister, November 23rd, quote, "There has never been a single proven allegation of abuse involving a prisoner transferred by Canadian forces. Not one," end quote. In one question period alone, the Minister repeated this line no less than 5 times. There was no ambiguity, no uncertainty, just an unqualified statement dismissing disturbing allegations of torture, a statement we now know was false. Why did the Defence Minister fail to ensure he was speaking the truth before answering in this House? Why was it left to the Chief of Defence Staff to uncover this Minister's falsehood?
The Honourable Minister of National Defence. Order.
Well, Mr. Speaker, at 9:30, when the Chief of Defence Staff called to share this new information with me, Mr. Speaker, that is, of course, what happened, and we accept his version of the truth, Mr. Speaker. I and members of the government act on information received from our military, from our professional public service. Mr. Speaker, we continue to act on their advice. We continue to work with them to carry out our important work in Afghanistan, and great progress is being made, improving their human rights, improving their jail system through monitoring and mentoring, Mr. Speaker. We've made great strides, of course, also improving upon the failed record of the member and his government.
The Honourable Member for Ajax Pickering.
There was nothing new about this information. The Chief of Defence Staff asked questions, dug, sought out the facts, and then did the honourable thing. He told the Canadian public the truth. His integrity, our soldiers' integrity, is not in question. This minister's is. This minister stated a falsehood, stated it with certainty, asked no questions, and made no apologies for misleading this House or Canadians. Was the minister incompetent or dishonest? Why didn't he ask questions to fight and get the truth? When will he stop using our troops as a shield, take responsibility, and resign?
The Honourable Minister of National Defence. Order.
Speaker, as I've said now a number of times, when the Chief of Defence Staff called a press conference to correct the record yesterday, he did so with the utmost integrity and honour, as he always would, as members of the Canadian Forces have, in carrying out their duties. Anytime there's been credible evidence, Mr. Speaker, they've acted as they did in this instance, as they did on other occasions. We have great faith and confidence in them, Mr. Speaker, and the honourable member may want to play politics with this issue, may want to, by implication, smear the Canadian Forces. We're not going to do that, Mr. Speaker. We're going to continue to support them, give them the resources they need, and back them 100%.
The Honourable Member for La Pointe. Order. The Honourable Member for La Pointe de Lille. Mr. Speaker, the Defence Minister has attempted to play down the government's involvement in the torture of Afghan prisoners by saying that he did not intentionally put them in a situation where they'd be tortured. And yet, the Geneva Convention is unambiguous. Canada has an obligation to ensure that prisoners handed over to Afghan authorities are not at risk of torture. Any other action would constitute a war crime. Doesn't the Prime Minister believe it is time to dismiss his Minister of Defence, a minister refusing the Honourable Minister of National Defence?
Our diplomats, our professional military on the ground in Afghanistan and on 18 other missions continue to distinguish themselves by their hard work, their integrity, as, by the way, do the military leadership and members of the professional public service who testified before a parliamentary committee, all of whom confirmed the government's position, and that was that we acted appropriately. We took the information that they gave us to make the right decisions, Mr. Speaker. In each and every instance, the Canadian Forces have done the right thing, as they did in the case in question. We continue to support them. We want to see them succeed. We want to see our country to succeed. I wish the honourable member shared that sentiment.
The Honourable Member for La Pointe de Lille. Mr. Speaker, many law professors believe that the current government could be found guilty of war crimes. According to Errol Mendes from the University of Ottawa, quote, "The law is clear. Listen, the law is clear. When there is a substantial risk of torture, there is an absolute obligation to stop the transfer of prisoners." We got evidence yesterday that the government knew since 2006 that prisoners handed over to the Afghan authorities risk being tortured. Don't these serious accusations warrant a public inquiry? The Honourable Minister of National Defence. Order.
Block member referring to the star NDP candidate who's accused people like Rick Hillier of being guilty of war crimes in the past. He pulled the same stunt, Mr. Speaker, back in 2007, a PR stunt. This is Michael Byers, who only a month ago was advocating a new coalition between the Liberals and the NDP. Apparently, this is the same kind of coalition and the same kind of systemic attack that we've seen in the past against our men and women in uniform. Mr. Speaker, we won't stand for it. We'll stand up for our men and women in uniform, support them all the way. I invite her to do the same thing.
Order, please. The Honourable Member.
Joliette.
The Honourable Member for Joliette, Mr. Speaker. It's a responsibility of the Minister and the governments that we're talking about, not the people in Afghanistan. Abraham Lincoln said you can fool all the people some of the time, but you can't fool all the people all of the time. And that's exactly what's been happening with the Conservatives, who through cover-up and falsehoods have got caught up in the versions of torture in Afghanistan that nobody believes. Would the Prime Minister show a minimum of respect to the people, to the service people and their families in this House, and immediately call for an independent public inquiry? The Honourable, the Minister of National Defence.
I might want to check that quote. I think it was P.T. Burnham that said it, Mr. Speaker. But I'll tell you what Honest Abe did do. He tried to unify a nation. He tried to bring people together during a time of war, Mr. Speaker. That's what great Canadians do. They get behind their forces, they back them, they give them the necessary resources, they give them the necessary support that they need when they're doing difficult work, Mr. Speaker. The Honourable Member continues to play cheap politics, continues to use wedge politics, Mr. Speaker. We'll support our forces. We'll see our country succeed, Mr. Speaker, with no help from him.
The Honourable Member for... Order, please. The Honourable Member for Joliette. The Prime Minister and the Minister are about as credible on torture in Afghanistan as Richard Nixon was with respect to Watergate. In fact, we're seeing the same political approach: information control, cover-up, defamation. Would the Prime Minister not have the decency to put his version of the facts to the test by calling an independent commission of public inquiry at once? The Honourable Minister of National Defence.
Just look at the facts again, Mr. Speaker. When we inherited this mission, we discovered very quickly there was a need for a change. There was a need to invest in resources, to give the Canadian Forces the tools they needed to do the job, as well as the need, Mr. Speaker, to improve their justice system. That meant investing in their system, in mentoring, in having more monitoring. All of that was enabled by a new enhanced transfer arrangement, which our government did, Mr. Speaker. We took that responsibility, recognized the important improvements and changes that had to occur, and as a result, things are better in Afghanistan today, Mr. Speaker. 3 years later, things are looking much better as a result of this government's action.
The Honourable Member for Random, Buren St. George's.
Mr. Speaker, yesterday when General Natinchuk honorably stepped forward to correct the record, he said, and I quote, "If this is the information I'm finding out this morning at 9 a.m. on the 9th of December, what else is there?" End of quote. Mr. Speaker, the General recognizes that something is not right. Why won't the government follow the General's lead and appoint a public inquiry rather than stonewalling and censoring everything in sight?
The Honourable Minister of National Defence.
Well, more of the same implicit contradictions, Mr. Speaker. Wash me, but don't make me wet. We want to support the military. We want to suggest somehow that we take the word of the General, and yet the General said at the same press conference, we're going to have a military board of investigation to find out about this information. We're going to follow up through the military to see what happened. So the Honourable Member should take a look at what the General said, the entire part of his press conference where he talked about how we'll get to the bottom of it, and in the meantime recognize the improvements that have been made, recognize the failures of her government and the improvements we've made in the mission on this side of the House.
Honourable Member for Random, Buren St. George's.
Mr. Speaker, before yesterday, there was already overwhelming evidence that a Canadian transfer detainee had been abused. There were photographs before and after. There were notes from a soldier on the ground. There were notes from a medic discussing the injuries. Officials knew that abuse was systemic. That is why the photos were taken. This information has been available to the government since 2006, and they failed to act for over a year. Will the government make the arresting officer, the medic, Colonel Noonan, and General Deschamps available to Parliament so Canadians can get the truth?
The Honourable Minister of National Defence.
course, once again, Mr. Speaker, she leaves out the important fact that the Chief of Defence Staff didn't have that information, but when he did, passed it on to us. And as always, we act on the information available to us. We act on the information given to us by diplomats. And when we do, we're able to make important improvements, as we did with the transfer arrangement, as we did with issues related to the prisons and human rights. We made important changes, Mr. Speaker, that improved upon the failed record of her government, improved upon the inadequate arrangement, Mr. Speaker. We made important changes, investments in mentoring and training, making things better, Mr. Speaker. That's what our diplomats and soldiers do. She adds nothing to this file.
The honourable member for Hull Aylmer. Order, please, Mr. Speaker. The revelations by General Natichuk yesterday are incontestable. Yes, detainees transferred to Afghan authorities were tortured. The question has been asked to the Conservative for years. After all the questions in this House, it was only yesterday that a little bit of light was shed on the matter. If this isn't an operation to hide the truth from Canadians, what is it then? Is it crass incompetence on the part of the Minister? Minister of National Defence.
No, that all of the witnesses that we've heard, with one exception, have testified on their version of what was happening in Afghanistan at the time, because they were closest to the mission. Of course, these were top generals and bureaucrats who were in charge of this mission. Mr. Speaker, we received that information through that prism. So the honourable member and most of the opposition continually suggest that they can accept that testimony and that evidence, but somehow suggest that the government should have come to different conclusions. So, Mr. Speaker, I would ask the honourable member to somehow try to square that circle, figure out that this is the information that we acted upon. And, Mr. Speaker, when we took over this mission in 2006, there were many things that were wanting. We made positive improvements.
The honourable member for Hull Aylmer. Mr. Speaker, the document that was made public yesterday by General Natichuk contained a very important element, but nothing new. In November 2007, that document was included in a binder of 1,200 pages presented in the federal court by National Defence. At that time, the date of the document was redacted, as well as the sections concerning bad treatment of detainees. This is perhaps new for General Natichuk, but it wasn't clearly new for the government. Why are they hiding the truth? The Honourable the Minister of National Defence.
Defence, Mr. Speaker, I of course rely on the advice of our senior generals, of our leaders in the military, as I did in the previous department, Mr. Speaker. And so we'll continue to work with the people that we trust, those closest to the mission, those with the most knowledge, those with the most ability to give us good advice. And we'll continue to do that, Mr. Speaker. But the members, by implication, suggesting somehow that the military did something wrong, that somehow they didn't do the right thing, is what is so despicable, Mr. Speaker. I asked them to slip out of their comfy shoes and pull on some combat boots and walk outside the wire with some of those men and women.
The honourable member for Brant.
Mr. Speaker, our Conservative government introduced Canada's Economic Action Plan to respond to the global economic crisis. Our plan is stimulating the economy, creating jobs, and helping businesses weather the economic storm. In November, Canada created nearly 80,000 jobs. Today, we have more good news coming from Toyota. Can the Minister of Finance please tell Canadians how our commitment to a low-tax business environment is helping create jobs for Canadians?
The Honourable Minister of Finance. Order.
Thank you. I thank the Honourable Member for Brant for the question about the economy. Mr. Speaker, today Toyota announced that they will hire 800 workers at their automotive assembly plant in Woodstock, Ontario. This is great news. It shows how competitive Canada's and Ontario's economy is. Our Economic Action Plan is supporting our manufacturing sector with lower business taxes that are creating jobs for Canadians. In fact, by 2012, Canada will have one of the lowest overall tax rates on new business investment in the G7. Our government will continue to seize the opportunities that will ensure Canada's economic recovery and Canada emerges from the recession stronger than ever.
The honourable member for Edmonton. Order. The honourable member for Edmonton, Strathcona. Order. There we go.
Mr. Speaker, a peer-reviewed report in the oil sands emissions just published in the Proceedings of the National Academy of Sciences
shows oil sands operations are emitting today and have been emitting for decades levels of contaminants, putting the Athabasca watershed and its fisheries at serious risk. They found levels of airborne toxins equal to a major oil spill each year. The finding raises serious questions about the government's long-term failure to regulate the impacts of this industry. Will the government commit to undertake an immediate, fulsome investigation and timely response? Canadians...
The Honourable Parliamentary Secretary to the Minister of the Environment.
Well, Mr. Speaker, I wish she would be honest with Canadians. The fact is that Canada emits 2% of greenhouse gas emissions globally. The tar sands, the oil sands, produce approximately 4% of the total GHGs in Canada. The transportation sector, on the other hand, 27%. And that's why this government released features of the draft regulation report, Mr. Speaker, on vehicles. Our challenge is to be a clean superpower, and that includes clean oil, clean vehicles, clean energy, clean technology.
The Honourable Member for Thunder Bay Superior North.
Mr. Speaker, scientist David Schindler has recently confirmed that pollution from the tar sands is out of control. Tar sands pollution is hurting our climate and the health of Canadians. This government continues to turn a blind eye to the industry's toxic pollution and the damage that it causes. Mr. Speaker, is it not time for this government to halt its reckless expansion of further tar sands development until it can control the environmental and health aspects?
The Honourable Parliamentary Secretary to the Minister of the Environment.
Mr. Speaker, the reality is the NDP would have Canadians lose their jobs, Mr. Speaker. They're opposed to the oil sands, Mr. Speaker. Our plan is clear, 20% reduction by 2020. Mr. Speaker, Canada and the United States is working together on a North American continental harmonized approach. Mr. Speaker, we go to Copenhagen, we want an agreement. It's in our interest to have an agreement, and we're prepared to accept our fair share. Why will the opposition not support a real plan, Mr. Speaker, on climate change?
The Honourable Member for HoC. Mr. Speaker, according to the Canadian West Foundation, if the government were to impose the same GHG reduction targets on Alberta as the other provinces in Quebec, Canada would be going through a unity crisis. These words echo the words of the Minister of the Environment and the oil companies who ask for a privileged status for Alberta and polluters. Doesn't the Prime Minister find it strange that the so-called Canadian unity can accommodate the interests of Alberta and the oil companies to the detriment of the economic interests and the environmental interests of Quebec? The Parliamentary Secretary to the Minister of the Environment.
The reality is this government has worked with the provinces, the territories, our international partners. Right now, Mr. Speaker, we're in Copenhagen working hard for a new international agreement on climate change. Why would the opposition members want to have Canada lose its jobs, Mr. Speaker? We're standing with a balanced approach, 20% reduction by 2020, Mr. Speaker. It's a realistic plan, Mr. Speaker. We're getting it done in the environment. Why would they oppose a good plan on the environment?
The Honourable Member for HoC. Well, the reality is that the members of the Conservative Party who come from Alberta don't hesitate to line up behind the government of Alberta. So why do the Conservative members who come from Quebec, that group of yes men, why do they not stand up when it's time to defend the interests of Quebec? The Honourable Parliamentary Secretary to the Minister of the Environment. Order, please.
Members got it all wrong. It's this government that stands for all provinces, Mr. Speaker. All Canadians, Mr. Speaker. We're the ones that are working on the environment, Mr. Speaker. Mr. Speaker, we need support from every member of this House. What's good for Canada? What's good for the planet? What's going to make a difference? It's our plan, Mr. Speaker, 20% reduction by 2020 and harmonization with the United States. They need to get on board and do something, Mr. Speaker.
The Honourable Member. Order. The Honourable Member for Dartmouth, Paul Harbour. Order.
Speaker, last week it was reported that the Finance Minister will make not-for-profit groups pay for his Conservative deficit. Kairos was only the first example. Kairos, an organization whose mission statement is Canadian churches working together for justice and peace. Mr. Speaker, those who were poor before the Conservative recession are worse off now, and now he wants them to pay for the Conservative deficit.
Shame.
Canadians helping those in need are heroes. and they do so with scarce resources and much faith. They should not be further victimized. What does this government have against the poor and our churches, and who's next on the hit list?
The Honourable Minister of International Cooperation.
Thank you, Mr. Speaker. Mr. Speaker, our government recognizes that Canadians are very generous and compassionate, but they also are very responsible people. That's why they want to make sure that the money that we put into the micronutrient initiative is going to save millions of children's lives. The money we put into food aid last week is going to help feed 17 million people. The money that we've committed to agriculture will help these people feed themselves. Mr. Speaker, the money we put into medical aid and counseling to women who are the victims of rape and sexual violence, that's how they want to see their money spent.
The Honourable Member for Dartmouth, Cole Harbour.
Mr. Speaker, even when they inherited a Liberal surplus, this government cut those in need. Literacy, women's groups, the core challenges. Now with a Conservative deficit, they again target the vulnerable, just like the Finance Minister did as part of the Mike Harris gang in Ontario. We have communities without clean water, women suffering from abuse, people with disabilities living in poverty, families that can't feed their children, and people living in the streets of our country. And we have a government that spends millions of dollars promoting themselves and making videos of the Prime Minister. Why should the poor have to pay for that? Is this even Canada anymore?
The Honourable Minister of Finance.
You know, part of the Economic Action Plan is the Working Income Tax Benefit. The acronym is WITBE, easy to remember. This is a tremendous program. It is the most important social program change in the tax system for lower income Canadians since the introduction of the RSP. This is an important tax change. What it means is that more Canadians who have been on social assistance are incented to work and help to work and get to keep more of that money. That's an important advance that helps real Canadians work in the environment in Canada. Thank you, Edward.
The Honourable Member for Windsor West.
Mr. Speaker, while the constituents in my riding and Canadians across this country are suffering under the recession, the Globe and Mail is reporting that the CEOs of Canada's 6 largest banks are pocketing $8.3 billion in bonuses. Mr. Speaker, this comes less than 1 year after this government propped the banks up with $75 billion. In the United States and the United Kingdom, the governments are taking this on and restricting executive pay. Why won't this government do the same?
The Honourable Minister of Finance.
Mr. Speaker, let's be clear. We have what is seen around the world as the soundest banking system in the world. This is not the United Kingdom. This is not the United States. We did not have to bail out banks. We did not have to nationalize banks. We did not have to use taxpayers' money to bail out banks in Canada. That's why we have the reputation around the world of having one of the soundest financial systems. Now, the G20 has guidelines, Mr. Speaker. There are the Financial Stability Board guidelines. I've written to the financial institutions requesting their compliance. If there is not compliance, there will be consequences in Canada.
The Honourable Member,
The Honourable Member for Acadie-Bathurst. Thank you, Mr. Speaker. I think the Minister of Finance needs a short course in math. $8.33 billion can support 101,000 families with children, 192,000 families, single-parent families, 293,000 elderly living alone. 293,000 older people could live with the bonuses paid to the 6 major banks. What is the Minister of Finance waiting for to follow the leadership of Great Britain and legislate against these excessive bonuses? The Honourable Minister of Finance.
The government of the United Kingdom had to bail out banks. In fact, it had to nationalize banks. On the contrary, we have one of the best financial systems in the world, not only in our banking system, but in our insurance system. This is something Canadians can be proud of, that we weathered the recession, that we are recovering with a strong system of financial institutions who employ tens and tens of thousands of Canadians. In fact, building our financial institutions up is good for the country. It's good for employment, high-paying jobs.
The Honourable Member for Winnipeg South. Order.
Drug
production, and drug trafficking is without a doubt the most significant source of illicit money for organized crime groups. Despite this fact, Liberal senators yesterday voted to gut our drug bill, which aims to disrupt gangs. Liberal amendments not only weaken this bill, they create a two-tier justice system with Aboriginals on the losing end. Exempting Aboriginals from jail time makes them a target for drug dealers who know they'll be back on the streets sooner than non-Aboriginals. Police organizations from across this country have begun speaking out about the Liberal Senate amendments and the damage they'll cause to our streets. Can the Minister of Justice say why this is such an important bill for Canadians?
The Honourable Minister of Justice.
Mr. Speaker, yesterday was a bad day for Canadians worried about drug crime. But it was a good day for people involved with the grow-op business, Mr. Speaker, because they received an early Christmas present from the Liberals in the Senate. The Liberals think that people trafficking in up to 200 marijuana plants should not face mandatory jail time. Canadians disagree, Mr. Speaker. I've been calling on the Liberal leaders to show some leadership on this. They have no trouble fighting among themselves. How about fighting crime for a change? Would that be so bad?
The honourable member for Markham Union Bill. Order.
Mr. Speaker, someone once said, and I quote, "Key social programs such as public pensions are outdated." He also said, quote, "There's no real reason for government to run it." What was he talking about? The Canada Pension Plan. Who said it? The Prime Minister said it. Is the Prime Minister's laissez-faire, I don't care attitude about pensions the real reason why the Finance Minister cannot commit to a national supplemental CPP?
The Honourable Minister of Finance.
We've done a great deal of work on the question of pensions this year. We brought in the changes just about a month ago now. Province of Ontario brought in some changes yesterday. The finance ministers are meeting later on next week at Whitehorse. We're going to spend about half of our time at least talking about pensions. We commissioned the work, the research work by Professor Mintz and his group. Other work has been done by the provinces of Alberta and British Columbia and Ontario and Nova Scotia as well. So we'll be meeting next week, reviewing that, focusing on what might be done with respect to improving retirement income in Canada.
The Honourable Member for Laurentides-Labelle. Mr. Speaker, another Canadian mining business, Blackfire, has been blamed for odious behavior that has been perpetrated in Mexico. It's being accused of contaminating rivers, of destroying livestock and crops, and the local authorities also suspect the business of being linked to the assassination of a militant environmentalist. When is the government going to put in place a legal framework which will make Canadian businesses abroad accountable, as has been asked for by the Bloc Québécois for years now? The Honourable the Minister of International Trade. Mr. Speaker, now there are more than 8,000 sites through the world where you can find Canadian companies in the mining industry. And, Mr. Speaker, we have a process that is established to deal with the regulations that must be followed by the mining companies. And also, Mr. Speaker, we have an advisor who is available to advise those companies.
For Churchill.
Mr. Speaker, residential school survivors struggle every day with the agonizing trauma from their experience. The Minister knows that the Aboriginal Healing Foundation has been critical in providing the support in terms of counselling to the survivors and their families. In my riding alone, 18 projects in 17 communities depend on this money. Since healing is a key part of reconciliation, will this government commit to supporting the Aboriginal Healing Foundation and its programs beyond the March 2010 cutoff?
The Honourable Minister of Indian Affairs and Northern Development.
Mr. Speaker, I do share the, I think, broad support for the Aboriginal Healing Foundation. As the member knows, that was part of the Indian residential school settlement, that 5-year segment, at which time, as part of that court-ordered settlement, Mr. Speaker, the government is to work with the Healing Foundation to do a review of the efficacy of the program, to see what what improvements could be made. Make sure it's getting the job done, Mr. Speaker. That evaluation is taking place, and Mr. Speaker, it will be, when that evaluation is done, of course, there's within the agreement, it will be posted on our website, and Mr. Speaker, as of right now, the evaluation hasn't been completed, but as soon as it is, I'll be sure to get it to her.
Honourable Member for Nanaimo, Alberni.
Mr. Speaker, just 10 months into our 2-year economic action plan, we've already committed 97% of the funding. This adds up to 12,000 projects across the country. 8,000 have already begun. All across the country, from coast to coast, projects are up and running. Jobs are being created, and Canadians are seeing the benefit. I'd like to ask the Minister of Transport and Infrastructure to advise this House about an important project that was announced just this morning in British Columbia.
The Honourable Minister of Transport.
Mr. Speaker, once again, this government has been delivering for the people of British Columbia. This morning, with the province, we announced $25 million for the construction of a new ferry terminal in Clemtu, British Columbia. This work will start immediately. It's a great project in the riding of Skeena-Bulky Valley. It's one that's going to create jobs and hope and opportunity and improve the lives of the First Nations community who live there. Step by step, Mr. Speaker, we are delivering for British Columbia like no other government has in Canadian history.
Order. That will conclude question period for today, but I want to remind honourable members that they have received an invitation to a reception in room 253D, which starts now, where they will be able to meet the Olympic athletes introduced earlier. Tous les députés seront les bienvenus. I also wish to inform the House that because of the proceedings in Committee of the Whole, government orders will be extended by 7 minutes. The Honourable Member for Wascana is rising to ask his Thursday question.
Yes, Mr. Speaker, it being Thursday, I wonder if the government House Leader could explain his business plan for the rest of today and tomorrow, and what his expectations might be for the weekend and next week.
Honourable Government House Leader.
Well, thank you very much, Mr. Speaker. Mr. Speaker, today we will continue with the business of supply. Tomorrow, it's my intention to call Bill C-56, the Fairness for the Self-Employed Act, which, as you know, Mr. Speaker, is at third reading. It's crucial, Mr. Speaker, that we pass C-56 before we rise for the Christmas break, because to qualify for benefits, Canada's self-employed must have paid premiums for a year beforehand. Officials in the department need the green light from Parliament to begin preparing for the January 1st implementation. We cannot start notifying people until the bill receives royal assent, Mr. Speaker. As you know, this bill is supported by 3 of the 4 parties in our House, and when there's that much support, as you've seen, anything can happen. We will put that support to the test tomorrow, Mr. Speaker, when the government will propose to dispose of the final stage of C-56. The support from the Liberals and the NDP, of course, in this minority parliament are key, and I hope that their support does not evaporate overnight. This is our one chance to get this job done, and I assure you, Mr. Speaker, the government will have every available body here tomorrow to vote in order to get the Fairness for the Self-Employed Act into law before we break, to ensure that the self-employed benefit from these important and popular measures, Mr. Speaker. And while I'm on my feet, I'd like to take this opportunity that following the rise of Parliament, whenever that was to happen, I would like to wish Merry Christmas to all my colleagues on both sides of the House.
I'll thank the Government House Leader on behalf of all honourable members for his good wishes. The Honourable Member for Winnipeg North is rising on a point of order.
Thank you, Mr. Speaker. Yes, Mr. Speaker, I have a motion for which I believe you will find that there is unanimous consent if you seek it. It is on this day, United Nations Human Rights Day, and the day when the Olympic torch entered this chamber, that I would like to move, seconded by the Honourable Member from Charleswood St. James, Assiniboia, that this House calls upon the government to ratify the Convention on the Rights of Persons with Disabilities, which was tabled in the House on Thursday, December the 3rd, 2009, as soon as all provinces and territories have officially given their consent, and that this House expresses the hope that ratification is achieved by the time of the Paralympic Games.
Here, here.
Does the honourable member for Winnipeg North have the unanimous consent of the House to propose this motion? Yes. Agreed? La Chambre l'a entendu.
The House has heard the motion. Is it the pleasure of the House to adopt it?
D'accord?
Agreed. I declare the motion adopted.
Now, while I'm on my feet, je suis maintenant prêt à rendre.
I am now prepared to give my ruling on the question of privilege raised on November 30th, 2009 by the Honourable Member for Windsor-Tecumseh concerning the inability of the Standing Committee on Justice and Human Rights to obtain documents requested from the head of Correctional Service of Canada in advance of the committee's clause-by-clause consideration of Bill C-36, an act to amend the Criminal Code, as is described in the 14th report of the committee, which was presented to the House on November 26, 2009.
For Windsor-Tecumseh for having raised this matter, and I'd also like to thank the member for Abitibi-Temiskaming, the member for Mississauga South, the government House leader, the member for Notre-Dame-de-Grâce-la-Chine, as well as the Minister for Public Safety for their interventions. Dans son intervention,
in presenting his case, the member for Windsor-Tecumseh gave a detailed account of his attempts to ascertain whether the information which a witness, Mr. Don Head of Correctional Service of Canada, had committed to provide to the committee prior to its clause-by-clause consideration of Bill C-36 on November 16th, had indeed been provided.
The sole source of this information had been prepared in a timely manner and forwarded to the Office of the Minister of Public Safety. It was not until November 23, 2009, the day that Bill C-36 was considered at third reading in the House, that the member for Windsor-Tecumseh received an undated copy of a letter containing the information in question. The rest of the committee received a dated version of the same letter on November the 25th, 2009, the day after the House finished the third reading debate on the bill. In alleging interference by the Minister's office, either through incompetence or deliberate intent, the honourable member questioned the role of ministers in supplying information to committees and concluded that his work as a member of Parliament had been impeded. L'honorable député
This argument was supported by the Honourable Member for Abitibi-Temiskaming, the Honourable Member for Mississauga South, and the Honourable Member for Notre-Dame-de-Grâce-la-Chine.
2009, the Minister of Public Safety rose in the House to apologize unreservedly for the unwarranted delay caused by his office in transmitting the requested information from Mr. Head to the committee. Pursuant to Standing Order 108-1A, it is a well-established and unequivocal power of all committees of the House to order the production of papers and records. Page 978, House of Commons Procedure and Practice, second edition, describes this as a broad absolute power. End of quote. And at page 979 it states, aucune loi ou pratique.
No statute or practice diminishes the fullness of that power rooted in House privileges unless there is an explicit legal provision to that effect, or unless the House adopts a specific resolution limiting the power. The House has never set a limit on its power to order the production of papers and records.
End of quote. His attempt to obtain information is unsuccessful. There are essentially three options available. As outlined on page 980 of O'Brien and Bosk, and I quote, the first is to accept the reasons and conditions put forward to justify the refusal. The second is to seek an acceptable compromise with the author or the authority responsible for access to the record. The third option is to reject the reasons given for denying access to the record and uphold the order to produce the entire record. Fin de citation. C'est donc aux membres.
Accordingly, it is then incumbent upon committee members to avail themselves of these options, which are designed specifically to ensure that a committee's power to secure information is not circumvented.
And it is the view of the Chair that the honourable member for Windsor-Tecumseh could have proposed a motion to have the committee report to the House the fact that the information requested had not been received and request that the House compel the production of that information. House of Commons Procedure and Practice, second edition, sets out this process when it notes on pages 980 to 981, je cite,
and I quote, since committees do not have the disciplinary power to sanction failure to comply with their order to produce records, they can choose to report the situation to the House and request that appropriate measures be taken. Among the options available to the House is to endorse, with or without amendment, the committee's order to produce records, thus making it a House order. End of quote.
To follow this prescribed course of action, the honourable member is asking the House to do that which the committee itself was required to do to remedy this situation. The Chair must note that the committee in question did not come back to the House to request an order of the House to produce specific papers. As with all claims pertaining to a breach of privilege, the standard which must be demonstrated is whether the member has been impeded in the fulfilment of his or her duties and functions by some action or omission.
As outlined in the 14th report of the Standing Committee on Justice and Human Rights, in the submission of the member for Windsor-Tecumseh and through the admission of the Minister of Public Safety, there is no denying that the information failed to reach the committee within the specified time. However, it is equally clear that the proceedings on the bill were nonetheless able to continue with members' full participation.
Neither the committee nor the House appeared to share the view of the honourable member that they needed the requested information in order to complete their deliberations on the bill. I cannot find that a prima facie case exists in this matter. So in this case, I'll dismiss the matter, but I thank the House for their attention to this ruling. Now, I believe the Honourable Parliamentary Secretary of the Government House Leader is rising on a point of order.
Thank you, Mr. Speaker. Mr. Speaker, I rise on a point of order regarding Bill C-471, Pay Equity Task Force Recommendations Act, on the grounds that it requires a royal recommendation. Mr. Speaker, let me first say that, as you know, normally royal recommendation interventions are made before first hour of debate, which occurred on this bill last night. However, Mr. Speaker, after a request from the Liberal Party, who had an event of some importance last night, we delayed that so we would not unduly delay the members opposite from attending their most important event. But, Mr. Speaker, let me make my intervention now. Bill C-471 proposes to do two things. First, it imposes on the government a duty to implement the recommendations of the 2004 Pay Equity Task Force report and sets deadlines by which this must be done. As noted in Clause 2 of the bill, this includes establishing, quote, all statutory oversight agencies. The second component of Bill C-471 is to immediately repeal the Public Sector Equitable Compensation Act, which was passed by this Parliament 9 months ago in March 2009. I have objections to both of these components and will address them in turn. Turning to the first component, subsection 2.1 of the bill imposes an imperative duty on the government to, quote, implement the recommendations of the Pay Equity Task Force set out in its final report, end quote. Mr. Speaker, I have considerable concerns with this provision. While a sponsoring member may attempt to argue that Bill C-471 is similar to the Kyoto Protocol Implementation Act or the Kelowna Accord Implementation Act, which you ruled in order in the last Parliament, there is significant distinction. In your ruling on September 27, 2006 regarding Bill C-288, you stated, and I quote, in a ruling earlier this week on a similar matter, namely C-292, an act to implement the Kelowna Accord, the Chair made a distinction between a bill asking the House to approve certain objectives and a bill asking the House to approve the measures to achieve certain objectives. So too in the case before us, the adoption of a bill calling on the government to implement the Kyoto Protocol might place an obligation on the government to take measures necessary to meet the goals set out in the protocol, but the Chair cannot speculate on what those measures may be. In the case of Bill C-471, the measures are set out in detail in the 113 recommendations of the Task Force report, which is referenced in this bill. The recommendation is that, quote, Parliament enact new standalone proactive pay equity legislation. The other 112 recommendations describe the measures that should be included in that legislation. As a result, this bill raises grave concerns. It places an impossible duty on the Crown of implementing the recommendations, which can only be done by passage of legislation. It seeks to bind this or a subsequent Parliament to pass this new legislation, which I submit would unconstitutionally undermine the fundamental principle of parliamentary sovereignty. It would fundamentally alter the relationship between the Crown and the Parliament, and that is the heart of the financial initiative. As you aptly quoted in your February 24, 2005 ruling, Mr. Speaker, suffice it to say that those relations are neatly summed up in the phrase, quote, the government proposes and Parliament disposes, end of quote. Bill C-471 clearly turns that relationship on its head by both proposing and disposing the measures and purposes for which public monies should be spent. This is made even more apparent, Mr. Speaker, by subsection 2, sub 2 of the bill. This provision sets the deadline by which the government must implement the Task Force recommendations. In particular, Mr. Speaker, it states, quote, the Government of Canada shall ensure that all statutory oversight agencies are put in place no later than January 1, 2011. This provision of the bill also distinguishes it from Bill C-288 and Bill C-292, considered in the last Parliament. Neither of those bills dictated the establishment of new institutions, much less as part of its express terms. Based on the Task Force report, the duty in subsection 2, sub 2 entails the new creation of 2 new statutory agencies as well as a new system of adjudicators. Assuming Bill C-471 is constitutional and the government is bound by its terms, it has no choice but to establish these new bodies. And it is trite to say that such a measure would require the expenditure of new funds to a new purpose. For example, the Speaker's ruling of September 19, 2006 concluded that the creation of an advisory committee requires a royal recommendation, since this clearly would require the expenditure of public funds in a manner not currently authorized. For this reason, Bill C-471 requires a royal recommendation to be in order. Now, Mr. Speaker, the second component of Bill C-471 also clearly demonstrates that a royal recommendation is required. As mentioned at the beginning of my remarks, Mr. Speaker, Bill C-471 at Clause 3 repeals in its entirety the Public Sector Equitable Compensation Act. This repeal would take immediate effect if this bill were to be given royal assent. The nature of this provision is completely different from anything that was in Bill C-288 and Bill C-292 from the last Parliament. To fully understand why it has an impact on the financial initiative of the crowd, it is first necessary to understand the purpose of the PSECA. The purpose of this act, put simply, was to remove jurisdiction over public sector pay equity complaints from the Canadian Human Rights Act and to create a new statutory scheme for dealing with public sector pay equity issues proactively. By the same token, Mr. Speaker, the PSECA removed jurisdiction for dealing with public sector pay equity complaints from the Canadian Human Rights Commission and the Canadian Human Rights Tribunal. Complaints that arise out of the PSECA process are instead dealt with by the Public Service Labour Relations Board. The grounds for those complaints are defined in the PSECA. This is underscored in the PSECA's consequential amendment to the Canadian Human Rights Act, which states, quote, the Commission does not have jurisdiction to deal with complaints made against an employer within the meaning of the Public Sector Equitable Compensation Act related to the pay equity provisions of the Canadian Human Rights Act. The effect then, Mr. Speaker, of Clause 3 of Bill C-471 is to reverse all of that. This has 2 distinct impacts. First, it gives jurisdiction over public sector employers to the Canadian Human Rights Commission and Tribunal, which jurisdiction was expressly removed in the PSECA. And second, it subjects public service employers, that is, the Crown as employer, to liability for new statutory grounds of complaint under the Canadian Human Rights Act. Both of these impacts infringe on the financial initiative of the Crown. In the second edition of House of Commons Procedure and Practice, O'Brien and Bost state a fundamental principle of the royal recommendation at pages 833 to 834. An appropriation accompanied by a royal recommendation, though it can be reduced, can neither be increased nor redirected without a new recommendation. A royal recommendation not only fixes the allowable charge, but also its objects, purposes, conditions, and qualifications. For this reason, a royal recommendation is required not only in the case where money is being appropriated, but also in the case where the authorization to spend for a specific purpose is significantly altered. Without a royal recommendation, a bill that either increases the amount of an appropriation or extends its objects, purposes, conditions, and qualifications is inadmissible on the grounds it infringes on the Crown's financial initiative. Mr. Speaker, this principle is reflected in your ruling of February 11, 2008, in which you held that Bill C-474 required a royal recommendation because it proposed to substantially alter the mandate of the Commissioner of the Environment and Sustainable Development. The same principle applies to the bill before you today, Mr. Speaker. The object of the Public Service Equitable Compensation Act was to fundamentally change the structure, process, and jurisdiction for dealing with public sector pay equity issues from what existed before the passage of the Act. A royal recommendation accompanied the Budget Implementation Bill, which included the PSECA. Accordingly, Mr. Speaker, repealing the PSECA and giving the Canadian Human Rights Commission and Tribunal a jurisdiction over public sector pay equity complaints is essentially a fundamentally new and altered purpose for those organizations. No royal recommendation accompanies that change in Bill C-471. The royal recommendation that accompanied the PSECA cannot be redirected to the Canadian Human Rights Commission and Tribunal, and past appropriations for the Canadian Human Rights Commission and Tribunal cannot be used for a purpose and jurisdiction that Parliament expressly removed it from the PSECA. On that ground alone, Mr. Speaker, Bill C-471 infringes on the Crown's financial initiative. In addition, Mr. Speaker, the bill infringes on the financial initiative on the basis that it exposes the Crown to a distinct liability that would be paid by public monies. As stated in Erskine May, Parliamentary Practice, 21st edition on page 714, and again I quote, "Any proposal whereby the Crown would incur a liability or a contingent liability payable out of money to be voted by Parliament requires the Queen's recommendation," end quote. In this vein, Mr. Speaker, a June 12, 1973 Speaker's ruling held that a royal recommendation was required for Bill S5, an act to amend the Farm Improvement Loans Act. The Speaker noted, and again I quote, "It may be said that the proposal in Bill C5 does not in itself propose a direct expenditure. It does, however, propose substantial additional liabilities on public monies," end quote. Similarly, on May 5, 2009, ruling from the Speaker of the other place ruled that Bill S219 out of order because it would change the Crown's liability under the Canada Student Loan Act. As held in that ruling, the passage of Bill S219 would expand the range of conditions under which the government would have to make good its guarantees of loans under the Canada Student Loans Act. This would change the existing scheme, since payments from the Consolidated Revenue Fund might increase due to the change in possible obligations. As such, the bill would have, or should have, a royal recommendation and would have to originate in the other place. This is also consistent, Mr. Speaker, with your ruling on February 12, 1988 regarding Bill S4, an act to amend the Shipping Act. In that case, Mr. Speaker, you found that increases to the limits of civil liability of ship owners did not require a royal recommendation because the payment was covered by the authorization in Section 30 of the Crown Liability and Proceedings Act. That act, and my correction, Mr. Speaker, if you weren't here in '88, you've been here for so long, Mr. Speaker, I think you've been here forever. Again, and that is a compliment, Mr. Speaker, and please take it as such. Mr. Speaker, that act essentially provides that the Crown can be civilly liable in court for breaches of what is known in the common law tradition as tort or property law. Crown liability for breaches of the law of civil salvage is also expressly provided under Section 5. Section 30 provides judgments issued by a court against the Crown are authorized to be paid. The case of Bill C-471 is clearly distinguishable from Bill S-4 in that it creates a new and distinct statutory liability for the Crown under the Canadian Human Rights Act. The Crown Liability and Proceedings Act does not authorize payments for new statutory liabilities of the Crown. In fact, Section 33 states, "Except as otherwise expressly provided in this Act, nothing in this Act affects any rule of evidence or any presumption relating to the extent to which the Crown is bound by an Act of Parliament." Bill C-471 creates a new and distinct statutory charge of the Crown's liability. The more adversarial, quasi-judicial setting of the human rights regime is fundamentally different from the proactive and integrated approach of the PSECA. Under the PSECA, pay equity obligations are integrated in the bargaining process, subject to complaint on certain grounds to the Public Service Labour Relations Board. In contrast, under the Canadian Human Rights Act, liability is initiated by individual complaints adjudicated before an administrative tribunal and, potentially, results in awards for damages. The authority for awarding those damages is the Canadian Human Rights Act. As you may recall, Mr. Speaker, through the previous complaints-based process under the Canadian Human Rights Act, the government has paid out of public monies multi-billion-dollar judgments. The Crown's obligations are significantly different under the PSECA, and a royal recommendation is required to change that. Before concluding, Mr. Speaker, and I know you wish me to conclude quickly. I would like to address a point that may arise during your study of this bill. As we know, the Public Service Equitable Compensation Act has been passed by Parliament, but it has not been proclaimed into force. Like many other statutes, Parliament delegates to the Governor in Council the authority to determine the day on which the Act comes into force. This transitional period, as one of the terms under which Parliament has passed the law, allows the Executive time to prepare for the effective implementation of provisions. For purposes of assessing the need for a royal recommendation for Bill 471, it does not matter whether or not the legislation has been proclaimed into force. It suffices that the law has been passed by both houses of Parliament and that it has received royal assent. What is and should be most critical and salient is Parliament's decision to make law. In the 21st edition of Erskine-May, in formulating the test for whether a change is new and distinct, or whether a charge, Mr. Speaker, is new and distinct, it is stated at page 712, the question may arise whether a proposal for expenditure or for increased expenditure is not already covered by some general authorization. The test for determining this question in the case of a substantive proposal that a provision is in a bill as introduced is a comparison with existing law. In this case, the Public Service Equitable Compensation Act was passed by Parliament on March 12, 2009. It forms part of the Statutes of Canada. It reflects the will of Parliament. It will be implemented under the terms passed by Parliament because that is what the law directs. As Erskine-May puts it, it forms part of the existing law, and this is the law against which the provisions of Bill C-471 must be compared. To look at it another way, Mr. Speaker, there would be no purpose for Clause 3 of Bill C-471 but to change the law. It follows that in this instance, it also changes the purposes and conditions for which this House has authorized expenditures. For that reason, it requires a royal recommendation. Mr. Speaker, in closing, while Bill C-471 is a short bill, it has significant consequences, and there are multiple reasons for which it requires a royal recommendation to be in order. I shall also add, Mr. Speaker, that the member from Lakeshore Etobicoke, the sponsor of Bill C-471, has said that he believes Bill C-471 would result in some additional unspecified costs for the government. In other words, Mr. Speaker, the Leader of the Official Opposition, who is a sponsor of this bill, agrees that in his own bill it requires a royal recommendation. Thank you for your patience in this matter, Mr. Speaker.
The honourable member for Eglinton Lawrence is rising on the same point of order.
Yes, Mr. Speaker. Clearly, we've just listened to another specious argument by the government side against pay equity. And I think he's beginning to engage in debate of the bill itself with his last comment. If, of course, we don't have pay equity, even though the law is there, it's because they've not taken the measures to implement it. However, we as the official opposition will refer our position on this in due course, Mr. Speaker.
Okay. Well, I thank the Honourable Parliamentary Secretary and the Honourable Member. I look forward to further submissions on the matter, and we'll take it under advisement accordingly. I don't sense a particular urgency in coming up with a ruling on this, so we might not hear until January sometime. Well, I might, but I don't think so. Now, and I know the Honourable Parliamentary Secretary would want me to take time to give due consideration to every argument he's advanced, and they were lengthy. The Honourable Member for Buren, Random Buren St. George's is rising on another point of order.
Thank you, Mr. Speaker. I'm rising today because I take my responsibilities here in the House of Commons seriously, and I do sincerely think I have a contribution to make to the debate in the House. So I can't begin to tell you how disappointed I was when I'm told, and I didn't hear this, that the Minister of National Defence, in response to my second question to him today, suggested that she adds nothing to the debate. Now, Mr. Speaker, for that to come from the Minister of National Defence, a Minister of the Crown, is truly disappointing, and it begs the question of his attitude toward women. I know that there have been other circumstances where this minister has had to apologize for saying things that weren't proper of a female member in this House of Commons. And it was some time ago, and at that point in time, the remarks were alleged that he had said about another woman in this House of Commons. And he did subsequently apologize, even though I think the ruling at the time was that the remarks that he was alleged to have made could not be heard on the tape. But I think, Mr. Speaker, that if you were to listen to the tape, and I'm told that it was very clear that he did say, in response to my question to him in his concluding remarks, that she adds nothing to the debate. Now, Mr. Speaker, for me it's a serious issue, as I think it is for all women who serve this country, no matter what profession. But when you have that kind of attitude being displayed toward another colleague in the House of Commons, whether it be male or female, but in this instance, to have the Minister of National Defence, in response to a very serious question that I put to him on a very serious matter that is taking place in this House of Commons with respect to the Afghan detainee issue, that I really question the attitude of the government, if this is a pattern of this government or if it's just of this minister in particular. But, Mr. Speaker, I'm rising on the point of order. I would like to have an apology from the minister. I think he needs to show some respect in the House of Commons toward his colleagues, and in this case toward a woman colleague who has every right to make a contribution in this House of Commons as he does.
The Honourable Parliamentary Secretary to the Government House Leader.
Yes, Mr. Speaker. Mr. Speaker, in response to my honourable colleague's intervention requiring an apology, I mean, to suggest that the Minister of National Defence is sexist in any way is outrageous. Mr. Speaker, we sit here day after day after day, and as you know, Mr. Speaker, adjudicating this debate every day, that the comments coming from the members opposite when the Minister of National Defence gets to his feet are absolutely outrageous. And yet this member has the gall, the unmitigated gall, to stand up here with her feelings hurt, suggesting that the Minister of National Defence is in some way, some fashion, some manner, accusing her of something that she considers to be sexist. I mean, Mr. Speaker, this is unbelievable to me. Absurd. To finally have an opportunity to speak firsthand with the member opposite on a debate, and this is a debate, Mr. Speaker, it's certainly not a legitimate point of order, when she considers the Minister of National Defence to be sexist. It is something that she should apologize for, not the Minister of National Defence, Mr. Speaker.
Ridiculous. Is the Honourable Member rising on the same point of order? Then I'll also hear from the Honourable Member for Nanaimo, Alberni.
Well, Mr. Speaker, I was in the House when the alleged remark was made, and I recognize that the member is new in the House here, and I think the fact that her feelings are hurt because somebody disagreed with her comments is probably more reflective of the nature of the comment from the minister. And I think she should recognize, once she's been here a little longer, that what was said was purely a response to her remarks and had no other innuendo attached to it.
Well, the Honourable Member for Mississauga South on the same point.
Yes, thank you, Mr. Speaker. I was also in the chamber when the member, the Minister of Defence, made the comment, and it was quite clearly a dismissive remark that the member has nothing to offer to the debate. And Mr. Speaker, as you know, in our standing orders, I believe it's Standing Order 18. If I may, that no member shall speak disrespectfully of the sovereign or of any member of the royal family or governor general or person administering the government, nor use any offensive words against either house or against any member thereof. No matter may reflect upon a vote, etc. Mr. Speaker, this section in our standing orders, I'm advised, has been unchanged in its wording since Confederation, and I would just suggest to you, Mr. Speaker, that its interpretation that the House has always looked at is a matter of whether or not it's respectful. And the comment of the Minister of Defence certainly was not respectful of this honourable Member of Parliament.
I'm not going to hear more on this. I'll look into the matter and come back to the House in due course. I thought everything in question period that I could hear, given the noise. I didn't think there was anything that was said that was out of order, but I'll look into the matter and come back to the House in due course. Orders of the day. Ordre du jour.
Government orders. Business of supply. Resuming debate on an opposition motion concerning documents regarding Afghan detainees and an amendment. Resuming debate.
Squamalt Wandafuka.
Thank you very much, Mr. Speaker. And this particular debate is
is especially important to my constituents of Esquimalt-Juan-de-Fuca because I serve the men and women and their families who are at Canadian Forces Base Esquimalt and who, to a person, do a remarkable job, one that as Canadians we are deeply indebted to and for their work. The detainee issue, Mr. Speaker, and I trust I have 20 minutes. Is that right, Mr. Speaker? Mr. Speaker, 20 minutes? Thank you very much. What I'm going to do, Mr. Speaker, is use the detainee issue as an insight for our public to examine the way in which the government, this Conservative government, has been operating since they came into power. Ways and utilizing tools that the Canadian public is not aware of for the most part because it hides behind the place that is this Parliament. To start off with, in February 2007, allegations surfaced of abuse of 3 Afghans in Canadian custody. The Military Police Complaints Commission launched an investigation into these detainees. In March, warnings came from Mr. Richard Colvin, a heroic public servant who came in front of committee and gave quite dispassionate but critically important testimony and did his job in the best traditions of a public servant in Canada. He spoke at that time and gave warnings to the government about torture that was taking place with detainees that were given to the NDS. What happened as time has progressed, the Conservative government has done everything in its power to block and prevent the truth from coming out. And why this is important, Madam Speaker, for more than anything else, is for our troops, for the Afghan people, and for the success of the mission. And I'll get to that in a little bit later period of time. In March 2009, the Conservative government tried to indefinitely delay the Military Police Complaints Commission hearing. In April, their application is denied by a federal court, and Mr. Colvin is subpoenaed to appear before the MPCC. So the government, our government, was trying to block the work that the MPCC was trying to do. In July, and this I found utterly shocking when Mr. Colvin was giving his testimony, that federal government lawyers, and this is very important for our public to know, federal government lawyers were being used to threaten witnesses not to participate in the MPCC hearings. And Mr. Colvin said, and this is a matter of record, he stood up and said in the special committee that he himself was threatened by government lawyers. This does not come, Madam Speaker, from the lawyers themselves. This would be a directive by and from this government. And I find, Madam Speaker, that this is a complete abuse of their position. In October, the MPCC shut down the hearings after the federal government, the Conservative government, blocked witness testimony and failed to produce documents. Madam Speaker, this all speaks to the reason why we are here today and why the Liberal Party has put forth this motion into the House of Commons, because we want to get to the bottom of this issue. And in fact, this wouldn't have been taking place if the government would have given the documents that they gave to the witnesses in front of the committee that they failed to give to the members of Parliament who sit on that committee. Don't you find that absolutely remarkable, that members who sit on the committee were deprived and denied from accessing the very documents that witnesses have had privy to? So it's not, as the government claims, an issue of public security at all. It's an issue of the obfuscation and the stonewalling that has become the sine qua non of this government's behavior, not only in this area, but in so many other areas. And I'm going to go down that, Madam Speaker, because what has happened, unbeknownst to many members of the public, is that the Conservative government has been foisting on all elements of the Canadian federal government and its arms a culture of denial, of secrecy, of obfuscation, of stonewalling, and bullying. They've used an arsenal of hyperbole, partisan rhetoric to divide Canadians, not to unite. The modus operandi of the government is not to unite Canadians, Madam Speaker. It is to divide Canadians to secure that 42% that they need to get a majority. What kind of leadership is that? It's not leadership. It's the pursuit of political power over the public good. The public good is merely a backdrop upon which this government is playing its little games. The tragedy of this all, and the victims of this, are our citizens, our country, our future, and the potential that we could have as a nation. The public service are also victims. And let me give you an example. Any of us in opposition, and I think the public would be find it shocking to know this. As members of Parliament, when we go to meet members of the public service who serve the government of the day regardless of their stripe, we have to have, or they have to have, somebody from the minister's office eavesdropping in on that meeting. That's right. Meetings that we have with members of the public service have to have a member from the minister's office there in person or in a box, listening in, eavesdropping in on the conversation and taking notes. And that is what happens to us. The fear that is happening within the public service is terrible because they can't do their job. Not only can they not serve the government of the day, but they can't serve the Canadian people. That is offensive at a most fundamental level of democracy. Our public service is being abused in this and other ways, as we've seen with Mr. Colvin. And what happens is, how on earth do you attract the best and brightest you have? How do you get the best and brightest out of our public servants? How do you attract, engage, encourage, and foster the type of excellence that our public servants have given to Canadians for generations? You can't do it if you're sitting down with a hammer over their head, willing to knock them over the head at every turn. And when does this happen? Well, a few examples. What has the Conservative government done to some of these people? Adrian Meisner, President and CEO of the Wheat Board, fired in December 2006 for his decision to follow the direction of the farmer-elected Wheat Board directors. Joanne Galinas, Environment Commissioner, fired in January 2007 after publicly commenting to the media about not receiving sufficient information from the government about its Made in Canada Environment Plan. Yves Le Boutillier, President of the Law Commission of Canada, fired on September 2006 after all federal government funding for the commission was cut. Andrew Okolich, scientist, and this is shocking given that Copenhagen is taking place right now, Mr. Okolich, scientist with the Geological Survey of Canada, fired in September 2006 for objecting to an order to turn federal correspondence into political propaganda. Mr. Okolich refused to turn the federal correspondence into the political propaganda in the area that he's responsible for. And the list goes on. I've got 2 pages, Madam Speaker, here, of people that have been abused. This speaks to that very serious problem, as I mentioned before, of what is taking place. And it goes down to other areas. The government doesn't like certain people who have substance abuse problems. What do? They take life-saving interventions like the Insight program. They try to take it to court to block people having access to life-saving interventions that will reduce harm and save lives. What kind of a government does that? Because in effect, it will cause and does cause these people to die. We have a Conservative government that is engaging in policies to block treatments that have proven to be effective from some of the top scientists from around the world, and as a result, these people will die. Madam Speaker, this speaks, as I said before, to the issues I mentioned, including what Mr. Colvin has faced. The kind of threats that have come down on his head is just symptomatic of the kind of abuse that is taking place against our public servants. And in fact, you could say that public servants today should have a letter from the Government of Canada saying, if you're not with us, you're against us, and you need not apply. Because that is, in essence, what they're actually saying. They don't want, as they claim, truth to power. They don't want excellence. They want people to be lemmings to do as they tell them to do. That's not a public service. That does not serve the Canadian public at all. Mr. Colvin's testimony has managed to go and incite and mobilize 70 former ambassadors, Madam Speaker, to go and support Mr. Colvin in the fact that he is actually doing his duty. So the character assassination that the Minister of Defence had done in this House, much to I think, the embarrassment perhaps of his own party, but certainly to the Canadian people, is something that is appalling. And it has to be stopped in its tracks, because you cannot and should not do that. Now, why is this important to the Canadian forces, Madam Speaker? Because this particular issue, we're trying to get to the bottom of it, because the government has this little game that they play, and then the parliamentary secretary was playing it just before question period. What the government does is they sidle up to the Canadian forces, they put their arm around them, wrap themselves around with the Canadian flag, and say, we're with the Canadian forces, everybody else is against them. What a bunch of nonsense. Every single political party in this House of Commons, Madam Speaker, supports the institution of the Canadian Forces, the men and women who serve the Canadian Forces, and their families. So this kind of nonsense that's being portrayed and trotted out by the government is offensive. An example, the Prime Minister stands up on a ship, one of our naval ships, in front of our Canadian Forces and proceeds to lambaste the opposition, utilizing the backdrop of our Canadian Forces men and women as a tool to be able to go and hammer the opposition. That's not what the Canadian Forces are about, Madam Speaker. So they're using the Canadian Forces as a tool for their own political gain. The Conservatives, Madam Speaker, cannot do this. And what they have failed to do while wrapping themselves up with the Canadian Forces and claiming to be their best friends, while utilizing them as a tool against everybody else, in effect what they've been doing is negating and actually not engaging in their responsibility, which was to be able to have an effective plan for Afghanistan. The government has taken the Afghanistan mission and looked at it through the narrow prism of the military. But in effect, what we have here is an insurgency that's primarily coming from Pakistan, not from within Afghanistan. In an insurgency, what you have to do is you have to defeat an insurgency through political means, utilizing military tools as a backup to those political interventions. But what the government has done, in effect, the Conservative government, is that they have utterly failed in the 4 years that they have been at the helm to come up with any political strategy for Afghanistan, any political strategy for Pakistan, which is at the center of al-Qaeda, any kind of national debate to be able to bring together the best and brightest minds we have to deal with this? No. They look at this through the military prism, and by doing that, they compromise and they weaken and they compromise the lives of our Canadian Forces, the mission itself, and the Afghan people. Now, why is that important with the detainee situation? Because by handing over detainees, and I must say that our Forces members have exerted extraordinary restraint and professionalism on the field, and that is without any debate whatsoever. They have been absolutely extraordinary. But what the Canadian government has done, by the failure to deal with these issues politically, they've actually compromised our ability to do better in the mission and compromise the lives of our forces, because by having a political doctrine that's compromised our Canadian Forces members, by not dealing with the detainee issue, by burying their head in the sand, by not being proactive, what actually happened is you destroy the hearts and minds aspect of the mission. Because many of these people have actually been, in the words of Mr. Colvin and others who have been in Afghanistan, individuals who are simply people at the wrong place at the wrong time. Farmers, people who are peasants, individuals who are just ordinary rural folk have been caught up, tortured. What happens if you're tortured? The people who pick you up become the problem. And so what happens is that the government's political failures are actually causing a failure in the mission that is out of the hands of our Canadian Forces and compromises the lives of our Canadian Forces, compromises the mission, and compromises the lives of the Afghan people. So what have they failed to do? First of all, in terms of an overriding objective, we went into Afghanistan, Madam Speaker, to get rid of al-Qaeda. Job done very quickly by our forces and others, and well done at that. We did not, however, go into nation build. And what's happened is that this mission has quietly morphed into a nation-building exercise. What's happened also is that the actual insurgency coming from Pakistan has not evoked any kind of plan from the government to come out with a political strategy for Pakistan. And then they talk about the Taliban being some monolithic structure. What a bunch of nonsense. The Taliban is a heterogeneous structure made up of individuals who are warlords, common thugs, yes, religious zealots, individuals who have been family members who have been killed or harmed by coalition forces. And the three major groups that are coming in the insurgency are the ones by Mullah Omar and the warlords Haqqani and Hekmatyar. Those are the three major insurgencies coming in from Afghanistan. Do we hear anything about that from the government? Do they have a plan to deal with this? No, they don't. They don't at all. So what in effect they're doing by their political failure, they're actually sowing the seeds of a potential Vietnam quagmire. And it's our men and women out there in the dirt, in the dust, in very, very difficult circumstances who are paying the price for this. So the irony of it all is while the Conservative government wraps themselves up in the flag and with the Canadian Forces, their political failures are in fact compromising the lives of our men and women in uniform. And that, Madam Speaker, is absolutely inexcusable. The members are saying, come on, but we don't hear for a moment any kind of plan of action whatsoever in terms of what they have to deal with the mission at hand. Well, here's a few suggestions. Number one, and a few reality checks. The government in the traditional structure in Afghanistan, Madam Speaker, is Pashtun-led. Mr. President Karzai is Pashtun. But he's not who the Pashtun want. In fact, the security structure within Afghanistan are controlled by Tajiks. This is a complete turnaround and a completely unnatural situation given the traditional power structure within Afghanistan. So what's happened is that the security forces and security situation is controlled by members of the Tajik tribe who are part of the Mujahideen, the individuals that the Taliban kicked out because they were corrupt and they were abusive to the people. The government, Madam Speaker, has no plan to address that problem. So the and intertribal problems and the abnormal and unnatural structure that exists right now in Afghanistan is not being addressed. And unless you address it, you can't have peace there whatsoever. The government of Mr. Karzai is predatory, venal, and corrupt. Is there a plan to deal with corruption in that government, Madam Speaker? They talk about it. There isn't one at all. And the fact of the matter is that corruption kills. Corruption is the cancer that will prevent the mission from being successful and prevent the Afghan people from being able to enjoy the safety and security that they have wanted for decades. The same things that we all want. But the reality of it is that the government has simply failed miserably to have any plan whatsoever to do that. Ultimately, security is up to the Afghan people, not up to Western forces. And increasingly, we're seen to be part of the problem in Afghanistan. So while President Obama has had chosen to do a surge, which I have to say personally, I think, if I may say that, I think that was an error on his part. But I think that what we have to do is be able to have those political solutions that deal with this issue. So what may some of those solutions be? Number one, a doctrine to deal with corruption within Mr. Karzai's government that has not zero tolerance, but being able to go and have a situation where we take a much firmer line on that. Secondly, a transparent reporting mechanism so the Afghan people can have access to and know where the monies are going, which should go for primary services and healthcare education, as well as into security. The political process must be instituted to encourage various members of the Taliban leadership to be part of the political solution and the power structure within Afghanistan. You hive off elements of the Taliban, and you're able to sort of weaken the Taliban in a way that enables those people to be able to have be part of the political solution and have ownership of their country. A regional working group must also be instituted involving Afghanistan, Pakistan, China, Iran, and others in the region that need to, including India, that has to be at the table because their interests have to be congruent with the future and the interests of a stable Afghanistan. India and Pakistan are part of the problem in Afghanistan. So in essence, Afghanistan's future in some ways lies outside of the country, and that has to be dealt with. I just want to close, Madam Speaker, and say this. The government is focused on a very narrow, through a very narrow prism with respect to the mission in Afghanistan. It is a very complex situation. It requires a coherent, intelligent, and well-executed political solution that focuses on enabling the Afghan people to be the masters of their security forces. We will not, and Afghanistan will not be, a democratic, Western-loving, human rights-respecting nation. It is the Islamic Republic of Afghanistan. So we have to change our goals. In the end, it's up to the government to implement these solutions. The failure to do that fails our troops, fails the people of Afghanistan, and fails the people of our country. Thank you.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of International Cooperation.
Speaker, with all of the wonderful highfalutin words that our interlocutor just gave us, I wonder how he feels about the fact that the motion as written will lead to a situation where there will be uncensored, unredacted, uncontrolled information that will be available ultimately on the internet for the Taliban to be able to plot and plan and do whatever they wish with. I wonder if he could explain to us how he feels about the fact that the motion also will put Canada in a position of not having any allies who will trust us with the information that we so desperately require in order for us to carry out this work that he is so pompously speaking about. I find that the position of him and the position of his party, the position of the opposition, to be politically opportunistic and very, very shallow. I wonder how he will feel in the event of a possible death as a result of this motion.
The Honourable Member for Esquimalt Wanda Fuca.
I see my colleague has swallowed the Kool-Aid, Madam Speaker. And in fact, this nonsensical comment that somehow the information that's going to be released to members of the committee is somehow going to be a security threat. The reality of the situation, and I ask my honourable colleague to reflect upon this, is that the witnesses received the information, and the members on the committee simply want to be able to receive this information too. From our side, we have, Madam Speaker, Privy Council members who were sitting there at the table. Members from the government. Also, all the members, Madam Speaker, want on the committee is to have access to the same information that the witnesses have had when they've come in front of the committee. That's simply the right thing to do. Legal precedent respects it, the principles of Parliament respect it, and the government should stop hiding behind these arguments which bear no, which are only meant to scare the public, in fact, for political gain, and they need to stop utilizing those tools and do the right thing instead of hiding behind these absurd arguments that hold no water whatsoever.
Questions and comments? The Honourable Member for Burnaby, New Westminster.
Well, thank you very much, Madam Speaker. I listened with interest to my colleague from BC, and I'm very happy that the Liberal Party has caught up to the NDP. The NDP, of course, was the first to call for a judicial inquiry and the first to call for the minister's resignation, and the Liberal Party, creaking and groaning, but getting there nonetheless, has now followed the NDP on those recommendations. It did take some time, but they did get there. And Madam Speaker, the problem that we're facing, as the member well knows, is far greater than just this particular case. It's a systematic pattern of obstruction from this government. Now, unfortunately, the examples that they take from are the previous Liberal government that was consistent with holding information from Parliament. So my question is very simple. Does this signal a change in Liberal policy? Are they now willing to say we were wrong before, but now we believe that that Parliament should be receiving these kinds of documents in this kind of situation? Does this say, very simply, that the Liberals are asking for forgiveness for their past?
The Honourable Member for Esquimalt Wanda Fuca.
Well, Madam Speaker, I think the member has made a presumption that is utterly false. The reality of it is that the Liberal Party, Madam Speaker, has been calling for truth and transparency in this issue in a non-political way for the sake of our troops, for the sake of our mission. Because the failure to do this, Madam Speaker, as I said before, and I think the members over there, as all members do, all of us do, want to make sure that the mission is going to be successful, but above all else, that our troops are going to be safe and secure. And what we can't have is a situation where our troops are put in a compromised situation because of a political failure that the government has made with their own pen. So the reality of it is that the government needs to rectify this situation. There's no harm, and they should fear nothing about being able to come clean with this issue so that the truth can come out and such a situation can't repeat itself. Also, I'd ask them to really look at the way that they treat their public servants, because certainly the type of abuse that is being thrown on the head of Mr. Colvin is something that cannot continue and is really a blight on this government's record.
Questions and comments? The Honourable Member for Mississauga South.
Thank you, Madam Speaker. We've already established that this is a constitutional privilege of Parliament, that it in fact is in the standing orders, and it has been extended to committees of this House. Even the Parliamentary Law Clerk has given his opinion that under the Candidate Evidence Act, notwithstanding the public safety and national security interests, that it is available. I guess the question for me, Madam Speaker, is the fact that since there already is information in the public domain that in fact a detainee in the custody of Canadians released to the Afghans was in fact tortured, that is the issue at question, whether or not it happened. The government was saying no, and now all of a sudden evidence come out. And I understand also that embedded journalists have information as well, including film, Madam Speaker, and there will be more coming out. The issue for me, and I wonder if the member would care to comment, is whether or not the government simply has to stop the stonewalling and the cover-up and make sure that we take the appropriate steps as we move forward on this, and just stand up and be responsible for its actions or, in fact, its inactions.
The Honourable Member for Esquimalt-Juan-Fuca.
Thank you, Madam Speaker. And I thank my honourable friend for his excellent question. In fact, it is the constitutional right of Parliament to demand information, and it's the supremacy of Parliament that trumps other provisions of the laws. So the fact of the matter is what the member across the way from the Conservative government said was utterly wrong. And the kind of information we're asking for, not information on operations, not information that is going to detail the operational needs or current situation of our Canadian Forces members. That we don't need to find out. But we do need to find out information that is specific to these events, and also to make sure that this doesn't happen again. Because it is the issue, but it is also goes to the ability for us to actually win in this mission, to be able to win the hearts and minds of the Afghan people. Our CF members are there doing their job. The members of the Provincial Reconstruction Team are doing their job. Our allies are doing their job. But if Canadians are put in a situation where they're doing things that are going to harm that because of a failure of political doctrine of the Conservative government, then in effect what they're doing is that the Conservatives are actually harming the very mission that so many of our men and women have given their blood, sweat and tears for, and the Canadian public significant amounts of money. So I think shouldn't be seen in some superficial way, but the government, I think, also needs to utilize this as a springboard to deal with the larger issue of the mission in Afghanistan. What are they doing? What are their objectives? How are they doing it? How are they integrating with other groups? And what is the political strategy for the mission in Afghanistan, looking at it in a broad regional context? Because it is only in the regional context will you be able to deal with this mission and to be able to ensure some semblance of security for the Afghan people into the future. Thank you.
Comments? A very brief question. The Minister of State for Science and Technology. Very brief question.
Well, thank you, Madam Speaker. Perhaps I'll just make a comment. The facts are that we're debating a motion here, a motion that is asking that the government release information that could, in fact, entail something as simple as a soldier's name, middle name, address, perhaps phone number, that the Taliban are hoping they can get their hands on, not just to attack that soldier, but potentially put the soldier's family at risk. That's exactly what this motion says. This member has not read the motion. So I want to remind the member with my final comment. It was the Liberals that put us in Afghanistan without a debate in 2003. We have fixed their mess. This happened under their watch. And to release this kind of information, we have no problem with dealing with committees as long as folks on committee aren't using Twitter. But what we will not do is release information that is in the national interest so our allies can continue to...
I would like to give the Honourable Member for Esquimalt-Juan-Fuca time to respond.
Well, all I say, Madam Speaker, is that it's interesting that the members from the other side all have the same talking points, all tread out the same nonsense, and not willing to utilize their own God-given intellect to be able to deal with a very important issue. And what, Madam Speaker, I would just impress upon the members from the other side is look at this clearly. understand what they're saying is a bunch of nonsense and get to the heart of the matter so we can resolve this issue, so we will have a proper mission in Afghanistan with a proper structure and a proper political solution to deal with this very serious and important issue.
Order. Order. Reprise du débat.
Resuming debate, the honourable member for La Pointe de Lille. Good afternoon, Madam Speaker. I'm pleased to recognize you in the chair. Madam Speaker, for the last few weeks we have been dealing with exceptional events here in this House, where I was elected in 1993. I have experienced a lot of upheaval, a lot of heckling and so on, but I've never seen anything like this. This kind of situation makes us wonder about the role of parliamentarians. I saw this legal opinion provided by Rob Walsh, the law clerk, so a senior officer of this parliament. And it deals with the constitutional framework for the House and committees. I'm going to read a few excerpts from it because I think that it is strong and pertinent. He says, as I mentioned in my latest letter, it is important to keep in mind that the committee, given responsibility by the House to consider Canada's mission in Afghanistan, must always demonstrate that it is assuming its constitutional role. That is, by requiring the government to be accountable. This is vital to ensure responsible government, and particularly to maintain proper relations between the government and the House and its committees. These are strong words, but I continue. This principle is also the constitutional basis of the request for information from the committee to the government and the government's obligation to provide the committee with the information that the committee needs to carry out that role. The right relating to parliamentary privilege means that these reports are outside legal constraints, and those constraints, therefore, do not apply in this case. I would invite my colleagues to read the rest of this document. Not only is he confirming that the motion introduced this morning and that has been supported by the opposition parties is valid, but he is also confirming the importance of the parliamentary role played by the committee. And not only the parliamentary role, but the constitutional role that parliamentarians and the committee play. I would invite my colleagues in the opposition parties who might feel insulted or uncomfortable with some of our positions and questions to reflect on this, because this applies to opposition and government members alike. It also says a lot about the importance of the committee role. We should thank Mr. Walsh for having written these remarks, and I think that they will be useful to us. But why do we need this? On the one hand, A lot of time would be required. My colleagues have taken a lot of time, but I do want to come back to a few main points. Since 2001, there were, as we know, attacks on the Twin Towers, and since that time, our world, not the whole world, but our world, as in any way that you might like to define that, has been precipitated into a situation of war. And this was unknown to a large extent since the end of the Second World War, or rather I could say since the Korean War. And that context is one that hearts and minds and politicians are not used to. And people need to emphasize the importance of it. They need to find their principles within that context. With all due respect for the member and in the interest for members.
I just, in considering the coincidental matters of which the member is speaking to, in accordance with Standing Order 32.2, I have the honor to table the 6th quarterly report on Canada's engagement with Afghanistan and also the government's response to the legislative review of Export Development Canada. Thank you. Merci beaucoup pour l'interruption, Madame.
Thank you, Madame. Mr. L'Honorable, the Honourable Member for La Pointe de l'Île.
Merci. J'ai hâte de lire, Madame la Présidente.
Well, I'm very keen to read the document, Madam Speaker.
Je disais que...
Now, as I was saying, since 2001, we, many of us, the United States, first and foremost, NATO, which is larger, including the Eastern European countries, have moved us into a different world context. This has required a review. And I say that we need to review this because I'm including everyone in this situation. What principles will exist? And that is not an easy question. It's not easy because the war is not a traditional one. It's dirty war. And as a result, we need to develop principles that we need, not solely with a view to winning, but to enable the Afghan people to regain control over their country, to develop it with our assistance. And I'm keen to address that issue, as we are supposed to do at the committee and in Parliament, but it will be an important debate. How will we pursue our activities after 2011? Because our efforts need to be extended, not the military ones, but our assistance in Afghanistan. So in this context, Canada found itself in a position where it had to send troops in this context, a climate of war. And it is an issue of complying with the Geneva Convention. Now, I don't know to what extent it was examined. Maybe it wasn't, because it would appear that the important aspect was to be strong, to win. Now, when we hear ministers and generals talk about how hard they worked, well, I believe it. I don't doubt that at all. The fact remains, however, that the Geneva Convention, which were established so that when countries go to war or go into an area where a war is underway and take prisoners, have guidelines with respect to how to treat the prisoners. You must, in fact, read the various Geneva Conventions to understand the situation fully and to understand the respect for prisoners contained with respect to the way they are treated. All of the aspects. All of the conditions show that their prisoners' rights must be respected, even if, in our eyes, without having gone to trial, they're considered by us criminals. And that's the rule under the Geneva Conventions. The rule is such that if a country under the Geneva Convention is responsible, either the country that has captured the prisoners, the country that is receiving the captured prisoners, the country that captures the prisoner and transfers the prisoner to another, if that first country has any fears that the prisoner will in any way, shape, or form be mistreated or tortured, that country that took the prisoner does not have the right to transfer the prisoner. Now, does this give rise to problems? I'm sure that it must. We have heard repeatedly that prisons in Afghanistan, there have been a lot written on the topic, were poorly built, ill supplied, people were not fed properly inside the prisons, and that has been confirmed abundantly in a number of documents. Conditions are such that torture takes place, and it does. Look at the report prepared by the Afghan Independent Human Rights Commission. The Commission conducted an in-depth study on 398 prisoners, including 57 from Kandahar, who were being held and who were identified as having been tortured, and that is a very high percentage. Now, in those conditions, was it difficult to manage the situation? I believe it was probably very difficult. And other countries did other things besides reaching an agreement with Afghanistan to transfer the prisoners and to conclude an agreement with respect to their treatment. Now, that isn't the subject of this debate. However, that enables us to understand and explain our anger, because this is a false debate. We are right to say that all of the signals were there, that in most situations the prisoners should not have been transferred. But they're saying, well, for starters, we turned to the Red Cross, but under the first agreement that was signed quickly, negotiated quickly and signed by General Hillier. In the first agreement, Canada did not obtain free access nor to the Red Cross. And so when there is no free access and a country is responsible for registers regarding the treatment of prisoners, because it's important not to forget that in prisons in Afghanistan, prisoners may encounter guards who have a bone to pick with them, who may have seen members of their families injured, killed because of the prisoners. So when precise records need to be taken on the prisoners, there has to be access, because without access, that can't be done. Now, I've attempted to read the documents we were given, the ones that were redacted, heavily redacted, and the parts that are not redacted make it possible to understand that there were a number of discussions on the transfer of prisoners, under what conditions, and on the fact that we can't establish a register or records of them. And someone at one point said we have not followed up on these prisoners for 2 months now. Just imagine what could happen over a 2-month period. Imagine what can happen in 2 months. So no follow-up from December 2005 to May 3rd, 2007. Now maybe there was goodwill, but no follow-up. So who can guarantee, under those conditions, that prisoners weren't tortured in the situation they were in? They were transferred, and because it was also written in the document that it would be up to Afghanistan to take charge of the prisoners. In the Geneva Convention, it clearly stipulates that that is not allowed. The person transferring the prisoner remains responsible for the prisoner. The person cannot transfer that responsibility. Since the state is responsible, if prisoners are transferred and under the conditions as they were, the risks, or there is a risk of torture, and that is a breach of the Geneva Convention.
Contre la Convention de Genève, ça veut dire que oui.
A breach of the Geneva Convention means that the penalties of not respecting the Geneva Convention can be applied. Now, I've tried to paint a picture of the situation. And when I was young, I taught history. And I always sought not just to learn, but to understand. I'm sorry, I didn't hear what you said. If you'd like me to understand, you'll have to speak more loudly. But what has occurred? What has happened over the past couple of weeks? On the government side, Mr. Colvin was prevented from passing on the documents that he had provided to sound the alarm, that he had sent, in fact, to several people, 18 or 19 documents that he had sent out stating that we couldn't do X, Y, and Z. I mean, I assume that's what he did. I believe that to be the case. It makes, in fact, no sense. Canada is attempting to tarnish his reputation. And I hope that following the conclusion of this debate, we will see the documents. Now, we have also seen and heard evidence testimony where, well, I was going to say without any acknowledgement that any kind of mistake was made. So what we could expect nothing less than an explosion here during question period in the House. That's not what is desirable. What we would like to see, what we would like to be able to do, is to find a way of enabling Mr. Colvin to give evidence, to share the documents, so that we can reestablish Canada's reputation. Thank you. Questions and comments.
The Honourable Member for Renfrew, Nipissing, Pembroke.
Thank you, Madam Speaker. I have found evidence of torture in Afghanistan, and I quote, "You must become so notorious for bad things that when you come into an area, people will tremble in their sandals. Anyone can do beatings and starve people. I want your unit to find new ways of torture so terrible that the screams will frighten even crows from their nests, and if the person survives, he will never again have a night's sleep." This was under the heading, "I was one of the Taliban's torturers. I crucified people," as reported by Christina Lamb on September 30th, 2001. Madam Speaker, today's motion, by design or not, may provide information to assist the cause of the insurgents to rid Afghanistan of the protection UN-sanctioned forces provide. As a member of the Separatist Party, why does the member opposite want to put the lives of our soldiers in danger?
L'honorable député de la Pointe-de-Lille.
Madame la Présidente.
The Honourable Member for La Pointe-de-Lille. Madam Speaker, colleague, I will point out that among those soldiers who have made the ultimate sacrifice are many Quebecers. I'd also like to point out that the men and women of Quebec are courageous, disciplined, and that no officers have reported any lack of compliance or non-participation with enthusiasm by the soldiers in their work and in accordance with their commitment. I am an independentist, and yes, I'm calling for that. But if you had listened, if you listened in fact to my speech, you would have heard that the situation that we are currently facing is something we share. Because by the will of Quebec, we remain within Canada, and we are loyal, and we participate in the debate. And when I say that the work that we can do could restore Canada's reputation, you should be happy that we are concerned with that. I would like to remind all members that they need to address their comments through the chair.
The Honourable questions and comments. The Honourable Member for Mississauga South.
Thank you, Madam Speaker. And I know the member has been involved in the foreign affairs files for many, many years during her career as an honourable parliamentarian. Madam Speaker, the issue here ultimately comes down to that it appears that Canada has been in violation of international law, the Geneva Convention. And this is the allegation, and I see the member from Cambridge is having his words already. But, Madam Speaker, I don't believe that the House has been reminded often enough of the terms under which it would be determined that someone would be in violation. It's not a matter, I don't believe, Madam Speaker, that you simply think that something happens. It's a matter of whether or not you are aware. And just being aware that there's the possibility, I believe that's the case, that you could be in violation of international law. Why is it so important, maybe the member could answer that question, why is it so important that we do in fact clear our name to ensure that the reputation of Canada continues to be in favor of human rights?
L'honorable député de la Pointe-de-Lille.
The honourable member for La Pointe-de-Lille. Thank you, Madam Speaker, and I'm addressing you. What is important is that there be an investigation. That's why there has to be a public inquiry. An inquiry to determine who's responsible and ensure that Canada can get back to its original position.
The honourable member for Elmwood Transcona.
Thank you, Madam Speaker, and appreciated the member's answer to the government members' insightful wedge-type question that we've been hearing from other government members as well. You know, trying to incite people in this House. My colleague, the member for Ottawa Centre, made an observation earlier today that may provide an ultimate solution here, and that is that in countries such as the United Kingdom and Holland actually have a very transparent system with regard to the detainees, and in fact in Holland the Parliament has to be informed whenever a detainee is transferred. And I think that, you know, when the government finally extracts itself from the current mess that it's in, maybe it should look to best practices elsewhere to develop a better system. Now, as far as the Liberals are concerned, it's nice to see that since they got us into this mess in 2003 without a debate in this House, that they at least are willing to have the public inquiry to include their time in office. But I'm particularly upset with the government because when I ask them a question about why did the government leak Mr. Colvin's memos to the media and why is it obstructing the Parliamentary Committee's request for documents, they deliberately hide from that question. They won't answer the question. They go around and answer any other type of question they can, but not that particular one. Could you answer or give me some observations as to why you think they're doing that?
La Pointe-de-Lille.
The honourable member for La Pointe-de-Lille. Madam Speaker, yes, the observations I could make are that it seems to me that the government chose the absolute worst way to manage this situation. As you stated, the Dutch, the British look at this whole matter in a much more transparent way. Situations in which they find themselves because of this war. As a matter of fact, from the outset in 2005, the agreement should have been inspired by that of the Netherlands and Great Britain. And the Honourable Whip will probably remember that I had recommended, while he was Minister of Defence, that he do so. He ended up doing so, and he stated that at the committee on April 25th. And the agreement was finally signed May 3rd, but he did so and he told us at the committee. And that was a surprise.
Comment, a very brief question by the Minister of State for Science and Technology.
Thank you, Madam Speaker. I always have the fortunate opportunity to give brief questions and comments, and I appreciate that. The member, I really would like to ask the member in all sincerity, and I understand the passion, and I listened very carefully, that there are in fact different levels of security. And the member would know going to committee that some documents are secure for Canadians and some documents are internationally secure, and there's probably 6 levels of security. And many of us have the opportunity to share in some of those levels. With respect to releasing documents and this particular motion, would the member not agree that there is a need for a nation who deals with other nations and has information from other nations so that we can work together in the best interest, through you, Madam Speaker, in the best interests of national security of democratic nations around the world, that not all information in all documents can be released. I remember being in a committee where the member from Mississauga South would not release documents that had no security implications. So it's interesting how the Liberals have, if I could just ask the question.
Order! Order! The Speaker's risen.
Just to give the honourable member time to respond within the 30 seconds left, l'honorable.
The honourable member for La Pointe de Lille. Madam Speaker, I am profoundly convinced that if the government had not taken this very closed attitude, if it had been open to discussing what documents could be released and those that may be more sensitive, I'm sure that the committee would have been able to discuss this. But when it's not possible to do that, we exercise our rights, and Mr. Walsh told us what our rights were.
Chief Government Whip on a point of order.
Point of order, Madam Speaker. I think if you seek it, you'll find agreement for the following motions. That in relation to its study of Arctic sovereignty, 12 members of the Standing Committee on National Defense be authorized to travel to Yellowknife, Northwest Territories, Elmdorf Air Force Base, Anchorage, Alaska, and USA, and Winnipeg, Manitoba in February-March 2010, and that the necessary staff accompany the committee. Second, that in relation to its study of high-speed rail in Canada, 12 members of the Standing Committee on Transport, Infrastructure, and Communities be authorized to travel to La Pocatière, Quebec in January-February 2010, and that the necessary staff accompany the committee.
Does the honourable member have the unanimous consent of the House to move this motion? Yes? Agreed. The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Carried.
Before we resume debate, pursuant to Standing Order 38, it's my duty to inform the House that the questions to be raised tonight at the time of adjournment are as follows. The Honourable Member for Gatineau regarding museums, and the Honourable Member for Etobicoke North regarding health.
Member for Mississauga South.
Thank you, Madam Speaker. Today we're debating an opposition motion that is actually bringing to the floor some fundamental issues with which there is a disagreement. And depending on how that is disposed of, Madam Speaker, will affect how parliamentarians will be able to discharge their responsibilities. Madam Speaker, the first element has to do with the constitutional right of parliamentarians to call for persons, papers, and records. And I would refer you to the publication called The Power of Parliamentary Houses to Send for Persons, Papers, and Records, a source book on the law and precedent of parliamentary subpoena powers for Canadian and other houses, and it's authored by a member of Parliament, the member for Scarborough Rouge River, back in 1997. Madam Speaker, in the book and on page 29, he makes general references, but I will just read one of them. It states, Madam Speaker, as Mangoat, quote, as Mangoat notes, a privilege may not be diminished prejudicially if affected or repealed, save an express statutory enactment to that effect. Madam Speaker, the right to call for persons, papers, or records is a constitutional right. It is also in our standing orders, Madam Speaker, and the members are well aware of that, and it's been used often in committee. The issue before us, Madam Speaker, in part has to do with whether or not, under the Canada Evidence Act, paragraph 37, 38, which essentially deal with an exclusion with regard to public or national security or safety. Madam Speaker, in the powers, it states, and in parliamentary privilege issues, the only way, Madam Speaker, that the power can be exempted from Parliament or taken from Parliament is if it is in a specific statute, specifically expressed. and that is the subject matter with which the law clerk of the Parliament of Canada gave his opinion to the committee. And Madam Speaker, I was there when General Hillier was there with two other, former General Hillier and two other generals now, who gave testimony before the committee. And Madam Speaker, each of those three persons, even the former General, General Hillier, had copies of the documents in question, unredacted. They had the full information, and Madam Speaker, they were in fact giving their testimony with the full knowledge of all of the details. And Madam Speaker, I thought it was kind of interesting that they all basically gave the same story, that there was nothing in these documents that would tend to indicate that there was any torture that took place of detainees turned over by Canadians. Well, Madam Speaker, the committee had asked for these documents, and there was the problem of having to have them translated before they could be circulated to the committee. But, Madam Speaker, ultimately, some of the documents were received and they were redacted, and some of them, in fact, totally blacked out. Madam Speaker, it begs the question, why is it that if the government is prepared to say, and the witnesses are, on behalf of the government are prepared to say, there is nothing in here that would indicate any evidence whatsoever of any torture being suspected or having taken place. Not one instant, not one case, to quote the Minister of Defense. It's clear. There's nothing here. You don't have to worry about it. But we're not going to give you the documents so that you can satisfy yourself. This is a fundamental issue in terms of parliamentary privilege, Madam Speaker. It is a fundamental right of parliamentarians to have access to information. And as a parliamentarian, if you're sitting at the committee and you want to ask questions of witnesses, how can you ask questions of witnesses when you don't have all the information that the witness has? How can you test them on the veracity of their testimony? How can you get to the nub of the point that you're trying to get at without having the information before you? The members didn't even have the redacted information when those witnesses were called. But members at the committee said, we want to assure we have the right to recall these witnesses once we eventually get the documents. Well, Madam Speaker, it's pretty clear if you look through the various events that transpired with the Special Committee on Afghanistan, that there seems to have been what some would describe as obstruction of the committee to do its work. And Madam Speaker, that is so fundamentally wrong, if parliamentarians are unable to discharge their responsibilities and their rights, Madam Speaker, to exercise their rights, to ask those questions. So, Madam Speaker, that's substantively where the debate has been going so far. Today there is a motion before the House, which I think comes in on the basis that we have not been able to get the information. We have not been able to do it, but we have the evidence coming from the Chief of Defense Staff, the General Nachinchik, who has now come forward and indicated that, yes, there is a clear, known case where a detainee in the custody of Canadians was turned over and that detainee was abused. Madam Speaker, there is more. There is more to come. I'm absolutely convinced of it because I've also heard stories myself coming from journalists who were embedded in theater in Afghanistan. And they have an interesting situation. If members would want to try to find out what are the rules of the game guiding embedded journalists, can they disclose any information, things that they personally witnessed? They've taken film. They're censured and censored before and after. But, Madam Speaker, is all the film accounted for? And I believe, and my understanding is what I've been told, it's hearsay though, that in fact some film does exist in the public domain. Clear evidence of further examples of torture. That is going to come out, Madam Speaker, because you cannot you cannot expect that people are going to hold on to this when it is so vital to the public interest. Canadians, as the previous speaker said, are very concerned that somehow, it's not a matter of the military, it's a matter of the direction of the military, and that comes straight from the government. The government is the one who is responsible here. The government is the one who has put roadblocks in the way of parliamentarians getting the information. There is no question that parliamentarians don't want to somehow put Canada in a position of embarrassment or any other sanctions. I think the concern here, Madam Speaker, is that parliamentarians want to be absolutely sure that we are now doing the right thing, and that if there is a problem, that it's corrected. And in fact, Madam Speaker, before all of this occurred, the Minister of Defence was, had actually said, the protocol for detainee turning over was inadequate. It was inadequate. So in 2007, they came out with a new one, a new protocol. Well, Madam Speaker, if they said it was inadequate from the previous government, why wasn't it changed immediately? Why wasn't it changed? It begs the question, Madam Speaker. You can't just say it was inadequate, so we came out with something else in 2007, but in the interim, under our watch, things were happening. The allegations were there. And Mr. Colvin testified to that. And now we've subsequently had so many former ambassadors come forward and defend the right of a whistleblower to do this. It's the right thing to do, to say there was concern, and those concerns were raised at various levels, but also to the highest level. And it was suppressed or denied. And Madam Speaker, very slowly, this cover-up is being taken apart very slowly, and the information's coming out. And I think that the Chief of Staff of the Defense, General Natinchik, did the right thing, the honorable thing. I found that information. It's true, and here it is, and he did it as soon as he found out. The government hasn't, though. The government is still, whenever it's raised, their approach is to attack back and say, oh, well, you're doing this because you don't stand behind our troops. Well, Madam Speaker, that's just a strategy of flip the channel, change the channel, get the attention somewhere else and say, actually, they're the bad guys, we're the good guys. Madam Speaker, the issues before the House ought to be focused on, and we ought to stay there. And when people start to switch the channel, you know that you're on the right track. When they start to heckle you and yell at you, you know you're on the right track, Madam Speaker. This is an issue before this place which is fundamental to the supremacy of Parliament, to call for persons, papers, and records, to get to the truth and to do the right thing. That's why we're fighting for this, Madam Speaker, and that's why the majority of the House supports this motion. And the motion is asking that, and I won't read it all, but that the House provide in original and uncensored form all the documents referred to in the affidavit of Richard Colvin, dated October 5th, 2009, which is the first witness before that committee. Secondly, all documents with the Department of Foreign Affairs' written response to the documents referred to the affidavit of Richard Colvin, dated October 5th, 2009. Thirdly, all memoranda for information or memoranda for decisions sent to Minister of Foreign Affairs concerning detainees from December 18th, 2005 to the present. Fifthly, all documents produced pursuant to all orders of the Federal Court in Amnesty International Canada and British Columbia Civil Liberties Association versus Chief of Defence Staff for the Canadian Forces, Minister of National Defence and Attorney General of Canada. Sixthly, all documents produced to the Military Police Complaints Commission in the Afghanistan public hearings, all annual human rights reports to the Department of Foreign Affairs on Afghanistan, and finally, accordingly, the House, and this is part of the motion, is asking the House to order that these documents be produced in their original and uncensored form forthwith. Madam Speaker, there is a suggestion that somehow, Madam Speaker, that these documents, if released, would create a further risk to our military, either as individuals or collectively. Madam Speaker, we've been at war in Afghanistan for a long time. I don't think it's a secret. I don't think that there's anybody on either side of the conflict that is unaware that there are tens of thousands of people in theater from a variety of countries, and more coming. Madam Speaker, somehow to suggest that an individual soldier might be at risk because of information coming out. Well, Madam Speaker, we have tools. We have tools to work with. And you know, Madam Speaker, if the government was acting in good faith, if the Minister of National Defense was acting in good faith, he wouldn't say why we can't have the documents presented to this special committee. He would tell us how we can. The difference is that we do have tools. One of the things that I had suggested earlier in this whole chronology of events was that since this was a special committee dealing with it, most of the members on the committee are already privy councillors who are sworn to secrecy of state secret information, that the others could, in fact, be sworn in. They could be sworn in and bound to secrecy and could have access and could look at it if there was a case and if it could be found. To do it, just to do it, say we need to protect this information. Once they see it, and I think they can start off, Madam Speaker, with the Colvin documents. If the witnesses who are presenting to the committee say we didn't notice anything in here that gave us any indication whatsoever that there was any evidence of torture, then why would they be reluctant to release that to the committee members so that they could satisfy themselves? It's a disconnect. If there's nothing there, if three generals are prepared to say there's nothing in there, why is it that the government says, but we're only going to give you the blacked out version? Why not swear them in? Why not go in camera? Why not give them a chance to look at it and demonstrate that the government can be trusted on this? But the actions of the government thus far have been, we don't trust the government. It's not a matter, it has nothing to do with whether or not we have the greatest respect for our military. Where we have the problem, the trust in our military is not the question, it's the trust in the government. The government has not shown good faith. And as a consequence, Parliament is now seized with a motion before it to say, we have to do something about this because this is not going away. And the government, can, at its own peril, is going to continue to play this game to cover up the facts and the details until it's whittled out. But other stuff will come out. It will. They know it. It always does. Madam Speaker, we just received the quarterly report to Parliament for the period of July 1st to September 30th, 2009. Just about an hour ago, it was just tabled in the House by the Minister. And Madam Speaker, there's some interesting developments to report upon, an election and all other good things. The thing that I found very interesting, because it's only really 13 pages long if you forget about the attachments. But in the conclusion, and I think this is really important because it tends to go to what we're talking about right now. It says, this is a conflict of utmost complexity in the region of violent instability. We share this difficult mission with our close allies under UN authority and most importantly with the Afghan people. Although the endeavor remains risky and the outcome far from certain, Canada's mission in Afghanistan underscores, and here it is, the values that Canadians themselves hold dear. That's why we're there.
Hear, hear.
To underscore the values that Canadians themselves hold dear. Madam Speaker, the value is respect for international law, international human rights. That's the value. The government may put it in a report, Madam Speaker, but I don't think this particular government believes it. I don't think that they really believe that human rights is something worth fighting for. I don't believe that they have given any indication that they will protect and defend human rights. I can't believe, Madam Speaker, all of the different things that have happened. The member for Cambridge is going to rant. That's fine. He can do that. But, Madam Speaker, I can tell you that when the law clerk, he gave an opinion to the committee, the Department of Justice lawyers challenged it. They said, no, there's an override here because of sections 37 and 38.16 of the Canada Evidence Act. The member for Scarborough Rouge River was involved in that. Make absolutely sure that it did not override the powers and the privileges of Parliament. It's clear. And he gave a second opinion to say they never explained. They just said we reject The lawyers for the Justice Department just said they reject the advice of the parliamentary law clerk, the person who has the resources necessary to advise parliamentarians of the legal ramifications of things and our legal rights. Well, Madam Speaker, the second opinion says that he totally dismisses the Justice Department's assessment of whether or not the Canada Evidence Act applies here. The issue is, Madam Speaker, that Parliament has a constitutional right. It is in our the rules and the privileges, and the issue of this committee. There are tools to have done this, but when it really gets back to it, if you get it down to its simplest form, you have to go back to the initial documents that the three witnesses had in the second meeting after Richard Colvin was before the committee. They had the documents. They testified that there was nothing there that would indicate that there was any concern about torture or releasing detainees where you were concerned about torture occurring. If that was the case, you have to ask yourself, why wouldn't the government simply take all reasonable steps to satisfy the committee that that was the case? What they did, Madam Speaker, they said, first of all, we can't give you anything in time for these witnesses, so you're going to have to go on the fly based on what they say and not what you know. And by the way, we have to translate these things, and it's going to take a little bit longer, and then we'll give it to you. But when we give it to you, there are going to be a lot of blacked out pages, because this is, very sensitive and could be a problem. Well, Madam Speaker, it's not the case. The witnesses said it wasn't the case. The testimony of those witnesses said there should have been nothing blacked out. But it was. And that is the question, Madam Speaker. Why? Because the government is covering up, the government is caught, and the government is going to have to be accountable. And if all they're going to do is throw it back and say, well, you have no respect for our military, you don't support our military. When they hear that, when public hears that, Madam Speaker, they know the government is just trying to change the channel. They don't want to be accountable, and they don't want to respect the rights and the privileges of Parliament.
Questions and comments? The Honourable Minister of State for Science and Technology now has the floor after the presentation.
Thank you very much, Madam Speaker. I would like to ask this member a question. He mentions that we do have the tools. Of course, one of those tools is redaction. I would like to remind the member, because he chooses to forget, and he has a lot of experience. Member, through you, Madam Speaker, has a lot of experience as a chair of a committee. In fact, he's the chair of the so-called Ethics Committee. When we were on the Ethics Committee, Madam Chair, we put up a number of witnesses that we would like to hear from, and that member denied the entire list of witnesses. The member also did not get documents to committee members while we were doing our work on the so-called Ethics Committee. Madam Speaker, as a chairman myself, a past chairman, we've had opinions from Mr. Walsh, and we fully respect those opinions. Mr. Walsh is the epitome of this area as a law member of the legal advisory committees. I know the members of the bloc down there, when we put forward funding for our troops, voted against that, so that's another story. But Mr. Walsh gave an opinion to our committee, and if I may, Madam Speaker, for the chipping on the other side.
Order, please. Order, please. The Honourable Minister can finish his question.
My question, appreciate that very much, Madam Speaker, but of course, when Mr. Walsh gave an opinion at that time, the Liberals, the Bloc, and the NDP did not take that opinion. They voted completely opposite to it. So the member opposite has a lot to account for, but the question that I ask him is, in those documents, would he not admit, if there was information, for example, the names of the soldiers, the numbers in that brigade, that troop, in that area, the location of the transfer, wouldn't that be subject to security interest? The Taliban would just love to know how many of our soldiers are wandering where.
The Honourable Member for Mississauga South.
Thank you, Madam Speaker. And I have a different version of what happened at my own committee because, Madam Speaker, chairs don't make those kind of decisions. It's the committee that makes those decisions. But I would remind the member that he was the chair of procedure in House Affairs, and they fired him and threw him out. So, Madam Speaker, I want to, the member is, he's asking again the question, is suggesting that there is some information that might be there that may impact persons and their safety and security. Okay? And Madam Speaker, if that's the case, we have the tools, but it's not just our right, and I think this is very important, Madam Speaker. It's not just our right to have the documents. It's our duty to get them to do the job. That's the difference. And if there is some risk, if there is national security and safety risk, I can assure you, Madam Speaker, that this Parliament would not take the steps that would allow that to happen. And, Madam Speaker, I think it's important.
Order, please.
I think it's important, Madam Speaker, to understand that if the government would start operating in good faith, that there are ways, either in camera, swearing in those who are not privy councillors, showing. Don't tell me that it's so. Prove it to me. And they can start, Madam Speaker, by the Colvin documents. If they could do that, Madam Speaker, it would be very clear that the government has not been honest with Canadians.
And comments? Questions and comments? L'honorable député.
The honourable member for Drummond. Yes, thank you, Madam Speaker. I would also like to thank my colleague, the member for Mississauga South. I want to ask him a general question that has been bothering me for 2 weeks already. There are other countries that are in Afghanistan as part of this war, whether we like it or not. There are other countries that have the very same problems we do. That is, the Geneva Convention rules, the need to protect their soldiers, being therefore open to their citizens, to their public, and therefore that have the same experience, the same problems. So are we being too aggressive as an opposition? Are we doing our job too well? What is the nature of this problem in the sense that other countries are dealing with it, but we're the only ones talking about it?
Thank you to the member, Madam Speaker. I am aware that Canada has the weakest protocol of any of the other countries who are in Afghanistan. But, Madam Speaker, the member just simply reminds all of us again that the question here is very serious. It's very serious, and as the speaker from the Bloc just said, we're talking about compliance with the Geneva Convention. We're talking about human rights. And it's hard for some people to say, I know the government always says, you got to support our troops, and we're in a terrible environment, and, things sometimes happen. Well, Madam Speaker, yes, things sometimes happen, but we have to do everything possible and show good faith that we're taking all necessary steps that bad things don't happen. The government still is refusing to show good faith and put into place the necessary safeguards, and, in fact, to be open and honest with Canadians and parliamentarians.
Comments? The honourable member for St. John's East.
Thank you, Madam Speaker. I just have a couple of points. The member for Mississauga South referred to Richard Colvin as a whistleblower, and I'd ask him to reconsider that. Mr. Colvin was doing his job, reporting to his superiors, warning them of the danger of breaching international legal obligations. He appeared before the committee as a command performance, I guess you could say, as a request of the committee. He was also subpoenaed before the MPCC and was doing his duty to respond to the subpoena. So I think it's proper to characterize him as a public servant doing his duty. The second thing I'd ask, and it seems that members opposite on the government side appear not to take seriously the obligations of parliamentary, the precedent of Parliament, and the fact that Parliament has the overriding right to this. Are you satisfied that this government is going to comply with this order should it be passed by the House today?
The honourable member for Mississauga South.
Thank you. I take the the comments of the member respectfully. Mr. Colvin is not a whistleblower that in fact is his job, and he communicated and then found himself in a position where he was told to stop putting things in writing. He was told that we'll have these verbally. You know why, Madam Speaker? Because that way there's no trail, there's no evidence, there's hearsay. There's hearsay. That's what it is. So, Madam Speaker, Madam Speaker, when you get those kind of instructions, and we've even dealt with it in our own committee on access to information, privacy, and ethics, whether or not there is a problem that there is a concerted effort to get around the requirements under the Access to Information Act by not having documents being created that normally should be created. So, Madam Speaker, this is very deep. It's very serious, and we take this seriously. And it's about time, Madam Speaker, that the government took it seriously.
Okay. Did the Honourable Minister of State want to introduce the document on a point of order?
If I could, the member made some statements earlier that the record, yes, if I could, the record sort of reflects something different. I wonder if I could get unanimous consent from the House to table the documents.
Absolutely. Does the Honourable Minister have unanimous consent for this motion? Mais je pense qu'il n'y a pas besoin de...
I don't believe he needs.
Well, I'm going to respond to that, Madam Speaker.
Okay. Reprise.
Resuming debate, the Honourable Member, the Honourable Minister of Foreign Affairs. Thank you, Madam Speaker. Madam Speaker.
This debate will be to remind my colleagues of the solitary stark fact: we are at war. Of all people, we should never forget that. As we speak, thousands of our soldiers are risking their lives in the most dangerous place in the world. They are defending the values, institutions, and principles our great democracy represents. They are fighting to bring freedom, security, and justice to one of the poorest, most vulnerable states in the world. And what does the opposition, all three opposition parties, want to discuss today? The progress of our mission? No. The safety of our soldiers? No. Are they worried about the criminal and cruel tactics employed by the enemy?
I don't think
so. What the opposition wants, Mr. Speaker, all three opposition parties, is to obtain access to secret documents to try and prove that our enemies in Afghanistan are mistreated by their own people. For weeks, the opposition, all three opposition parties, have been desperately trying to embarrass the government by alleging that our troops and civilian personnel in theatre of war are somewhat complicit in torture. The reputation of our armed forces, police personnel, and diplomatic service be damned. They, all three opposition parties, are searching every nook and cranny to unearth some kind of evidence that would show that Canada is responsible for the commission of war crimes.
Ridiculous. It's shameful.
Mr. Speaker,
disgusting.
I'm not even sure the opposition, once again, all three opposition parties, care that the release of information they are demanding would be irresponsible and damaging to our national interest. They do not accept that Section 38 of the Canada Evidence Act, which puts restrictions on the release of information for reasons of national defence and national security, applies in this case. In defining national security, the federal courts, I want to remind everybody, had determined that this includes information provided in confidence by foreign agencies and confidential diplomatic exchanges. Many, if not most, of the documents that the opposition has identified fall into these categories. We are bound to respect our obligations under the law, not to release information that would put at risk our national security.
National security, protection of our troops, success of our mission. Those are words we do not often hear from opposition members. Any risk is reasonable, even that of providing information to the enemy, because we are dealing with enemies, Madam Speaker. We do not manage prisons in Afghanistan.
Government is clear and has been repeated many times by the Prime Minister. All the information that can be released will be made available to members of the Special Committee. And we have already released last week some of the documents that have been asked for by the committee. The documents produced for the military police complaints alone constitute several thousand pages. We also have obligations to confidentiality in our relationship with the International Committee of the Red Cross, which plays an important monitoring role of detainees in Afghanistan. This organization is mandated under national humanitarian law to visit detainees. It works to improve the conditions of detention of detainees and to ensure that they are treated humanely and receive judicial guarantees according to international standards. Information on ICRC visits to detainees is shared only between the RCRC and the detaining power. The ICRC's activities are based on a policy of confidentiality, which is key to maintain its neutrality and impartiality, and to secure access to detainees and people in need, who need, various contexts around the world. Officials of my department, Madam Speaker, meet regularly with the ICRC in Geneva, Washington, and in their field offices around the world, including Afghanistan. Releasing the details of those discussions would not only jeopardize our relationship with the long-standing partner, but compromise their ability to do their important job effectively on the ground in Afghanistan. The irresponsible demands of the opposition could also bring harm to third-party organizations and individuals that our diplomats often meet confidentiality. And finally,
I regret to interrupt the Honourable Minister, mais comme il est 17h20,
it being 5:22, and because this is the last opposition day for the period ending December 10th, it is my duty to interrupt the deliberations and to immediately deal with all questions for dealing with supply. The question is as follows.
Seconded by Mr. Kotler, move that given the undisputed privileges of Parliament under Canada's Constitution, including the absolute power to require the government to produce uncensored document when requested, and given the reality that the government has violated the rights of Parliament by invoking the Canada Evidence Act to censor documents before producing them, the House urgently requires access to the following documents in their original and uncensored form. Puis-je dispenser?
May I dispense?
Yes.
No.
I can dispense tous les documents mentionnés dans la déclaration.
All documents mentioned in the document on October 5th, 2009. All memoranda for information or memoranda for decision sent to all documents within the Department of Foreign Affairs.
Or memoranda for decision sent to the Minister of Foreign Affairs concerning detainees from December 18, 2005 to the present, tous les documents
all documents produced pursuant to all orders of the Federal Court in Amnesty International Canada and British Columbia Civil Liberties Association versus Chief of the Defence Staff for the Canadian Forces, Minister of National Defence, and Attorney General of Canada.
Documents produced to the Military Police Complaints Commission in the Afghanistan public interest hearings. All annual human rights reports by the Department of Foreign Affairs on Afghanistan, et par conséquent, la Chambre ordonne.
And accordingly, the House hereby orders that these documents be produced in their original and uncensored form forthwith.
Mr. Ignatieff, seconded by Mr. Goodale, move the following amendment that the motion be amended by adding before the word accordingly the following. All documents referred to by the Chief of Defence Staff in his December the 9th, 2009 press conference and all other relevant documents, and la mise aux voix porte sur l'amendement.
The question is on the amendment.
To adopt the amendment. Que tous ceux qui appuient.
All those in favor of the motion will please say yay.
All those opposed, please say nay. In my opinion, the nays have it. Convoquer les députés.
Order. The question is the following one. Mr. Dosanjh, seconded by Mr. Kotler, moved that given the undisputed privileges of Parliament under Canada's Constitution, including the absolute power to require the government to produce uncensored documents when requested, and given the reality that the government has violated the rights of Parliament by invoking the Canada Evidence Act to censor documents before producing... May I dispense? Agreed? Thank you. Mr. Ignatieff, seconded by Mr. Goodale, move the following amendment, that the motion be amended by adding before the word accordingly the following: all documents referred to by the Chief of Defence Staff in his December 9, 2009 press conference and all other relevant documents, and. The question is on the amendment.
Those in favour of the amendment will please rise.
Ignatieff. Mr. Dion. Mr. McCauley. Mr. Valte. Mr. Bevilacqua. Mr. Easter. Ms. Fry. Ms. Mina. Mr. Goodale. Mr. Regan. Mr. Bélanger. Mr. Byrne. Ms. Bennett.
Ms. Bennett.
Mr. Bryson.
Mr. Bryson.
Ms. Gros.
Ms.
Mr. McCallum.
Mr. McCallum.
Mr. Dosanjh.
Mr. Dosanjh.
Mr. Dryden.
Mr. Dryden.
Mr. Malley.
Mr. Malley.
Madame Jennings.
Madame Jennings.
Mr. Cosner.
Mr. Cosner.
Monsieur Proulx.
Monsieur Proulx.
Mr. Martin Esquimalt Wandafuka.
Mr. Martin Esquimalt Wandafuka.
Mr. McTague. Monsieur
McTague.
Patry.
Mr. Patry.
Mr. Zabo.
Mr. Zabo.
Madame Folco.
Madame Folco.
Mr. McKay Scarborough Guildwood.
Mr. McKay Scarborough Guildwood.
Mr. Wilford.
Mr. Wilford.
Mr. Bagnall.
Mr. Bagnall.
Mr. Iking.
Mr. Iking.
Mr. Murphy Charlottetown.
Mr. Murphy Charlottetown.
Mr. Tonks.
Mr. Tonks.
Mr. Pachetti.
Mr. Pachetti.
Mr. Baines.
Mr. Baines.
Mr. Damour.
Mr. Damour.
Ms. Dalla.
Ms. Dalla.
Mr. Holland.
Mr. Holland.
Mr. McGinty.
Mr. McGinty.
Ms. Ratansi.
Ms. Ratansi.
Mr. Rota.
Mr. Rota.
Mr. Savage.
Mr. Savage.
Mr. Sharpalegia.
Mr. Scarpalegia.
Mr. Silva.
Mr. Silva.
Mr. Sims.
Mr. Sims.
Mr. Russell.
Mr. Russell.
Mr. Dhaliwal.
Mr. Dhaliwal.
Mr. Murphy, Moncton, Riverview, Dieppe.
Mr. Murphy, Mountain Riverview, Dieppe.
Mr. Pearson.
Mr. Pearson.
Ms. Hall Finley.
Ms. Hall Finley.
Ms. Murray.
Ms. Murray.
Mr. Andrews.
Mr. Andrews.
Ms. Cody.
Ms. Cody.
Mrs. Crombie.
Mrs. Crombie.
Ms. Duncan, Etobicoke North.
Ms. Duncan, Etobicoke North.
Ms. Foote.
Ms. Foote.
Mr. Garneau.
Mr. Garneau.
Mr. Kanya.
Mr. Kanya.
Mr. Kennedy.
Mr. Kennedy.
Madame Mendez.
Madame Mendez.
Mrs. Simpson.
Mrs. Simpson.
Monsieur Trudeau.
Monsieur Trudeau.
Mr. Valeriat.
Mr. Valeriat.
Madame Zarak.
Madame Zarak.
Monsieur Duceppe.
Monsieur Duceppe.
Monsieur Laframboise.
Monsieur Laframboise.
Monsieur Laforêt.
Monsieur Laforêt.
Monsieur Paquet.
Monsieur Paquet.
Madame Lalonde.
Madame Lalonde.
Monsieur Bachan.
Monsieur Bachan.
Monsieur Bigras.
Monsieur Bigras.
Monsieur Ménard.
Ménard.
Monsieur Bouchard.
Monsieur Bouchard.
Monsieur Lessard.
Monsieur Lessard.
Monsieur Roy.
Monsieur Roy.
Madame de Bellefeuille.
Madame de Bellefeuille.
Monsieur Guimond, Montmorency, Charlevoix, Haute-Côte-Nord.
Monsieur Guimond, Montmorency, Charlevoix, Haute-Côte-Nord.
Madame Gagnon.
Madame Gagnon.
Monsieur Lemay.
Monsieur Lemay.
Madame Brunel.
Madame Brunel.
Madame Gay.
Madame Gay.
Madame Bourgeois.
Madame Bourgeois.
Madame Demers.
Madame Demers.
Monsieur Blais.
Monsieur Blais.
Monsieur Bellavance.
Monsieur Bellavance.
Monsieur Cardin.
Monsieur Cardin.
Madame Faye.
Madame Faye.
Madame Lavallée.
Madame Lavallée.
Monsieur Plamondon.
Monsieur Plamondon.
Madame Freeman.
Freeman.
Monsieur Saint-Cyr.
Monsieur Saint-Cyr.
Monsieur Malo.
Monsieur Malo.
Monsieur Nadeau.
Monsieur Nadeau.
Monsieur Lévesque.
Monsieur Lévesque.
Monsieur Asselin.
Monsieur Asselin.
Monsieur André.
Monsieur André.
Madame Mourani.
Madame Mourani.
Monsieur Godet.
Monsieur Godet.
Madame Deschamps.
Madame Deschamps.
Madame Bonsang.
Madame Bonsang.
Monsieur Vincent.
Monsieur Vincent.
Madame Tillac.
Madame Tillac.
Monsieur Dufour.
Monsieur Dufour.
Monsieur Pomerleau.
Monsieur Pomerleau.
Correction. Monsieur Ouellet.
Monsieur Ouellet.
Monsieur Pomerleau.
Et ensuite Monsieur Pomerleau.
Monsieur Guimond, Rimouski-Neigette et Muscotin-les-Basques.
Monsieur Guimond, Rimouski-Neigette et Muscotin-les-Basques.
Monsieur Paillé-Louis-Hébert.
Monsieur Paillé-Louis Hébert.
Monsieur Dorion.
Monsieur Dorion.
Monsieur Paillé-Hochelaga.
Monsieur Paillé-Hochelaga.
Madame Baudin.
Madame Baudin.
Monsieur Desnoyers.
Monsieur Desnoyers.
Mr. Layton.
Mr. Layton.
Monsieur Mulcair.
Monsieur Mulcair.
Ms. Davies, Vancouver East.
Ms. Davies, Vancouver East.
Ms. Wajili-Salis.
Wajili-Salis.
Mr. Massey.
Mr. Massey.
Mr. Harris, St. John's
Mr.
East.
Harris, St. John's East.
Mr. Martin, Sault Ste. Marie.
Mr. Martin, Sault Ste. Marie.
Monsieur Godin.
Monsieur Godin.
Mr. Comartin.
Mr. Comartin.
Ms. Crowder.
Ms. Crowder.
Mr. Christopherson.
Mr. Christopherson.
Mr. Angus.
Mr. Angus.
Mr. Julian.
Mr. Julian.
Ms. Charlton.
Mr. Charlton.
Mr. Cullen.
Mr. Cullen.
Mr. Sixay.
Mr. Sixay.
Ms. Matheson.
Ms. Matheson.
Mr. Bevington.
Mr. Bevington.
Madame Savoy.
Madame Savoy.
Mr. Dewar.
Mr. Dewar.
Mr. Malloway.
Mr. Malloway.
Mr. Alan Welland.
Mr. Alan Welland.
Ms. Ashton.
Ms. Ashton.
Mr. Atamanenko.
Mr. Adamanenko.
Mr. Donnelly.
Mr. Donnelly.
Ms. Duncan Edmonton Strathcona.
Ms. Duncan Edmonton Strathcona.
Monsieur Gravel.
Monsieur Gravel.
Madame Hughes.
Madame Hughes.
Mr. Stauffer.
Mr. Stauffer.
Mr. Marston.
Mr. Marston.
Ms. Chow.
Ms. Chow.
Mr. Martin Winnipeg
Mr.
Centre.
Martin, Winnipeg Centre.
Mr. Thibault.
Mr. Thibault.
Ms. Leslie.
Ms. Leslie.
Mr. Rafferty.
Mr. Rafferty.
que tous ceux qui se...
All those opposed to the amendment will please rise.
Mr. Harper. Mr. Fletcher. Mr. Thompson. Ms. Ambrose. Ms. Oda. Mr. Van Loan. Mr. Tabe. Mr. Day. Mr. Nicholson. Mr. McKay Central Nova. Mr. Cannon Pontiac. Mr. Flaherty. Mr. Clement. Mr. Sproul. Mr. Baird. Ms. Finley. Mr. Ritz. Mrs. Shea. Mr. Kenny, Calgary Southeast. Mr. Moore, Port Moody, Westwood, Port Coquitlam. Mr. Paradis. Mrs. Aglukat. Mr. Blackburn. Mr. Abbott. Mr. Duncan, Vancouver Island North. Mr. Richardson. Mr. Benoit. Mr. Brightchrist. Mr. Lake. Mr. Keddy, South Shore, St. Margaret. Mr. Warawa. Mr. Mackenzie. Mr. Goodyear, Mr. Merrifield, Mrs. Yelich, Madame Werner, Mr. Hill, Mr. O'Connor, Ms. Raitt, Mrs. Lebloncy, Mrs. Sargent, Mr. Lebel, Mr. Ashfield, Mr. Lunn, Mr. Menzies, Mr. Camp, Pitt Meadows, Maple Ridge Mission, Mr. Dykstra, Mr. Delmastro, Mr. Gould, Mr. Carey, Mr. Cummins, Mr. Harris, Caribou, Prince George, Mr. Anders, Mr. Casson, Mr. Goldring, Mr. Bernier, Mr. Chong, Mr. Kerr, Mr. O'Brien, Mr. Moore Fundy Royal, Mr. Petit, Mr. Hahn, Mr. Poiliev, Mr. Lukiski, Mrs. Wong, Mrs. Glover, Madame Boucher, Mr. Anderson, Mr. Jean, Mr. Komarnicki, Mr. Lemieux, Mr. Saxton, Mr. Velicott, Mrs. Gallant, Mr. Lunny, Mr. Rajat, Mr. Reed, Mr. Sorensen, Mr. Schellenberger, Mr. Allison, Mr. Bazan, Mr. Brown Leeds Granville, Mrs. Greywall, Mr. Hebert, Mr. Cramp, Prince Edward Hastings, Mr. Miller, Mr. Preston, Mrs. Smith, Mr. Tilson, Mr. Trost, Mr. Tweed, Mr. Watson, Mr. Albrecht, Mr. Lauzon, Mr. Allen Tobic Mactaquac, Mr. Blaney, Mr. Brownberry, Mr. Brunouge, Mr. Calkins, Mr. Cannon Kelowna Lake Country, Mrs. Davidson, Mr. Fast, Mr. Galibo, Mr. Mays, Mr. Norlock, Mr. Shipley, Mr. Stanton, Mr. Storsett, Mr. Sweet, Mr. Van Kesteren, Mr. Wallace, Mr. Warkentin, Mr. Shear, Mr. DeVolen, Mr. Clark, Mrs. Block, Mr. Bowen, Mr. Braid, Ms. Brown Newmarket Aurora, Ms. Cadman, Mr. Calandra, Mr. Deckert, Mr. Shorey, Mr. Dreeshen, Mr. Holbach, Ms. Hepner, Mr. Holder, Mr. Lobb, Mr. McColman, Mrs. McLeod, Mrs. O'Neill Gordon, Mr. Payne, Mr. Ratgeber, Mr. Upal, Mr. Richards, Mr. Rickford, Mr. Weston, West Vancouver, Sunshine Coast, Sea to Sky Country, Mr. Weston St. John, Mr. Woodworth, Mr. Armstrong. No.
Mr. Armstrong.
Correction, Mr. Young.
Mr. Young.
Mr. Armstrong.
And then Mr. Armstrong.
Monsieur Généreux.
Monsieur Généreux.
Monsieur Arthur.
Monsieur Arthur. Yeas pour 145, 145. Nays contre 143, 143.
I declare the amendment carried.
The next question is on the main motion as amended. The question is as follows. Mr. Desange, seconded by Mr. Cotler, move that, given the undisputed. May I dispense? Thank you. Is it the pleasure of the House to adopt the motion as amended? All those in favor? Oh, the Honourable Chief Government Whip is rising on a point of order.
Mr. Speaker, if you seek it, I believe you'll find agreement to apply the vote from the previous motion to the current motion.
Is there unanimous agreement to proceed in this way? D'accord?
Agreed?
Yes. Then I declare the motion as amended carried. The next question is on the supplementary estimates B. The question is as follows. Mr. Taves, seconded by Mr. Hill, moves that the supplementary estimates B for the fiscal year ending March 31st, 2010 be concurred in. Is it the pleasure of the House to adopt the motion? Agreed? Carried on division? On division. Je déclare la motion adoptée.
Declare the motion carried on division.
Mr. Taves, seconded by Mr. Hill, moves that a bill entitled An Act for Granting to Her Majesty Certain Sums of Money for the Federal Public Administration for the financial year ending March 31st, 2010 be now read a first time and be printed. This motion is deemed adopted.
First reading of this bill, première lecture de ce projet de loi.
Monsieur Taves, appuyé par Monsieur
Taves, seconded by Mr. Hill, moves that the Bill C-64, an act for granting to Her Majesty certain sums of money for the Federal Public Administration for the financial year ending March 31st, 2010, be now read a second time and referred to a committee of the whole. Is it the pleasure of the House to adopt this motion?
Agreed? On division? I declare the motion carried on division.
Second reading of this bill, deuxième lecture de ce projet de loi.
Accordingly, this bill stands referred to a committee of the whole. Je quitte maintenant le fauteuil.
Will now leave the chair for the House to constitute itself as committee of the whole.
Order. La Chambre en comité.
The House in committee of the whole on Bill C-64.
Consideration of the supply bill. Does the honourable member for St. John Southmount Pearl wish to ask the usual question to the President of the Treasury Board?
I would like to ask the President of the Treasury Board if the bill is in its usual form.
The Honourable President of the Treasury Board.
Mr. Speaker, I can assure the member that the form of the bill is essentially the same as that passed in the previous supply period.
Shall Clause 2 carry? On division, carried on division. Shall Clause 3 carry? On division, carried on division. L'article 4 est-il adopté?
Shall Clause 4 carry? On division, carried. Shall Clause 5 carry? On division, carried.
6 carry. On division, carried on division. Shall Clause 7 carry? On division, carried on division. L'annexe 1 est-elle...
Shall Schedule 1 carry? Carried on division.
Est-elle adoptée?
Shall Schedule 2 carry? Carried on division.
Carry. On division, carried on division. Shall the preamble carry? On division, carried on division. Shall the title carry? On division, carried on division. Le projet de loi est-il adopté?
Shall the bill carry? On division?
Shall I rise and report the bill? Mr. Speaker, the Committee of the Whole has considered Bill C-64 and has directed me to report the same without amendment.
Already. Mr. Taves, seconded by Mr. Hill, moves that Bill C-64, an act for granting to Her Majesty certain sums of money for the federal public administration for the financial year ending March 31st, 2010, be concurred in at the report stage. Plaît-il à la Chambre?
Is it the pleasure of the House to adopt the motion?
D'accord.
Agreed? Agreed. I declare the motion adopted on division.
When shall the bill be read a third time? Now. Monsieur Taves.
Mr. Taves, seconded by Mr. Hill, moves that Bill C-64 for estimates for the fiscal year from ending March 31st, 2010 be now read a third time and adopted. Is it the pleasure of the House to adopt the motion?
No. All those in favor of the motion will please say yay.
All those opposed to the motion, please say nay.
À mon avis,
in my opinion, the yeas have it.
All those in favor of the motion will please rise.
Mr. Harper.
Mr. Harper.
Mr. Fletcher. Mr. Thompson. Ms. Ambrose. Ms. Oda. Mr. Vanlo. Mr. Taves. Mr. Day. Mr. Nicholson. Mr. McKay Central Nova. Mr. Cannon Pontiac. Mr. Flaherty. Mr. Clement. Mr. Straw. Mr. Baird. Ms. Finley. Mr. Ritz. Mrs. Shea. Mr. Kenny, Calgary Southeast.
Mr. Kenny, Calgary Southeast.
Mr. Moore, Port Moody, Westwood, Port Coquitlam.
Mr. Moore, Port Moody, Westwood, Port Coquitlam.
Mr. Paradis. Mrs. Aglukat. Mr. Blackburn. Mr. Abbott. Mr. Duncan, Vancouver Island North.
Mr. Duncan, Vancouver Island North.
Mr. Richardson.
Mr.
Benoit.
Mr.
Bright Price.
Mr.
Lake.
Mr.
Katie, South Shore, St. Margaret.
St. Margaret.
Mr. Warwa.
Mr.
Mackenzie. Mr. Goodyear. Mr. Merrifield. Mrs. Yelich. Madame Werner. Mr. Hill. Mr. O'Connor. Ms. Rape. Mrs. Oblonski. Mrs. Georges. Mr. Lebel. Mr. Ashfield. Mr. Lunn. Mr. Menzies. Mr. Camp, Pitt Meadows, Maple Ridge Mission. Mr. Dykstra. Mr. Del Mastro. Mr. Gould. Mr. Carey. Mr. Cummins. Mr. Harris, Caribou, Prince George. Mr. Anders. Mr. Casson. Mr. Goldring. Mr. Bernier. Mr. Chong. Mr. Kerr. Mr. O'Brien. Mr. Moore Fundy Royal. Mr. Petit. Mr. Han. Mr. Poilievre. Mr. Lukiski. Mrs. Wong. Mrs. Glover. Madame Boucher. Mr. Anderson. Mr. Jean. Mr. Komarnicki. Mr. Lemieux. Mr. Saxton. Mr. Velicott. Mrs. Gallant. Mr. Lunny. Mr. Rajat. Mr. Reed. Mr. Sorensen. Mr. Schellenberger. Mr. Allison. Mr. Bazan. Mr. Brown-Leeds Granville. Mrs. Greywall. Mr. Hebert. Mr. Cramp, Prince Edward Hastings. Mr. Miller. Mr. Preston. Mrs. Smith. Mr. Tilson. Mr. Trost. Mr. Tweed. Mr. Watson. Mr. Albrecht. Mr. Lauzon. Mr. Allen Tobic Mactaquac. Mr. Blaney. Mr. Brownberry. Mr. Brenou. Mr. Calkins. Mr. Cannon, Kelowna Lake Country. Mrs. Davidson. Mr. Fast. Mr. Galipo. Mr. Mays. Mr. Norlock. Mr. Shipley. Mr. Stanton. Mr. Storseth. Mr. Sweet. Mr. Van Kesteren. Mr. Wallace. Mr. Walkington. Mr. Scheer, Mr. DeVolen, Mr. Clark, Mrs. Block, Mr. Bowen, Mr. Braid, Ms. Brown Newmarket Aurora, Ms. Cadman, Mr. Calandra, Mr. Deckert, Mr. Shorey, Mr. Dreesen, Mr. Hoback, Ms. Hepner, Mr. Holder, Mr. Lobb, Mr. McColman, Mrs. McLeod, Mrs. O'Neill Gordon, Mr. Payne, Mr. Rathgaber, Mr. Upal, Mr. Richard, Mr. Rickford, Mr. Weston, West Vancouver, Sunshine Coast, Sea to Sky Country, Mr. Weston St. John, Mr. Woodworth, Mr. Young, Mr. Armstrong, Monsieur Généreux, Mr. Ignatia, Monsieur Dion, Mr. McCauley, Mr. Valpe, Mr. Bevilacqua, Mr. Easter, Ms. Fry, Ms. Mina, Mr. Goodale, Mr. Regan, Mr. Bélanger, Mr. Byrne, Mr. Lee, Ms. Bennett, Mr. Bryson, Mr. McCallum,
Mr. McCallum,
Mr. Dosange,
Mr. Dosange,
Mr. Dryden,
Mr. Dryden,
Mr. Malley,
Mr. Malley,
Madame Jennings,
Madame
Mr.
Jennings,
Cosner,
Mr. Cosner,
Mr. Proux,
Mr. Proux,
Mr. Martin Esquimalt Juan de Fuca,
Mr. Martin Esquimalt Juan de Fuca,
Mr. McTague,
Mr. McTague,
Mr. Petrie,
Mr.
Mr. Zabo,
Mr. Zabo,
Madame Folco,
Madame Folco,
Mr. McKay Scarborough Guildwood,
Mr. Scarborough Guildwood,
Mr. Wilford,
Mr. Wilford,
Mr. Bagnall,
Mr. Bagnall,
Mr. Iking,
Mr. Iking,
Mr. Murphy Charlottetown,
Mr. Murphy Charlottetown,
Mr. Tonks,
Mr. Tonks,
Mr. Pachetti,
Pachetti,
Mr. Baines,
Baines,
Mr. Damour,
Mr. Damour,
Ms. Dalla,
Dalla,
Mr. Holland, Mr. McGinty, Ms. Ratansi, Mr. Rota, Mr. Savage, Mr. Scarpalegia, Mr. Silva, Mr. Sims, Mr. Russell, Mr. Dallywall, Mr. Murphy, Moncton Riverview Dieppe,
Murphy, Mountain Riverview, DF,
Mr. Pearson,
Pearson,
Ms. Hall Finley,
Paul Finley,
Ms. Murray,
Ms. Murray,
Mr. Andrews, Ms. Cody, Mrs. Crombie, Ms. Duncan Etobicoke North,
Ms. Duncan and Etobicoke North,
Ms. Foote, Mr. Garneau, Mr. Kenya, Mr. Kennedy, Madame Mendez, Mrs. Simpson, Mr. Trudeau, Mr. Valeria, Madame Zarak,
Madame Zarak,
Mr. Layton,
Mr. Layton,
Monsieur Mulcair,
Mr. Mulcair,
Ms. Davies, Vancouver East,
Ms. Davies, Vancouver East,
Ms. Wajili Solis,
Ms. Rosalie Solis,
Mr. Massey,
Mr. Massey,
Mr. Harris St. John's
Mr.
East,
Harris St. John's East,
Mr. Martin Sault Ste. Marie,
Mr. Martin Sault Ste. Marie,
Mr. Godin,
Mr. Godin,
Mr. Comartin,
Mr. Comartin,
Ms. Crowder,
Ms. Crowder,
Mr. Christopherson,
Mr. Christopherson,
Mr. Angus,
Mr. Angus,
Mr. Julian,
Mr. Julian,
Mr. Charlton,
Mr. Charlton,
Mr. Cullen,
Mr. Cullen,
Mr. Sixay,
Mr. Sixay,
Ms. Matheson,
Ms. Matheson,
Mr. Bevington,
Mr. Bevington,
Madame Savoy,
Madame Savoy,
Mr. Dewar,
Mr. Dewar,
Mr. Malloway,
Mr. Malloway,
Mr. Allen Welland,
Mr. Allen Welland,
Ms. Ashton,
Ms. Ashton,
Mr. Atamanenko,
Mr. Adamanenko,
Mr. Donnelly,
Mr. Donnelly,
Ms. Duncan Edmonton Strathcona,
Ms. Duncan Edmonton Strathcona,
Monsieur Gravel,
Mr. Gravel,
Madame Hughes,
Madame Hughes,
Mr. Stoffer,
Mr. Stoffer,
Mr. Marston,
Mr. Marston,
Ms. Chow,
Ms. Chow,
Mr. Martin Winnipeg Center,
Mr. Martin Winnipeg Center,
Mr. Thibault,
Mr. Thibault,
Ms. Leslie,
Ms. Leslie,
Mr. Rafferty,
Mr. Rafferty,
Monsieur Arthur.
Monsieur Arthur.
All those opposed to the motion, please rise.
Monsieur Duceppe,
Monsieur Laframboise, Monsieur Laforêt, Monsieur Paquette,
Monsieur Paquette,
Madame Lalonde,
Madame Lalonde,
Monsieur Bachan,
Monsieur Bachan,
Monsieur Bigras,
Monsieur Bigras,
Monsieur Ménard,
Monsieur Ménard,
Monsieur Bouchard,
Monsieur Bouchard,
Monsieur Lessard,
Monsieur Lessard,
Monsieur Roy,
Monsieur Roy,
Madame de Bellefeuille,
Madame de Bellefeuille,
Monsieur Guimond Montmorency, Charlevoix, Haute-Côte-Nord,
Monsieur Guimond, Montmorency, Charlevoix, Haute-Côte-Nord,
Madame Gagnon,
Madame Gagnon,
Monsieur Lemay,
Monsieur Lemay,
Madame Brunel,
Brunel,
Madame Gay,
Madame Gay,
Madame Bourgeois,
Bourgeois,
Madame Demers,
Madame Demers,
Monsieur Blais,
Monsieur Blais,
Monsieur Bellavance,
Monsieur Bellavance,
Monsieur Cardin,
Monsieur Cardin,
Madame Faye,
Faye,
Madame Lavallée,
Madame Lavallée,
Monsieur Plamondon,
Monsieur Plamondon,
Madame Freeman,
Madame Freeman,
Monsieur Saint-Cyr,
Monsieur Saint-Cyr,
Monsieur Malo,
Monsieur Malo,
Monsieur Nadeau,
Monsieur Nadeau,
Monsieur Lévesque,
Monsieur Lévesque,
Monsieur Asselin,
Monsieur Asselin,
Monsieur André,
Monsieur André,
Madame Mourani,
Madame Mourani,
Monsieur Godet,
Monsieur Godet,
Madame Deschamps,
Madame Deschamps,
Madame Bonsan,
Madame Bonsan,
Monsieur Vincent,
Monsieur Vincent,
Madame Tillac,
Madame Tillac,
Monsieur Dufour,
Dufour,
Monsieur Ouellet,
Monsieur Ouellet,
Monsieur Pomerleau,
Monsieur Pomerleau,
Monsieur Guimond, Rimouskinet, Témiscouata, les Basses,
Monsieur Guimond, Rimouskinet, Témiscouata, les Basses,
Monsieur Payet, Louis Hébert,
Monsieur Payet, Louis Hébert,
Monsieur Dorion,
Monsieur Dorion,
Monsieur Payet, Hochelaga,
Monsieur Payet, Hochelaga,
Madame Baudin,
Madame Baudin,
Monsieur Desnoyers.
Monsieur Desnoyers. Yes pour 242, 242. Nays contre 47, 47.
I declare the motion adopted.
Troisième lecture de ce projet de loi.
The Honourable Minister of National Defence is rising on a point of order.
Mr. Speaker, in the spirit of Christmas, I want to admit that I was in the area behind my desk speaking to the Prime Minister when the vote was taken, so you may hear something from members opposite about that, but I'll leave it up to your discretion. Ho, ho, ho.
Ho, ho, ho. The Honourable Member for Guelph is rising on a point of order.
Mr. Speaker, I know that the Minister of Defence has had a very difficult week,
But if you apply the same rule that you applied a few short days ago, Mr. Speaker, I feel compelled to bring to your attention that he was not in his own seat either before or during the last vote. And I believe, Mr. Speaker, that his vote should not be counted.
Well, it sounded like there might have been a true confession from the minister before, and now a suggestion or accusation or whatever from the honourable member for Guelph, who had a rough experience, I know, the other day on this. In those circumstances, perhaps we'll amend the journals and exclude the honourable minister's vote in this case, but it won't change the result in terms of the adoption of the bill, which will be much to everyone's relief. Now, so the bill has been passed. The Honourable Minister of Human Resources and Skills Development, I understand, has a point of order.
I do, Mr. Speaker. Thank you very much. Mr. Speaker, there have been discussions throughout the afternoon with all parties, and I believe that if you seek it, you'll find unanimous consent for the following motion. That notwithstanding any standing order or usual practice of the House, the question of the third reading motion to C-56 be deemed put, a recorded division deemed requested, and the vote taken now. And when the House adjourns today, it shall stand adjourned until Monday, January 25th, 2010, provided that, for the purposes of Standing Order 28, it shall be deemed to have sat on Friday, December 11th, 2009, and que la Chambre demande
that the House call on the Minister of Human Resources and Skills Development to have the employment insurance system include the new program for self-employed workers to be included, and that a breakdown be given by province, and that the House provide the information necessary and receive information on the premiums to be paid by self-employed workers, that the Quebec workers not be penalized, that and as the program for self-employed workers calls for, there should be a more detailed report by the Commissioner for Employment Insurance to this effect.
Does the Honourable Minister of Human Resources and Skills Development have the unanimous consent of the House to propose this motion? Agreed? La Chambre l'a entendu.
The House has heard the motion. Is it the pleasure of the House to adopt it?
Okay.
Agreed.
I declare the motion carried. Accordingly, Ms. Finley, seconded by Mr. O'Connor, moved that Bill C-56, an act to amend the Employment Insurance Act and to make consequential amendments to other acts, be now read a third time and do pass. Is it the pleasure of the House to adopt the motion? Yes. Agreed? I declare the motion carried. Let me deal with the bill first.
Third reading of this bill, troisième lecture de ce projet de loi.
The Honourable Chief Government Whip is rising on a point of order.
Mr. Speaker, I think you've already passed the point. We had if you had seek it, you would have found agreement that we would have applied a previous vote to this vote with the Conservatives voting yes.
It was carried unanimously, so there was no need to do any application, I think. What's done's done and can't be undone. Okay. Pursuant to order made on Tuesday, December the 8th, 2009, the House will now proceed to the taking of the deferred recorded division on the motion at third reading stage of Bill C-291 under private members' business. La question est la suivante, Monsieur.
The question is the following. Mr. Saint-Cyr, seconded by Mr. Bicard, moves that Bill C-291, an act to amend the Immigration and Refugee Protection Act, coming into force of sections 110, 111, and 171, be now read a third time and do pass. All those on my left who in favor of the motion, please rise.
Cinquième rangée à ma gauche.
Fifth row on my right, on my left.
Mr. Andrews, Ms. Cody, Mrs. Crombie, Ms. Duncan Etobicoke North, Ms. Foote, Monsieur Garneau, Mr. Kanya, Mr. Kennedy, Madame Mendez, Mrs. Simpson, Monsieur Trudeau, Mr. Valeria, Madame Zarak, Monsieur Dufour, Monsieur Ouellet, Monsieur Pomerleau, Monsieur Guimond, Rimouski-Neigette, Témiscouata-les-Basses, Monsieur Payet-Louis Hébert, Monsieur Dorion, Monsieur Payet-Hochelaga, Madame Baudin, Monsieur Desnoyers, Mr. Donnelly, Ms. Duncan Edmonton Strathcona, Monsieur Gravel, Madame Hughes, Mr. Heyer.
Quatrième rangée à ma gauche.
Fourth row on my left.
Mr. Holland, Mr. McGuinty, Ms. Ratansi, Mr. Rota, Mr. Savage, Mr. Scarpelegia, Mr. Silva, Mr. Sims, Mr. Russell, Mr. Dhaliwal, Mr. Murphy, Moncton Riverview Dieppe, Mr. Pearson, Ms. Hall Finley, Monsieur Lévesque, Monsieur Asselin, Monsieur André, Madame Mourani, Monsieur Godet, Madame Deschamps, Madame Bonsang, Monsieur Vincent, Madame Tillac, Madame Savoie, Mr. Dewar, Mr. Malloway, Mr. Alan Wellen, Ms. Ashton, Mr. Atamanenko.
Third row on my left.
Mr. McTague, Mr. Patry, Mr. Zabo, Madame Folco, Mr. Bagnall, Mr. Iking, Mr. Murphy Charlottetown, Mr. Tonks, Mr. Pachetti, Mr. Baines, Monsieur Damour, Ms. Dalla, Monsieur Blais, Monsieur Bellavance, Monsieur Cardin, Madame Faye, Madame Lavallée, Monsieur Plamondon, Madame Freeman, Monsieur Malo, Monsieur Nadeau, Mr. Julian, Mr. Charlton, Mr. Cullen, Mr. Sixay, Ms. Matheson, Mr. Bevington.
Second row on my left.
Ms. Bennett, Mr. Bryson, Mr. McCallum, Mr. Dosange, Mr. Dryden, Mr. Malley, Madame Jennings, Mr. Cusner, Monsieur Proux, Mr. Martin Esquimalt-Wandafuca, Monsieur Lessard, Monsieur Roy, Madame de Bellefeuille, Monsieur Guimond, Montmorency, Charlevoix, Haute-Côte-Nord, Madame Gagnon, Monsieur Lemay, Madame Brunel, Madame Gay, Madame Bourgeois, Madame Demers. Mr. Martin Sault Ste. Marie, Monsieur Godin, Mr. Comartin, Ms. Crowder, Mr. Christopherson, Mr. Angus.
Premier rangé à ma gauche.
First row on my left.
Mr. Macaulay, Mr. Bevilacqua, Mr. Easter, Ms. Fry, Ms. Mina, Mr. Goodale, Ignatia, Mr. Regan, Monsieur Bélanger, Mr. Byrne, Monsieur Laframboise, Monsieur Laforêt, Monsieur Duceppe, Monsieur Paquette, Madame Lalonde, Monsieur Bachand, Monsieur Bigrat, Monsieur Ménard, Monsieur Bouchard, Monsieur Mulcair, Mr. Davies, correction, Mr. Layton, Ms. Davies, Vancouver East, Ms. Georgie Salis, Mr. Massey, Mr. Harris St. John's East.
Fifth row on my right. Fourth row on my right. Troisième rangée.
Third row on my right.
Deuxième rangée à ma droite.
Second row on my right.
Ms. Leslie, Mr. Rafferty.
First row on my right.
Mr. Marston, Ms. Chow, Mr. Martin Winnipeg Centre.
All those opposed to the motion will please rise. Fifth row on my left. Quatrième rangée à ma gauche.
Fourth row on my left.
À gauche.
Third row on my left.
Second row on my left. First row on my left. Cinquième rangée.
Fifth row on my right.
Mr. Shear.
Mr. Shear.
Mr. DeVolen. Mr. Clark. Mrs. Block. Mr. Bowen. Mr. Braid. Ms. Brown Newmarket Aurora. Ms. Cadman. Mr. Calandra. Mr. Deckard. Mr. Shorey. Mr. Dreeshen. Mr. Hoback. Ms. Hepner. Mr. Holder. Mr. Lobb. Mr. McColman. Mrs. McLeod. Mrs. O'Neill Gordon. Mr. Payne. Mr. Ratgibber. Mr. Upal. Mr. Richards,
Mr. Richards,
Mr. Rickford,
Mr. Rickford,
Mr. Weston, West Vancouver, Sunshine Coast, Sea to Sky Country,
Mr. Weston, West Vancouver, Sunshine Coast, Sea to Sky Country,
Mr. Weston St. John,
Mr. Weston St.
Mr.
John,
Woodworth,
Mr. Woodward,
Mr. Young,
Mr. Young,
Mr. Armstrong,
Mr. Armstrong,
Mr. Généreux,
Mr. Généreux,
Mr. Arthur.
Mr. Arthur.
Fourth row on my right.
Mr. Brownlees Granville,
Mr. Brownlees Granville,
Mrs. Greywall,
Mr. Greywall,
Mr. Hebert,
Mr. Hebert,
Mr. Cramp, Prince Edward Hastings,
Cramp, Prince Edward Hastings,
Mr. Miller,
Mr. Miller,
Mr. Preston,
Mr. Preston,
Mrs. Smith,
Mrs. Smith,
Mr. Tilson, Mr. Trost,
Trost,
Mr. Tweed,
Mr. Tweed,
Mr. Watson,
Mr. Watson,
Mr. Albrecht,
Mr. Albrecht,
Mr. Lauzon,
Mr. Lauzon,
Mr. Allen, Tobic McTaquac,
Mr. Allen Tobic McTaquac,
Mr. Blaney,
Mr. Blaney,
Mr. Brownberry,
Mr. Brownberry,
Mr. Bernouse,
Mr. Bernouse,
Mr. Calkins,
Mr.
Mr. Cannon, Kelowna Lake
Mr.
Country,
Cannon, Kelowna Lake Country,
Mrs. Davidson,
Mrs. Davidson,
Mr. Fast,
Mr. Fast,
Mr. Gallipo,
Mr. Gallipo,
Mr. Mays,
Mr. Mays,
Mr. Norlock,
Mr. Norlock,
Mr. Shipley,
Mr. Shipley,
Mr. Stanton, Mr. Storseth, Mr. Sweet,
Mr. Sweet,
Mr. Van Kesteren, Mr. Wallace, Mr. Warkington,
Mr. Warkington.
Troisième rangée à ma droite.
Mr. Anderson,
Third row on my right.
Mr. Goldring, Mr. Bernier, Mr. Chong, Mr. Kerr, Mr. O'Brien, Mr. Moore Fundy Royal,
Moore Fundy Royal,
Mr. Petit, Mr. Hahn, Mr. Poiliev, Mr. Lekiski, Mrs. Wong, Mrs. Glover, Madame Boucher, Mr. Anderson, Mr. Jean, Mr. Komarnicki, Mr. Lemieux, Mr. Saxton, Mr. Velicott, Mrs. Gallant, Mr. Lunny, Mr. Rajat, Mr. Reed, Mr. Sorensen, Mr. Schellenberger, Mr. Allison, Mr. Bazan,
The second row on my right.
Mr. Richardson, Mr. Benoit, Mr. Brightbright, Mr. Lake, Mr. Keddy, South Shore St. Margaret, Mr. Warwa, Mr. Mackenzie, Mr. Goodyear, Mr. Merrifield, Mrs. Yelich, Madame Werner, Mr. Hill, Mr. O'Connor, Ms. Raitt, Mrs. Oblonsky, Mrs. Georges, Mr. Lebel, Mr. Ashfield, Mr. Lunn, Mr. Menzies, Mr. Camp Meadows Maple Ridge Mission, Mr. Dykstra, Mr. Del Mastro, Mr. Gould, Mr. Carey, Mr. Cummins, Mr. Harris, Caribou, Prince George,
First row on my right.
Mr. Fletcher, Mr. Thompson, Ms. Ambrose, Ms. Oda, Mr. Van Loan, Mr. Taves, Mr. Day, Mr. Nicholson, Mr. McKay Central Nova, Mr. Harper, Mr. Cannon Pontiac, Mr. Flaherty, Mr. Clement, Mr. Straw, Mr. Baird, Ms. Finley, Mr. Ritz, Mrs. Shea, Mr. Kenny, Calgary Southeast, Mr. Moore, Port Moody, Westwood, Port Coquitlam, Mr. Paradis, Mrs. Aglukat, Mr. Blackburn, Mr. Abbott, Mr. Duncan, Vancouver Island North,
Yeas pour 143, 143. Nays contre 143, 143.
The honourable member for Sackville, Musquodoboit Valley is rising on a Sackville Eastern Shore is rising on a point of order.
Yes, sir. This won't change the vote at all, sir. But I believe if you check the official record, the clerks inadvertently had named me the member for Thunder Bay Superior North. And although he is much better looking than I am and much more intelligent, but my actual name is Mr. Stopper, they just made a slight error on that, sir. I'd like it recorded officially. Thank you.
Because the correction had been noted when the voting was done, and accordingly the member was counted correctly, I'm told. Maintenant nous avons.
We now have a tied vote on a third reading a motion for a bill that proposes amendments to other pieces of legislation. Despite the fact that I have a great deal of experience with votes, this is the first time that we face this situation at third reading.
I'm going to go with practice that I believe is normal for speakers, and that is to vote in favor of the status quo, which is for no change in the law, and accordingly I will vote against third reading of this bill, and I declare the motion defeated. Pursuant to order made... Order. Before I put the question on the last motion, since there might be a little noise in the chamber at the conclusion of the vote when things have completed, I just wish to wish all honourable members the very best for the Christmas season.
Best wishes for a good year in 2010. We'll be back together on January 25th, and I eagerly wait for the opportunities to see you back in January.
2009, the House will now proceed to the taking of the deferred recorded division on the motion to concur in the 8th report of the Standing Committee on Fisheries and Oceans. The question is the following one. Mr. Burns, seconded by Mr. Sims, moves que le 8e rapport du Comité permanent
that the 8th report of the Standing Committee on Fisheries and Oceans presented on Wednesday, November 18th, 2009 be conferred in.
I guess we better, fifth row on my left.
No.
Sorry? For all those in favor of the motion will please rise. The Chief Government Whip is rising on a point of order.
Mr. Speaker, if you seek it, I think you'll find unanimous agreement to apply the votes from a previous motion to this motion, with the Conservatives voting no.
Is there unanimous consent to proceed in this way? No, there's no consent. All right. So. Okay. All those in favor of the motion will please rise.
Mr. Ignacio.
Mr. Ignacio.
It's a motion for concurrence, so we'll vote as normal by party, I am told. So away we go.
Welcome back to Canada.
Mr. Dion.
Mr. Dion.
Mr. McCauley. Mr. Volpe. Mr. Bevilacqua. Mr. Easter. Ms. Fry. Ms. Mina. Mr. Goodale. Mr. Regan. Mr. Bélanger. Mr. Burns. Mr. Lee. Ms. Bennett. Mr. Bryson. Ms. Groh. Mr. McCallum. Mr. Dosange. Mr. Dryden. Mr. Malley. Madame Jennings. Mr. Cuzner. Monsieur Proux. Mr. Martin Esquimalt-Wandefuka. Mr. McTague. Monsieur Petrie. Mr. Zabo. Madame Folco. Mr. McKay Scarborough Guildwood. Mr. Wilford. Mr. Bagnall. Mr. Iking. Mr. Murphy Charlottetown. Mr. Tonks. Mr. Pachetti. Mr. Baines. Mr. Damour. Ms. Dalla. Mr. Holland. Mr. McGinty. Ms. Ratansi. Mr. Rota. Mr. Savage. Mr. Scarpelegia. Mr. Silva. Mr. Sims. Mr. Russell. Mr. Deliwal. Mr. Murphy, Moncton Riverview Dieppe. Mr. Pearson. Ms. Hall Finley. Ms. Murray. Mr. Andrews. Ms. Cody. Mrs. Crombie. Ms. Duncan Etobicoke North. Ms. Foote. Mr. Garneau. Mr. Kanya. Mr. Kennedy. Madame Mendez. Mrs. Simpson. Madame Zarak. Back to Monsieur Trudeau. And Mr. Valeria. Monsieur Duceppe. Monsieur Laframboise. Monsieur Laforêt. Monsieur Paquet. Madame Lalonde. Monsieur Bachand. Monsieur Bigra. Monsieur Ménard. Monsieur Bouchard. Monsieur Roy. De retour à Monsieur Lessard.
Monsieur Lessard et ensuite Monsieur Roy.
Madame de Bellefeuille.
Madame de Bellefeuille.
Monsieur Guimond, Montmorency, Charlevoix, Haute-Côte-Nord.
Monsieur Guimond, Montmorency, Charlevoix, Haute-Côte-Nord.
Madame Gagnon.
Madame Gagnon.
Monsieur Lemay.
Monsieur Lemay.
Madame Brunel.
Madame Brunel.
Madame Gay.
Madame Gay.
Madame Bourgeois.
Madame Bourgeois.
Madame Demers.
Madame Demers.
Monsieur Blais.
Monsieur Blais.
Monsieur Bellavance.
Monsieur Bellavance.
Monsieur Cardin.
Monsieur Cardin.
Madame Faye.
Madame
Lavallée.
Madame Lavallée.
Monsieur Plamondon.
Monsieur Plamondon.
Madame Freeman.
Madame Freeman.
Monsieur Saint-Cyr.
Monsieur Saint-Cyr.
Monsieur Malo.
Monsieur Malo.
Monsieur Nadeau.
Monsieur Nadeau.
Monsieur Lévesque.
Monsieur Lévesque.
Asselin.
Monsieur Asselin.
Monsieur André.
Monsieur André.
Madame Mourani.
Madame Mourani.
Monsieur Godet.
Monsieur Godet.
Madame Deschamps.
Madame Deschamps.
Madame Bonsant.
Madame Bonsant.
Monsieur Vincent.
Monsieur Vincent.
Madame Tillac.
Madame Tillac.
Monsieur Dufour.
Monsieur Dufour.
Monsieur Ouellet.
Monsieur Ouellet.
Monsieur Pomerleau.
Monsieur Pomerleau.
Monsieur Guimond, Rimouski-Neigette et Misquata-les-Basses.
Monsieur Guimond, Rimouski-Neigette et Misquata-les-Basses.
Monsieur Paillé-Louis Hébert.
Monsieur Paillé, Louis Hébert.
Monsieur Dorion.
Monsieur Dorion.
Monsieur Paillé-Hochelaga.
Monsieur Paillé-Hochelaga.
Madame Baudin.
Madame Baudin.
Monsieur Desnoyers.
Monsieur Desnoyers.
Mr. Layton.
Mr. Layton.
Monsieur Mulcair.
Mulcair.
Ms. Davies, Vancouver
Ms.
East.
Davies, Vancouver East.
Ms. Wajili Solis.
Wazali Solis.
Mr. Massey.
Mr. Massey.
Mr. Harris, St. John's
Mr.
East.
Harris, St. John's East.
Mr. Martin, Sault Ste. Marie.
Mr. Martin, Sault Ste. Marie.
Mr. Godin.
Mr. Godin.
Mr. Comartin.
Mr. Comartin.
Ms. Crowder.
Ms. Crowder.
Mr. Christopherson. Mr. Angus.
Mr. Angus.
Mr. Julian.
Mr. Julian.
Ms. Charlton.
Ms. Charlton.
Mr. Cullen.
Mr. Cullen.
Mr. Sixay.
Sixay.
Ms. Matheson.
Ms. Matheson.
Mr. Bevington.
Bevington.
Madame Savoie.
Madame Savoie.
Mr. Dewar.
Mr. Dewar.
Mr. Malloway.
Mr. Malloway.
Mr. Alan Wellen.
Mr. Alan Wellen.
Ms. Ashton.
Ms. Ashton.
Mr. Atamanenko.
Mr. Adamanenko.
Mr. Donnelly.
Mr. Donnelly.
Ms. Duncan Edmonton Strathcona.
Ms. Duncan Edmonton Strathcona.
Mr. Gravel.
Mr. Gravel.
Madame Hughes.
Madame Hughes.
Mr. Stauffer.
Mr. Stauffer.
Mr. Marston.
Mr. Marston.
Ms. Chow.
Ms. Chow.
Mr. Martin Winnipeg Centre.
Mr. Martin Winnipeg Centre.
Mr. Thibault.
Mr. Thibault.
Ms. Leslie.
Ms. Leslie.
Mr. Rafferty.
Mr. Rafferty.
All those opposed to the motion will please rise.
Mr. Harper.
Mr. Harper.
Mr. Fletcher.
Mr. Fletcher.
Mr. Thompson. Ms. Ambrose. Ms. Oda. Mr. Van Loan. Mr. Taves. Mr. Day. Mr. Nicholson. Mr. McKay Central Nova.
McKay Central Nova.
Mr. Cannon Pontiac.
Mr. Cannon
Mr.
Pontiac.
Flaherty.
Mr. Flaherty.
Mr. Clement.
Mr. Clement.
Mr. Straw.
Mr. Straw.
Mr. Baird.
Mr. Baird.
Ms. Finley.
Ms.
Mr. Ritz.
Mr. Ritz.
Mrs. Shea.
Mrs. Shea.
Mr. Kenny, Calgary Southeast.
Calgary Southeast.
Mr. Moore, Port Moody, Westwood, Port
Mr.
Coquitlam.
Moore, Port Moody, Westwood, Port
Monsieur
Coquitlam.
Paradis.
Mr. Paradis.
Mrs. Aglukat.
Mrs. Aglukat.
Monsieur Blackburn.
Mr. Blackburn.
Mr. Abbott.
Mr. Abbott.
Mr. Duncan, Vancouver Island North.
Mr. Duncan, Vancouver Island North.
Mr. Richardson.
Mr. Richardson.
Mr. Benoit.
Mr. Benoit.
Mr. Brightprice.
Mr. Brightprice.
Mr. Kevy, South Shore, St. Margaret.
Mr. Keddy, South Shore, St. Margaret's.
Mr. Warwa.
Mr. Warwa.
Mr. Mackenzie.
Mr. Mackenzie.
Mr. Goodyear.
Mr. Goodyear.
Mr. Merrifield.
Mr. Merrifield.
Mrs. Yelich.
Mrs. Yelich.
Madame Werner.
Madame Werner.
Mr. Hill.
Mr. Hill.
Mr. O'Connor.
Mr.
Ms. Raitt.
Ms. Raitt.
Mrs. Oblonsky.
Mrs. Oblonsky.
Mrs. Georges.
Ms. Georges.
Mr. Lebel.
Mr. Lebel.
Mr. Ashfield.
Mr. Ashfield.
Mr. Lunn.
Mr. Lunn.
Mr. Menzies.
Mr. Menzies.
Mr. Camp, Pitt Meadows, Nipper Ridge Mission.
Mr. Camp, Pitt Meadows, Maple Ridge Mission.
Mr. Dykstra.
Mr. Dykstra.
Mr. Del Mastro.
Del Mastro.
Monsieur Gourde.
Monsieur Gourde.
Mr. Carey.
Mr. Carey.
Mr. Cummins.
Mr. Cummins.
Mr. Harris, Caribou, Prince George.
Mr. Harris, Caribou, Prince
Mr.
George.
Anders.
Mr. Anders.
Mr. Casson.
Mr. Casson.
Mr. Goldring.
Mr. Goldring.
Monsieur Bernier.
Mr. Bernier.
Mr. Chong.
Mr. Chong.
Mr. Kerr.
Mr. Kerr.
O'Brien.
Mr. O'Brien.
Mr. Moore, Fundy Royal.
Mr. Moore, Fundy Royal.
Monsieur Petit.
Mr. Petit.
Mr. Hahn.
Mr. Hahn.
Monsieur Poilievre.
Mr.
Mr.
Poilievre.
Lekiski.
Mr. Lekiski.
Mrs. Wong.
Mrs. Wong.
Mrs. Glover.
Mrs. Glover.
Madame Boucher.
Madame Boucher.
Mr. Anderson.
Mr. Anderson.
Mr. Jean.
Mr. Jean.
Mr. Komarniki.
Mr. Komarniki.
Monsieur Lemieux.
Mr. Lemieux.
Mr. Saxton.
Mr. Saxton.
Mr. Velicott.
Mr. Velicott.
Mrs. Gallant.
Mrs. Gallant.
Mr. Lunny.
Mr. Lunny.
Mr. Rajat.
Mr. Rajat.
Mr. Reed.
Mr. Reed.
Mr. Sorensen. Mr. Schellenberger. Mr. Allison. Mr. Bazan.
Mr. Bazan.
Mr. Brown, Leeds Granville.
Mr. Brown, Leeds
Mrs.
Granville.
Greywall.
Mrs. Greywall.
Mr. Hebert.
Mr. Hebert.
Mr. Cramp, Prince Edward Hastings.
Cramp, Prince Edward Hastings.
Mr. Miller.
Mr. Miller.
Mr. Preston.
Mr. Preston.
Mrs. Smith.
Mrs. Smith.
Mr. Tilson. Mr. Trost.
Mr. Trost.
Mr. Tweed.
Mr. Tweed.
Mr. Watson.
Mr. Watson.
Mr. Albrecht.
Mr. Albrecht.
Monsieur Lauzon.
Mr. Lauzon.
Mr. Allen, Tobic McTaquac.
Mr. Allen to Big Mactaquac.
Monsieur Blaney.
Mr. Blaney.
Mr. Brownberry.
Mr. Brownberry.
Mr. Brenoud.
Mr. Brenoud.
Mr. Calkins. Mr. Cannon, Kelowna Lake Country.
Cannon, Kelowna Lake Country.
Mrs. Davidson.
Mrs. Davidson.
Mr. Fast.
Mr. Fast.
Monsieur Galipo.
Mr. Galipo.
Mr. Mays.
Mr. Mays.
Mr. Norlock.
Mr. Norlock.
Mr. Shipley.
Mr. Shipley.
Mr. Stanton.
Mr.
Mr. Sorsta.
Mr. Storsa.
Mr. Sweet.
Mr.
Mr. Van Kester.
Mr. Van Kester.
Mr. Wallace.
Mr. Wallace.
Mr. Walkington.
Mr. Workington.
Mr. Scheer, Mr. Volan, Mr. Clark, Mrs. Block, Mr. Bowen, Mr. Braid, Ms. Brown Newmarket Aurora, Ms. Cadman, Mr. Calandra, Mr. Deckert, Mr. Shorey, Mr. Dreeshen, Mr. Hobart, Ms. Hefner, Mr. Holder, Mr. Lobb, Mr. McColman, Mrs. McLeod, Mrs. O'Neill Gordon, Mr. Payne, Mr. Rathgaber, Mr. Upal, Mr. Richards, Mr. Rickford, Mr. Weston, West Vancouver, Sunshine Coast, City Sky Country, Mr. Weston St. John, Mr. Woodworth, Mr. Young, Mr. Armstrong, Monsieur Généreux, Monsieur Arthur.
Yeas pour 147, 147. Nays contre 142, 142.
Je déclare la motion.
I declare the motion carried.
Government House Leader is rising on a point of order. Order.
Thank you, Mr. Speaker. Mr. Speaker, one final point of order. Mr. Speaker, given the House is rising tonight and therefore the notice paper is unlikely to be published until the new year, I wish to inform colleagues in the House that the Minister of Labour gave notice of a bill today entitled An Act to Ensure Economic Success in British Columbia Ports Through Labour Stability. Thank you, Mr. Speaker. And Merry Christmas.
Order, it being, the House will now proceed to the consideration of private members' business as listed on today's order paper.
Private members' business, private members' bill, considération à l'étape de la deuxième lecture du projet de loi C-343.
Second reading of Bill C-343, an act to amend the Canada Labour Code.
Au nom de Madame Bonsan.
Standing in the name of Madame Bonsan.
Order. Order. Madame Bonson.
Ms. Bonson, seconded by Mr. Lissa, moves that Bill C-343, an act to amend the Canada Labour Code and the Employment Insurance Act, Family Leave, be now read a second time and referred to the Standing Committee on Human Resources, Skills and Social Development, and the Status of Persons with Disabilities. Debate. The Honourable Member.
The Parliamentary Secretary is rising on a point of order.
Thank you, Mr. Speaker. Mr. Speaker, on November 6, 2009, the Speaker made a statement with respect to the management of private members' business. In particular, the Speaker raised concerns about Bill C-343, an act to amend the Canada Labour Code and the Employment Insurance Act, Family Leave, which in the Speaker's view appeared to impinge on the financial prerogative of the Crown. Without commenting on the merits of the bill, I submit that Bill C-343 would add a new purpose to the Employment Insurance Act, which would require new spending and therefore would require a royal recommendation. Let me explain, Mr. Speaker, how the bill would require new spending. Bill C-343 would amend the Canada Labour Code to allow employees to take unpaid leave from work for 4 family-related reasons. First, the inability of their minor child to carry on regular activities because the child suffers a serious physical injury as a result of a criminal offense. Second, the disappearance of their minor child. Third, the suicide of their spouse, common-law partner, or child. Or fourth, the death of their spouse, common-law partner, or child as a direct result of a criminal offense. Bill C-343 would then change the Employment Insurance Act to allow all EI-eligible employees to receive up to 52 weeks of EI benefits when they take the proposed new family leave under the Canada Labour Code. As a result, Mr. Speaker, the EI benefit contemplated in C-343 would add a new purpose that is not currently authorized in the Employment Insurance Act, which would require new government spending. The Department of Human Resources and Skills Development estimates that Bill C-343 would cost the government between $340 and $410 million per year, depending on the level of criminal activity in the country. Precedents demonstrate that legislation for new spending for EI benefits not currently authorized under the Employment Insurance Act requires a royal recommendation. On November 6, 2006, the Speaker ruled in the case of Bill C-269, an act to amend the Employment Insurance Act, improvement of the employment insurance system, that, and I quote, Bill C-269 extends coverage of the employment insurance plan to the self-employed. New purposes must be accompanied by a new royal recommendation. I must rule that Bill C-269 requires a royal recommendation, end quote. Mr. Speaker, Bill C-343 would add a new purpose to the Employment Insurance Act, which is not currently authorized and should therefore be accompanied by a royal recommendation. Thank you, Mr. Speaker.
The Chair will take the Parliamentary Secretary's submission under advisement. I anticipate there may be others on this matter. At this point, we will resume debate. Reprise le débat.
Resuming debate. The Honourable Member for Compton-Stanstead. Thank you, Mr. Speaker. We will explain things the way they are. It's with great pride that I present in second reading Bill C-343, an act to amend the Canada Labour Code and the Employment Insurance Act, Family Leave. This bill seeks to amend the Canada Labour Code in order to give unpaid leave from 52 to 104 weeks for employees who have to be absent for one of the following family-related reasons: the inability of their minor child to carry on regular activities because the child suffers a serious physical injury during the commission as the direct result of a criminal offense, the disappearance of their minor child, the suicide of their spouse, common-law partner or child, the death of their spouse, common-law partner or child during the commission or as the direct result of a criminal offense. It also amends the Employment Insurance Act to allow these employees to receive benefits up to 52 weeks instead of 15 weeks currently provided for sick leave. In December 2007, the National Assembly of Quebec was a pioneer in this matter by adopting Bill 58, which provides salaried employees and their families who are victims of crime or who experience family suicide or a disappearance of a child to keep their job for up to 104 weeks. Unfortunately, the federal legislation as it stands creates discrimination toward those whose job is governed by the Canada Labour Code. Indeed, these workers do not have this employment link and can only have sick leave for 15 weeks. Up until now, the lack of action by the legislature creates two categories of workers. On the one hand, those who can have this difficult period while keeping their job, and those who have a choice between going back to work quickly or losing their job. It's one thing to allow people to take leave that allow them to come back under the same conditions, but if they have no income to earn a living, the result is the same. They have no other choice but to go back to work quickly. According to the Bloc Québécois, which has always been concerned with the fate of victims and their loved ones, the federal government must follow in the same vein as Quebec for various reasons. First of all, it's a well-known fact that suicide, violent crime, and disappearance are tragic events that are extremely difficult for the loved ones of the victim. It is the cause of psychological distress for many spouses and parents. There's waiting, grieving, depression that are part and parcel of the daily lives of the families of victims, often over a long period. Indeed, particularly in the case of murders and disappearance, there can be over 2 years between the criminal act and the resolution of the investigation. During that period, the family is very harshly affected. They cannot carry out their daily activities. They need support, aid, and understanding. Especially, they don't need more worries regarding their financial situation. It's terrible to think that they might be abandoned and have to continue to work during this kind of period as if nothing had happened, since they have to support their family like you and I. These people need some respite to get through this trauma and bring them back to work at their pace in a progressive manner. Unfortunately, many cases of murder and disappearance have shaken Quebec in the past few years. For instance, I'm thinking in particular of Cédrica Provencher, Nancy Michaud, Alexandre Livernoche, Julie Surprenant, Julie Boisvenu, Jolene Riendo, and very recently, Natacha Cournoyer. We may also think of the 14 victims of the Polytechnique during this commemorative week, as well as the shooting at Dawson College, where Anastasia de Sousa lost her life. In my own riding of Compton-Stanstead, Isabelle Bolduc was raped and killed in 1996. I've only named a few cases, but it's for the parents, friends, and loved ones of all these families that I'm fighting here today. After all, Mr. Speaker, the families of victims experience anguish, anxiety, and suffering, and other repercussions related to the violent crime, and they're victims too. Whether it's homicide, suicide, or disappearance, the experience is far longer than other forms of grieving, especially when the circumstances of violence or rape have taken place. The feeling of frustration, anger, and impotence come more to the forefront, and this is especially true when this is caused by the criminal or by the victim themselves. In parallel to these situations, there are many citizens who have come up with initiatives in solidarity with these families. In 2004, Quebec families affected by these tragedies came together to create l'Association des familles des personnes assassinées ou disparues, a Quebec organization that helps the families of victims. In first reading, the organization supported our bill enthusiastically. In their hard work to support these families, members of the association observe that they should be able to get through their hardship without financial problems. Since the beginning of the foundation of this association, the government has continued to say that we have to toughen up law and order. For the Reform Party and its successors, this was a priority. They claim loud and clear that they want the welfare and safety of the people and talk about repressing crime. Well, criminals currently have more rights and more attention than the families of victims who have no legal recourse. The measures adopted in the past few months concerning sentences only concentrate on one aspect of this tragedy. The spouses and parents of victims are left by the wayside and forgotten far too often. For this reason, it's not sufficient to fill up our prisons, and we must give concrete help to the families affected. In recognizing this, some members of the Conservative government have said they support the families of victims. The member for Thornhill said it would be a good thing for opposition parties to be as compassionate and worried about the families of victims and the victims themselves than the authors of these crimes, unquote. Moreover, the Minister of Justice and Attorney General for Canada, as well as the Minister for Public Safety, made an official commitment in April 2009 to support the families of victims. And I quote the Minister of Public Safety: "This government agrees that crime imposes a very heavy burden on victims, their families, or the communities and societies as a whole. We need a concerted effort to support victims, and this government is determined to continue to work with our partners to help victims," unquote. This government even initiated a national Victims Awareness Week in 2005 and organized symposiums on that occasion. These kinds of events are not sufficient. If the Conservative government is consistent and logical, it will support this bill unequivocally and turn its words into action for these families. As they say, put your money where your mouth is. If members of this House are opposed to this bill, they will undoubtedly say that these measures would be too expensive for the state because of the extension of EI benefits from 15 to 52 weeks. However, fortunately, this kind of tragic event would be quite rare. People who are eligible for EI through this bill are not numerous. The drop in revenue is not that much of a problem for some families. Others like to go back to work to keep busy. Also, part of the population is not insured by EI or does not work or do not pay enough premiums or do not have enough hours to get benefits. So the total would be more or less $50 million a year. I sat down with a lawyer who told me that when you want an answer to a question, you find the answer before you ask the question. Given the current annual federal budget, this is a minimum expenditure, a drop in the ocean. EI is funded by workers, and this allows these traumatized families to obtain benefits. When you think of the $56 billion EI fund surplus, the low cost of this bill is even more obvious. It's quite clear that if this government is really thinking about victims and their families, it will not hesitate 1 second to vote in favor of this bill. However, if it votes against it, the people will see that this is a message of total indifference toward the families of victims and will remember this for a long time. In closing, Mr. Speaker, I want to salute all the families of victims of criminal acts or suicide and tell them that I and the Bloc Québécois will work very hard to make sure that this bill receives support by a majority of members in this House. I hope that if the members sitting here are affected by the fate of victims and their families, they will proudly rise to vote in favor of this Bill C-343. I went into politics to change things, Mr. Speaker, and I sincerely believe that these measures will provide precious help to families that need it the most. I therefore urge all my colleagues in this House to help these families who depend on such assistance. Questions and comments?
For Elmwood Transcona.
Well, thank you, Mr. Speaker, and I want to congratulate the member for her Bill C 343, which I think is an excellent bill, and certainly our caucus, I believe, will be supporting this bill. But I find it rather interesting that the government would be trying to basically kill this bill through the route of the Royal Rec Challenge. Actually, you know, for a government that pretends to be supportive of the victims, that's what this bill is all about. This bill is all about supporting victims, and here you have a government at the first opportunity to actually do something for victims, basically trying to kill the bill. The bill would amend the Canada Labour Code to allow employees to take unpaid leave from work for the following family-related reasons. Number one, the inability of their minor child to carry on regular activities because the child suffers a serious physical injury during the commission or as a direct result of a criminal offense. And there are three other instances where they would qualify for this. And the government says the cost, they've costed it already, say it's going to be $340 million to $410 million. I'd like to know where they come up with figures like that.
Order. It's a 5-minute question and answer period. If members keep their questions to about a minute, we will have 2 opportunities. Honorable Deputy.
Honourable Member for Compton-Stanstead. I wish to thank my colleague for that question. You know, when it comes to victims and human beings, I think that this Conservative government has forgotten something. It costs about the same as an F-18 aircraft. So I think that these people who've experienced this immeasurable type of trauma, and I'm sure there are people who've known someone who was close to a victim. I worked with a girl whose nephew was the best friend of Alexandre Vernoche. That child was not related to the disappeared child, but he spent a week in hell. These people grieve immensely. I can't believe that a person has to continue to work under circumstances like that. There are their children to take care of, but they have to live somewhere and eat. That's why they need financial support, because it is impossible to work after 15 weeks when you experience such a thing.
Beaches, East York.
Thank you, Mr. Speaker. First of all, I want to commend the honourable member for the bill. It's something that needs to get done. But I just wanted to clarify something for my own sake. The bill has, I think, children and spouses, but not mother and father, and even an individual themselves, if they themselves were attacked. I don't know, a person that, say, may be single in terms of the amount, because under compassionate care, rather sickly, they only get 15 weeks. Here there's potential for getting more, and I've just wondered if there was a reason for leaving out those particular aspects.
Honourable Member for Compton-Stanstead. Now, according to statistics, there are far more young people who disappear than parents who disappear. You have to be careful as well. There are many who are runaways. There are many older people who have Alzheimer's. So this is, I did think of this, but it is something to be considered when we go before the committee, and I thank my colleague for having brought forward this idea, but it is true. We could add that if it's necessary.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Human Resources and Skills Development.
Thank you, Mr. Speaker, and certainly I enjoyed listening to the comments and the intention behind the bill. I thank you for the opportunity to speak on Bill C 343, an act to amend the Canada Labour Code and the Employment Insurance Act. It affects 2 pieces of legislation. All members here certainly sympathize with those whose loved ones have been a victim of violent crime. There's no question about that. It can take a long time for anyone to fully heal from this kind of tragedy. Before discussing what may be the best way to support these victims and their families, I would like to take a moment to sum up the main components of the proposed legislation. Bill C-343 would amend the Canada Labour Code to introduce a new type of unpaid leave known as family leave that would be available to federally regulated employees whose family member has experienced certain kinds of trauma. It would also amend the Employment Insurance Act to provide temporary income support up to 52 weeks, including the 2-week waiting period, to eligible individuals who take this new type of family leave. And it would use a provision of the same act to ensure that premium rates are reduced in provinces where similar income support is provided. In part, Mr. Speaker, the proposed bill seeks to address issues related to victims of violence through the Employment Insurance Program. I should like to note that the Employment Insurance Program already provides some compensation to victims of crime. Specifically, eligible individuals unable to work and undergoing treatment for the psychological effects of bereavement or violent crime may be eligible up to 15 weeks of employment insurance sickness benefits. In this way, the Employment Insurance Program already responds to the needs of Canadians in these difficult circumstances. In limited situations, eligible workers can also access up to 6 weeks of compassionate care benefits. Mr. Speaker, while the EI system plays a very important role providing some income support during absences from work for Canadians, the government recognizes it may not address the needs of all victims in all situations. The proposed changes represent a significant shift to special benefits, and it is not clear that employment insurance is the best instrument to provide income support under these circumstances. In addition to these concerns, the proposed changes have a number of additional concerning implications. The proposal to create family leave does raise some questions with respect to fairness. Not sure whether in making policy in this area, the distinctions and restrictions in this bill will result in a fair outcome. For example, I'm not sure parents of a 17-year-old, parents of a 19-year-old are deserving of substantially different treatment by the EI system. In the painful cases this bill seeks to address, I'm not sure either type of parent would agree that a differential treatment is fair either. And while a little outside of the scope of the bill, I'm concerned that crime is the only thing being addressed here with these changes, and that other painful, tragic events that are no less shocking, unexpected, and difficult to endure, are not being considered. As I said, other events aren't within the scope of the bill, and that's a matter of concern for sure. I will move on, however. It's important to note that most provinces already offer a variety of supports to assist families of victims of crime, such as coverage of medical expenses as well as access to counseling services. 6 provinces even provide compensation for lost wages. Provincial compensation measures also have the advantage of being provided to victims and their families without regard to employment status. Mr. Speaker, managing the employment insurance system is very complex, as we've seen in this House with the various pieces of legislation we've introduced, including the one that just passed today, Bill C-56. Our recent changes were only made after careful consideration and in response to a critical economic situation, and therefore a critical situation for thousands of Canadians and their families. Our most recent proposal for change is to bring access and fairness to self-employed Canadians, as I mentioned, people who have never had access to the special benefits within the EI system before. Right now, because of the global economic situation of the past year and because previous governments used EI premiums for non-EI spending, and the member makes a fair point there, the EI account is under strain. It is estimated that adopting this bill would increase program costs significantly and could result in significant upward pressure on premium rates, something that most don't want. While the length of the bill itself doesn't imply so, these proposed changes are major financial changes to the EI system. As we know from both the existing EI system and the new access to special benefits proposed by a government under Bill C-56, adding another class of people for whom 50 weeks' worth of benefits would be available is a very expensive proposition. I'm certainly not here to say that grief has a price tag or a price ceiling, but that these sorts of changes have consequences that need to be fully considered. Not only is the EI system perhaps not the best vehicle to help in these circumstances, but it is also an expensive way to use the system. Mr. Speaker, it is also important to bear in mind that the Department of Justice provides assistance with respect to issues surrounding victims of violence. It already offers a variety of programs and services, including the Victims Fund and the Ombudsman for Victims of Violence. In fact, in 2007, our government made a $52 million commitment over 4 years to increase services for victims and funding to the provinces for elements of their programs. Finally, Mr. Speaker, our government is also working to better protect Canadians against those who commit serious and violent crimes. In February 2008, the Tackling Violent Crime Act became law. This act strengthens the criminal code in the following 5 ways: mandatory prison sentences for criminals who commit crimes with guns, tougher bail rules to make it easier to keep people accused of serious gun crimes off our streets, a higher age of protection, 16 years old, to protect children from sexual predators, new stronger measures against impaired driving, and more effective sentencing and monitoring to prevent dangerous high-risk offenders from offending again. And these collectively will certainly have an impact in reducing the number of victims. Mr. Speaker, our government is concerned about the impact of violence on all Canadians, and it is taking measures to address these concerns. We always welcome ideas for improvements to programs and services to respond to the needs of victims and their families. However, further consideration is required to determine whether employment insurance is the most suitable income replacement instrument for addressing this issue. Mr. Speaker, I want to assure this House that our government acknowledges the extensive work done by groups engaged in promoting a better understanding of the needs of victims and their families. These include the Murdered or Missing Persons Families Association, which is led by Pierre Hughes Venu. However, we believe that the Canada Labour Code should not be amended in such a piecemeal manner. We strongly believe that adopting a comprehensive approach would enable us to address more efficiently the needs of employees whose family member has been a victim of violent crime, has committed suicide, or whose child has disappeared. For all these reasons, the government cannot support this bill and intends at the appropriate time to move forward on this issue and introduce its own legislation for unpaid leave for victims of crime. I think that area is an important one. I think those issues need to be addressed, but they need to be addressed in a comprehensive manner. They need to be addressed in a comprehensive way. And going through the employment insurance program is not the way to go. The system is not specifically designed for that, and this may not be the time to work through that. As I've said, the government will be introducing legislation and certainly will deal with the issues that have been raised. Thank you very much, Mr. Speaker.
Resuming debate, the Honourable Member for Beaches, East York.
Thank you, Mr. Speaker. I rise tonight glad to speak on Bill C-343, on Act to amend the Canada Labour Code and the Employment Insurance Act for the purpose of family leave. Also, first, Mr. Speaker, I want to say that while I have some areas of concern with the bill, I think there are more things that can be actually addressed as some of the comments I made earlier at committee. So I support sending the bill to committee, and I think that some of those things can actually be addressed at committee as we look at some of the aspects that I'm going to raise today. But definitely, we all understand the crises and the trauma that families can go through and individuals in a time of when a crime is committed, and this is something that victims in this country, we sometimes don't spend a great deal of time paying attention, and this is very critical. The main provisions I noticed as I read the bill, Mr. Speaker, do have mirror to some degree the legislation that already exists in Quebec, and I know the honourable member has obviously taken the information and used the Quebec model to draft her bill, which I believe was a good direction to go. The bill, as we all know, allows employees to take unpaid leave from work for family-related reasons, specifically when there is a criminal offence. And some of these areas, as I think others have mentioned before, and some of the provisions are to allow the minor child to carry on in order to allow the minor child to carry on activities because the child suffers a serious physical injury. Again, the parent could have time off because this would have happened because of a criminal offense. We need to talk about the trauma the family has when these kinds of things happen. We're talking about here the bill, as I mentioned earlier, addresses the spouse and common law partners and the child. Does not, however, mention the mother or father. And I know it wasn't so much referring to issues of Alzheimer's, although that is something that we may want to look at, but certainly acts of crime occur to other members of family at times, and I just wondered why that particular aspect was not mentioned at the time, or is not in the bill at this point. But the bill goes on to cover the things as the death of their spouse, common law partner, as I mentioned earlier, as a result of criminal offense. According to the bill, Mr. Speaker, in the case of a minor child, the child must be under the age of 18. I think that this is what the honourable member was mentioning as a concern, although I think that is a reasonable thing to do. And unpaid leave of up to 104 weeks is granted if the child was injured as a result of a criminal offense and the employee's presence is required by the child. Then there are different timing. The 52 weeks of unpaid leave is granted if a minor child is missing. However, if the child is found, the leave ends at after the 11th day following the return of the child. So there are some parts of the bill which actually sort of take into account different situations and different possible scenarios, and that is helpful. The 104 weeks of unpaid leave is granted if the employee's child, spouse, or common law dies during the commission or the direct result of a criminal offense. So this bill is very much tied to addressing the issue of victims in criminal activity, Mr. Speaker. The employee may not, and the bill is very clear in case anyone is concerned about it, the employee may not benefit from these provisions if it may be inferred from the circumstances that the employee, the deceased person, if that person is the spouse, common law partner, or adult or child, was probably a party to the criminal offense activity. This is, I think, again reflects very close to the provisions in the Quebec legislation, if I'm not mistaken, from having taken a look at it very briefly earlier today. Mr. Speaker, losing a child or a spouse in one of the most difficult circumstances anyone could ever face, and has a traumatic effect on all members of the family. In my writing about, Mr. Speaker, a year ago, on New Year's Day, a young woman by the name of Rangel was killed, stabbed about practically next door to her own home. The mother no one heard her cry because it was late, it was outside. She died on a snowbank, a couple of houses, a couple of doors from her own home. It was a horrible crime, and I still remember going and meeting with the parents and discussing the situation. It was one of those things that no one can ever say. No one can really help. It is not being sorry doesn't cut it. The trauma that the family has gone through and the difficult time, not only the mother and father, but the brother as well, and other members of the family, has been tremendous. So that we all know that victims of a criminal offense face serious injuries require the help and support of their families, and all efforts should be made to ease the challenges in meeting those needs, so that those that are injured but survive need time, not only the family to deal with the trauma, but also the victims themselves and the children or the spouse need time to be able to get back to a normal life and to rebuild their lives. And this is something that is extremely important, because we cannot take for granted our safety, or rather we do take our safety for granted sometimes, but we all know that when it hits, no one likes to believe that it would hit us, but it can, and it does, unfortunately, as some of us have seen. As I said earlier, Mr. Speaker, there are areas of this bill that need study at committee. I believe that committee needs to look at a couple of things, but that is not insurmountable, and nor something that cannot be addressed. I'm just going to highlight some of those things. For instance, the bill talks about, in the case of a physical injury to a child, an injury is deemed serious if it renders the child unable to carry on regular activities. I'm not sure that the bill is clear on what regular activities are, if it's limited to attending school or other activity. I'm not being picky, but I think it's important for us to be clear on that, and so that it's the interpretation is not wrong. Again, as I mentioned earlier, the other section dealing with while the family leave is restricted to an event happening to the child or the spouse, as I mentioned earlier, how about a father and a mother and the other family member? Now, I don't want to expand it too long, but the mother and the father certainly I consider to be immediate members of the family, obviously. So, but then now, of course, I'm going beyond the age of 18 and 19, and maybe there's something to be said about the age equation. Because I'm not quite sure that if somebody loses a child at the age of 19 or 20, that the impact is that much different, especially if they lose that member of the family through a criminal offense. So that's something that I think it's worthwhile for to discuss at committee. The other aspect of this would be the compassion. We have the question of the cost of somebody are allowing employees and family leave to receive EI special benefits is very important. But the bill allows for a maximum of 52 weeks of special benefits, compared with, say, 6 weeks on compassionate leave and then 15 weeks for sick leave. Maybe I think we might want to look at expanding compassionate care or compassionate leave, and that maybe this particular type of legislation could be in that, because we're going to have different categories. The reason I raise that, Mr. Speaker, is that I know that the Standing Committee on the Status of Women did a study with respect to the reform of EI specifically, and some of the recommendations dealt with compassionate leave, and we're looking at increasing it and expanding compassionate leave. And this might be something that would fit into that area, and I think that it's worthwhile looking into it, because certainly it is something that we may want to discuss and potentially change. Compassionate care and compassionate leave is something that we already have in the legislation in the EI, and it'd be something that maybe we could be expanding. The other thing, too, I think the committee also looked at taking some of these things out of EI, so that's something that we would want to look at, and I thought that's important. Now, the Canada Labour Code currently does not specify that an individual can take up unpaid leave when his or her family has suffered a major loss, including the death of spouse, common law, or child as a result of suicide or as a result of a criminal offense, nor if a child has gone missing. So, as I said earlier, Mr. Speaker, well, it's not there. I understand that the honourable member is what the honourable member is trying to accomplish with this bill. However, there are some clarifications I think the committee should look at, and this is, I'm just suggesting that we will support the bill, but that some of these things probably could be looked at committee to clarify further and ensure that when the bill comes back to the House, it would have some more clarity in some areas. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Hamilton Mountain.
Thank you very much, Mr. Speaker. I'm delighted to speak on Bill 343, an act to amend the Canada Labour Code and the Employment Insurance Act, Family Leave, brought forward by my colleague, the member for Compton-Stansted. As the title suggests, this is indeed a bill that seeks to reform Canada's labour laws. But in essence, it's about our society's treatment of victims of crime. I'll be interested to see how members of the Conservative Party end up voting on this bill. Their rhetoric, of course, is all about law and order. It's all about getting tough on crime. Yet if we look back on all of the bills that have been introduced in this House under the auspices of the government's crime agenda, it becomes painfully obvious that it has focused almost exclusively on the offenders and how they are treated by the criminal justice system. As I've said elsewhere, when those bills made sense, I was proud to stand in my place to support them. Other bills I voted against because, in the view of experts, they constituted bad public policy. But throughout the countless hours of debate that we've had on these bills, I don't recount the government bringing forward a single piece of legislation that spoke to the needs of the victims of crime. Surely we need to be smart on crime and not just tough on crime. Instead of focusing solely on the enforcement side of the law, a smart agenda on crime needs to incorporate policies on prevention, and it needs to have a plan for assisting the victims of crime. Historically, the criminal justice system consisted of two parties, the offender and the victim. The victim initiated and handled the prosecution of the offender. That scenario is a far cry from the scenario we have today, where the only two parties involved are the offender and the state, and where the victim is at most a witness for the prosecution. Today, a crime is considered to have been committed against the state, not against the victim. Through years of determination and hard work, the voices of victims began to be heard. Change began when victims themselves began to speak out about the system and its shortcomings. When police and others within the system began to validate what the victims were saying and supporting their message, people began to take notice. The victims' rights movement in Canada really has its foundation in the feminist movement and the results they obtained for women victimized by domestic violence and sexual assault. In Canada, since the early 1980s, victims' organizations like Victims of Violence and Caveat have convinced various governments that the role of the victim in the process is an important one and that it should be recognized. Changes with regards to the criminal code and victims' rights legislation were a direct result of the courage displayed by victims who have allowed society to benefit from their experience within the system. Their influence is not limited to ensuring that victims have their rights respected throughout the process, but as well with regards to legislation that will prevent future victims. And they want to enhance services and promote justice for all victims of crime and tragedy. It is out of this strong advocacy tradition that support for Bill C-343 has grown. The impact of serious crimes or tragedies is not just felt by victims in the realm of the criminal justice system. It is felt in all aspects of their lives. And with the vast majority of adults participating in the labour force, it is immediately felt in the competing demands of work and family. Even in the absence of personal tragedies, it is a challenge for working Canadians to meet the demands of both their jobs and their families. According to an Ipsos Reid poll in October of 2000, balancing work with home and personal life was the greatest source of stress for 45% of Canadians. The poll also showed that 40% of Canadians say their stress has increased over the past 5 years, while 21% say it has remained the same. There are a whole host of reasons for that. First, about 70% of women with young children are in the labour force. More than 15% of families with children are led by single parents, the vast majority of them women. 18% of Canada's population has a disability, yet there is still almost no accommodation of their work and family needs. As the aged population grows, more and more working Canadians are faced with caring for elderly relatives. In fact, 1 in 4 Canadians now provide some form of care to an elderly relative. Clearly, balancing work and family life has become a critical problem for workers right across our country. But imagine how much worse those already existing pressures become during times of personal tragedy. Imagine the pressures when a child or spouse commits suicide. Put yourself in the shoes of a parent whose child has disappeared. Imagine trying to cope with the aftermath of a child being seriously injured as a result of a criminal offense. And what would happen to your family if your child or spouse died as a result of a criminal offense? Thankfully, for most of us, those are pressures we may never have to face. But that doesn't mean that we don't have an obligation to recognize them, understand them, and accommodate them. And that's precisely what the bill before us today is all about. Many jurisdictions in Canada have already incorporated some provisions dealing with family leave and compassionate care leave into their employment laws. In other areas, it has been the labour movement that has fought for these benefits on behalf of its members at the bargaining table. Negotiated agreements often provide much better protection for organised workers than employment standards legislation offers. But the labour movement never rests on its laurels. It keeps alive the spirit of CCF NDP founder J.S. Woodsworth by acting on the credo, "What we wish for ourselves, we desire for all." And in that way, the labour movement fights for all workers in our country and not just its membership. That's why the Canadian Labour Congress, representing over 3 million workers in Canada, supports the legislation that is before us today. Like members in this House, the Congress is keenly aware that the only jurisdiction in Canada that currently has legislation to assist families who are victims of crime is the province of Quebec. And that simply isn't good enough. Victims' rights should be recognized from coast to coast to coast. Now, it is true that the Canada Labour Code only sets labour standards for employers and to employees under federal jurisdiction. These include sectors such as air and marine transportation, interprovincial and international rail, road and pipeline transportation, banking, broadcasting, telecommunications, and crown corporations. But since the federal government is often seen as setting the national standard that provinces then follow, it is imperative that these amendments to the Canada Labour Code get adopted. So let me just briefly address the details of what the bill proposes. Bill C-343 is a 9-clause bill that would modify the Canada Labour Code to allow employees to take unpaid family leave because of A, a serious physical injury to their minor child as a result of a serious criminal offence, B, the disappearance of their minor child, C, the suicide of their spouse, common law partner or child, or D, the death of their spouse, common law partner or child as a result of a criminal offence. Importantly, it would then also amend the Employment Insurance Act to allow employees on family leave to receive special benefits. Now, the precise wording of the bill does raise some questions for me, and unfortunately, debate at second reading does not allow the author of the bill to respond to my concerns in this House. These are not questions whose answers will determine my support for the bill. I do support its intent unequivocally. Rather, my concerns are of a more technical nature, and I'm certain that we'll be able to work out the details once the bill gets into committee. But let me flag them briefly so that the member from Compton-Stanstead will be aware. Why, for example, does our bill offer 104 weeks of leave for a physical injury that prevents a child from carrying on regular activities, while the disappearance of a child only leads to a maximum of 52 weeks of leave? Why is family leave restricted to an event happening to a child or spouse? How about a father or mother or another family member living in the same residence? The bill deems an injury to a child serious if it, quote, renders the child unable to carry on regular activities. It's not clear to me whether regular activities are limited to attending school. And finally, the bill suggests that nothing prevents an employer from dismissing, suspending, or reassigning an employee if the consequences of the criminal offence or the repetitive nature of the leave constitute a just and sufficient cause. I worry that this may contradict what I understood to be the essence of this bill, which is to allow employees to take an unpaid family leave in such circumstances and to be protected from dismissal for this reason. Again, though, I am confident that we can resolve these issues in committee. For now, let me just commend the member from Compton-Stanstead for bringing this bill forward, and I look forward to working with her as we amend Canada's labour laws to support victims of crime. Thank you very much, Mr. Speaker.
Reprise du débat.
Resuming debate, the Honourable Member for Chambly-Portua. Thank you, Mr. Speaker. Mr. Speaker, I think that I must begin by congratulating my colleague for Compton-Stanstead for tabling this bill and for her excellent explanation of its provisions. The examples that she gave us, the quotes from families, reminds all of us about difficult outcomes of crime, unexpected disappearances, etc. Now, if that shook us up, that kind of news, imagine the situation facing the families who are facing this kind of a tragedy. Now, it's important to remember that there are people who continue to suffer as a result of these crimes, and the challenge that we face is such that colleagues from all parties understand the scope of this bill. Even if the intentions vary, we saw the remarks by the parliamentary secretary, who said that he understood the purpose or intention of the bill. And his remarks were such that I understood he would be voting in favor of the bill. And that disoriented me a little bit because I listened very carefully to what he said. And he, too, was very sensitive to the situation and understood the intention and purpose of this bill. And he opened his remarks, began by, in fact, saying that he fully understood the intention of this bill. Now, Mr. Speaker, victims of criminal action who are directly concerned face a serious tragedy. But then there are also the people who are close to them, who help them, and who in many cases are forced to deal with an intolerable situation, a situation that forces them to leave their jobs. Now in Quebec, up until September 2007, there was nothing for those victims. Quebec, through Bill C-58, took measures to implement provisions to enable those people to take leave from their employment for 1 year or 2 years, depending on the nature of the crime or the event that has occurred. And when I talk about event or crime, I'm referring to criminal act, suicide, or disappearance. And for suicide or the disappearance, the duration of a leave is 1 year. So employers are required to grant leave for 1 year. With respect to homicide and other issues, it can be up to 2 years. Now, Mr. Speaker, the Quebec Act is very clear with respect to the rights of workers and the obligations for employers. Those rights and obligations allow for leave to be taken, but it is unpaid leave. So we need to offset that situation, compensate for it, because in fact we must acknowledge that we're creating a dual burden for these families. Families in these kinds of situations. Not only are they required to take leave, they have no income because it's unpaid leave. Now my colleague's bill, my colleague for Compton-Stanstead, deals with that. And we need to take action with respect to 2 pieces of legislation. The Canada Labour Code, to create the same provision, one similar to the one that exists in Quebec, to allow leave from work for family-related reasons, either for 1 year or 2 years. Now, colleagues, the colleagues, in fact, who spoke just prior to me, my Liberal colleague and my NDP colleague, both raised the need for some amendments to the Act because they see shortcomings in it. We agree with looking at all measures designed to improve this bill, and that's why we hope that it will be adopted at second reading and considered in committee. The Canada Labour Code must be amended to allow for this form of leave, but that will not, in fact, resolve the issue with respect to benefits. And that's why this legislation would require an amendment to the Employment Insurance Act and regulations, so that for the same period of time as outlined in Quebec, either 1 year or 2 years, based on the nature of the event or the crime, these people would be entitled to an income. It's a technical exercise, Mr. Speaker, and I don't think we need to belabor these technical aspects. We do need to take the time to consider the scope of this bill and consider 2 suggestions that have come in the past by the 3 other parties in this House. First of all to address the solution through measures that are already in place for serious illness, the 15 weeks, or the compassionate care leave that is for 6 weeks. Now, we're prepared to examine that, Mr. Speaker, but it seems to me that we're talking about something completely different. Something that must differentiate these measures from others. And I can announce to my colleagues here that we have a motion to increase the number of weeks in the event of serious illness, and the number of weeks for compassionate care leave. In keeping with the suggestion made by our colleague, the Parliamentary Secretary, in the event of a serious illness and for compassionate care leave. There is a petition that is in circulation and has been for some months now. There are 55,000 signatories. There are another 10,000 who are signing it in order to encourage this House to improve those two measures when people need to take compassionate care or sick leave. So those are completely different things, Mr. Speaker. Now let's get back to the bill introduced by my colleague for Compton-Stanstead, Bill C-343. Mr. Speaker, specifically, this bill will bring in the following measures. How much time do I have left? 2 minutes? 1 minute? Well, I will conclude then by reminding the House of the provisions in Bill C-343. The objective is to amend the Canada Labour Code and the Employment Insurance Act in order to grant benefits to people who are victims of crime or facing disappearance, the disappearance of one of their loved ones. And I will conclude, because if I'm not mistaken, I'm the last person to speak to this bill before we go to a Christmas break. Unless you feel that there is time for my colleague for Richmond Athabasca, he will speak as well. But if not, I would like to wish you happy holidays, Merry Christmas to you and to all colleagues in the House, and to our fellow citizens, and to the people of my riding. Thank you very much, Mr. Speaker.
Resuming debate. The Honourable Member for Elmwood-Transcona.
Well, thank you, Mr. Speaker. I'm very pleased to speak to Bill C-343 today. And this is a very important bill, Mr. Speaker, and one that I think is going to get a lot of support in the House. I'm rather disappointed to hear the Conservatives, make their opinions be known about it, and that they don't feel that it's a bill that they're going to be able to support. In fact, they suggest that somehow they're going to be able to come up with their own piece of legislation to take the place of this and basically, I guess, sell it as part of their crime agenda. But I think that this is a very solidly based piece of legislation. We certainly support it, and in fact, Mr. Speaker, what it does is it extends workplace benefits for victims of crime and their families. In fact, the bill amends the Canada Labour Code to allow employees to take unpaid leave from work for the following family-related reasons. And number one, it's the inability of their minor child to carry on regular activities because the child suffers a serious physical injury during the commission or as a direct result of a criminal offense. And number two, the disappearance of a minor child would be covered under this bill. Also, the suicide of a spouse, common law partner or child, or D, the death of a spouse, common law partner or child during the commission or as a direct result of a criminal offense. These are very stressful in all of these occasions, would be extremely stressful for families, and it's very important that they be allowed to take time off work because there are enormous amounts of stress associated with each and any one of these developments. Certainly, it would be the parties would need counseling to be provided to them. I would think it would be very hard for people to concentrate on what they were trying to do anyway. So certainly, these are major issues to be dealt with. As a matter of fact, I will tell you that in the province of Manitoba and maybe some other provinces, we have had for many years, since 1969, I believe, a fund called the Criminal Injuries Compensation Fund, and that provided benefits to people who have been hurt as a result of criminal acts in the province. And I am surprised. I would be surprised if, in fact, Manitoba is the only province with a Criminal Injuries Compensation Fund, but certainly that is one that I'm aware of. It would also amend the Employment Insurance Act to allow these employees to receive benefits while they are on their leave. And I wanted to point out that this government, talks a lot about crime. In fact, we had an entire week here where all we had were crime bills. It's just like it was almost like a factory. There was a new bill every day of the week on crime, and I rather enjoyed the process, but it was difficult keeping up. The government were announcing, I would read about or see it on CTV that the government was announcing another crime bill, so they had basically 2 days of free coverage on their bill without us even seeing what the bill was all about, and then have to do the research necessary to be able to respond in short order on the bill, and then the very next day there'd be another one, right? And it was just like it was as if it was never going to end. But I'm sure that the government has many more such crime bills planned for the upcoming year. I'm sure they'll be doing that. But when they talk about being tough on crime, of course we always say we want to be smart on crime, not just tough on crime. The fact of the matter is that they talk a great line about the victims of crime, but where are they? Where is this government when it comes time to do something about the victims of crime? They're big on talk, but they're not so big on action. And this bill, by this member, Bill C-343, in fact, does that. This bill does what the government talks about, but doesn't actually do anything about. So I'm really surprised that the government would take the very negative position that it takes on this bill and a lot of other good ideas that members in the opposition come up with. They always kind of got to find a reason why it's a bad idea, why they can't support it. For example, they talk about, just tonight, talked about that they've costed this out already, and the effects of this bill are going to cost the system $340 million to $410 million. Now, how in the world did they come up with a price like that? Do they know what the crime rate is going to be? Supposedly, with all their great initiatives and their crime bills, the crime rate's going to come down, and so there won't be the amount of crime they're talking about here. So how would they be able to project figures like this without knowing what the crime rate is going to be?
Order. The time provided for the consideration of private members' business has now expired, and the order is dropped to the bottom of the order of precedence on the order paper. The honourable member from Elma-Transcona will have 4 minutes remaining when this matter comes before the House again.
This time, pursuant to Standing Order 38, a motion to adjourn the House is deemed to have been put and seconded. Therefore, the question is as follows, that this House do now adjourn. The Honourable Member for Gatineau on museums. It's impossible to arrive at a negotiated agreement with the Canada Museum Corporation. The employees of the War Museum and Museum of Civilization have been on strike since September 21st, 2009. In late August, 92% of the 420 workers voted in favor of a strike. From the beginning, the union indicated clearly to the employer, the mediator, to members of Parliament, and to the public that employees of the Museums Corporation are simply looking for working conditions that are comparable to those offered in other museums and cultural institutions in the region.
Among these conditions, protection against layoffs, protection against subcontracting, a commitment to promoting stable permanent employment, and salaries that are harmonized with those of other museums in the region. The position of the Canadian Museum Corporation leaves much to be desired in all of these aspects. Regarding protection against subcontracting, the Canada Museum Corporation insists on maintaining its ability to lay off employees as it sees fit. In the case of a layoff, the Canadian Museum Corporation refuses to recognize the seniority of these employees. When it comes to protection against subcontracting, the employer wants to maintain the privilege of subcontracting work. With regard to fairer treatment for term employees, the employees wants it to make it more difficult for employees to become permanent. 38% of the staff is temporary. With regard to salary, the position of the employer regarding salaries and other financial considerations means that these employees lag far behind those of other museums in the region, and yet the Canada Museum Corporation recognizes at the outset that recruitment and retention are serious problems. When it comes to the overall situation, the striking workers at the Museum of Civilization and the Canadian War Museum massively rejected the final offer tabled by the Canadian Museum Corporation. They gathered and rejected the offer to the tune of 96%. After the vote, the Public Service Alliance informed the Minister of Labour that it would be impossible to arrive at a negotiated agreement with the Canada Museums Corporation and asked for her direct intervention to settle this dispute without further ado. Statements made by the corporation after the vote simply confirm to what extent the parties are divided on the litigious points. Given the length and intensity of the strike, binding arbitration is a reasonable solution to put an end to this conflict. So we are asking the Minister of Labour to take action to come to a reasonable solution by imposing binding arbitration.
Parliamentary Secretary to the Minister of Human Resources. Thank you, Mr. Speaker. I'm pleased to have this opportunity to provide further information in response to a question raised by the Honourable Member for Gatineau, who obviously has an interest in seeing a positive outcome to this matter, as we all do. Mr. Speaker, the strike at the Museum of Civilization Corporation has been going on since September 21, when 420 members of the Public Service Alliance of Canada walked off the job. All members of this House hope that the parties can resolve this dispute soon, and all members, I'm sure, would urge the parties to give it their best efforts. The Honourable Member from Gatineau would like the Minister to intervene further by imposing arbitration. Well, Mr. Speaker, I would remind the House that the Canada Labour Code provides the foundation of labour relations in our country, and Part 1 in particular outlines the steps that parties, including Labour, management, and the Minister, can take in these situations. Just as importantly, I would like to remind the House that this code is a finely balanced piece of legislation that has been refined over the course of several decades by Parliament with the input and advice of experts who, over the years, have guided various amendments since the original Conciliation Act was passed in the 1900s. The Code is built upon the long tradition of labour legislation and policy to promote common well-being through free collective bargaining and the constructive settlement of disputes. It supports freedom of association and free collective bargaining as the basis of effectual industrial relations. Mr. Speaker, that code balances the interests of both labour and management, and as a result, Canadian labour relations have recently enjoyed a degree of relative stability. The Honourable Member of Gatineau would like to have the Minister and the government intervene in a way that is not appropriate in this case. The best solution is always for the parties to reach a settlement themselves, assisted as needed by conciliators and mediators. Under the Code, the Minister has various options. For example, in this case, when given notice that parties failed to renew or revise the collective agreement, she appointed a conciliation officer on July 3rd. On August 27th, the parties were released from conciliation process. On that date, union members voted 92% in favor of strike action. Mr. Speaker, once the conciliation process has concluded, the Code provides the Minister with the authority to appoint a mediator. This was done on August 31. On September 17, the union gave notice to the employer that it would take strike action on September 21 if a settlement could not be reached. The settlement was not reached, Mr. Speaker, and the union members at the War Museum and the Museum of Civilization did indeed begin their legal strike on September 21. On November 20, the parties agreed to resume bargaining talks with the mediator. However, unfortunately, no settlement was reached. Mr. Speaker, there's another avenue that remains, and that is arbitration. The parties may agree in writing to refer outstanding issues to an arbiter for binding arbitration and determination. Both sides must, however, Mr. Speaker, agree to go to arbitration. Mr. Speaker, the Minister does not have the legal authority to impose arbitration without the consent of both sides. It's clear, Mr. Speaker, that in order to refer their outstanding issues to arbitration, the two parties need to come to agreement. The strikers have voted to pursue arbitration. The Museum of Civilization Corporation has indicated it does not wish to go to arbitration. So there is no legislative authority for the Minister to get involved in this strike by appointing an arbiter to settle a dispute. And so, Mr. Speaker, we would again urge the parties to get back to the bargaining table, to use their best efforts to bring out a resolution they can all live with. Thank you, Mr. Speaker.
The Honourable Member for Gatineau. In this morning's edition of Le Droit, we see that the architect of the Canadian Museum of Civilization, Douglas Cardinal, is outraged to see the employees on strike for 81 days and be treated with such disregard. These people are the custodians of our national treasures and heritage. This is a disgrace. The management of the museum does not want to establish a dialogue and settle this harmoniously. This internationally renowned architect, who's now 75 years old, wanted to speak yesterday in order to express his support for the 420 strikers at the Canadian Museum of Civilization and the War Museum. I am fully in agreement with Mr. Cardinal's statements. The 420 workers are asking the Labour Minister to put an end to this lengthy strike. She must intervene to impose binding arbitration. That is a reasonable solution to put an end to this conflict.
Parliamentary Secretary.
Mr. Speaker, I'd like to remind the honourable members of this House that this is a legal strike and that the Minister of Labour has done everything she can to help resolve this dispute. The Canada Labour Code clearly establishes the roles and responsibilities of the government and the Minister of Labour. In this case, she has exercised every option available to her to help the parties resolve their issues. Any further involvement by the government would be detrimental to the resolution of this labour dispute. The parties have to work together to reach a settlement. If they cannot achieve such resolution, they can both agree to submit all issues to binding arbitration. It's clear, Mr. Speaker, that acting within her authority, the Minister has sought to facilitate a timely and equitable resolution. This is why the Minister is urging the parties to go back to the bargaining table and, with the assistance of a mediator, find a solution to this dispute. Everyone in this House would like to see that, and it is in the interests of everyone. Thank you, Mr. Speaker.
The Honourable Member for Etobicoke North, Health.
Mr. Speaker, in preparing, responding to, and recovering from the H1N1 pandemic, Parliament's focus must be to reduce the rate of hospitalizations, illness, and death, as well as to reduce economic and social impacts. Therefore, our discussions must remain on the winding down of the second wave, as well as preparing for a possible third wave. Having said this, we are here to address a question regarding communication and consistent messaging. Before I address challenges, I do want to recognize the government's effort in producing a guide, information sheets, radio and television ads, etc. during the mid-fall. I also want to recognize Dr. David Butler-Jones, who made himself available to me several times to answer questions regarding vaccine research and safety. Mr. Speaker, however, we missed a window of opportunity in the summer to adequately prepare Canadians for a possible second wave. That is, to first let families know that for the vast majority of Canadians, H1N1 would be a mild illness, but for a small percentage, it would be a very severe, potentially fatal disease. And second, to inform Canadians of the best way to prevent the spread of the disease and to reduce their risk of contracting it. Tragically, it was a bereaved family that shook Canadians' complacency when their young hockey player son passed away. The family wanted other families to know that H1N1 could be deadly so that no other family would have to suffer as theirs had. Mr. Speaker, communication is vital in responding to any crisis, and clear, consistent messages are required. Prior to asking tonight's question in the House, our offices had been inundated by healthcare workers and the public who wanted real answers. Perhaps the greatest confusion surrounded vaccine for pregnant women. The WHO Advisory Panel on Vaccines recommended on July 7th that non-adjuvanted vaccine be used for pregnant women if it were available. However, the government ordered adjuvanted vaccine on August 19th and not August 6th, as earlier stated, and later ordered non-adjuvanted vaccine on September 4th. Why were pregnant women an afterthought? When the WHO made its recommendation in July, there was no safety data for the adjuvanted vaccine in pregnant women, and expectant women fared poorly during past pandemics. The government then recommended that pregnant women wait for the non-adjuvanted vaccine unless the cases of H1N1 were rising in their area. If the woman was over 20 weeks, she should take the adjuvanted vaccine. To add to the confusion, the government then ordered 200,000 doses from Australia. This meant that expectant women in Canada had to make a choice that they should never have had to make: risk getting H1N1 or risk taking a vaccine for which there were not yet clinical trials in pregnant women. Mr. Speaker, the position was eventually clarified, but the damage was done. Research shows that the first message received on a particular subject sets the stage for comparison of all future subjects. That is, if the public hears that the world is flat and someone comes along and says the world is round, the latter message may face some resistance because of preconceived ideas on the subject. Mr. Speaker, preliminary data shows that the vaccine uptake among pregnant women in Manitoba is lower than other priority groups considered at high risk of falling severely ill from H1N1 influenza. Consistent messages are vital, and inconsistent messages will increase anxiety and quickly torpedo credibility of experts.
The Honourable Parliamentary Secretary to the Minister of Health.
Thank you, Mr. Speaker. I appreciate the opportunity to respond in greater detail to the matter raised by the member opposite in regards to the Government of Canada's efforts to keep Canadians apprised of the developments of the H1N1 front. We, on this side of the House, fully recognize the importance of sharing timely information and of conveying it to Canadians in a clear and consistent way. We recognize the need for using multiple communication channels to get the message out. We recognize the need to partner with others to get these messages out, with provinces and territories, with health professionals, and with community organizations. We recognize the need to apply basic principles of risk communication, of ensuring people understand how serious the issue is, what they should expect, the steps they can take to protect themselves and their families, and where to access the latest information. More to the point, Mr. Speaker, we acted on the knowledge, the scope and breadth of our activities to keep Canadians apprised of the latest news of the H1N1 vaccine has been unprecedented. And against a backdrop of constantly evolving scientific knowledge about the virus and ongoing developments on the vaccine production front, we have done an admirable job, an admirable job. I know the honourable member opposite is aware of the diligence with which the Minister of Health has acted to keep all members of the House up to date on this issue. Since the beginning of the outbreak, the Minister of Health and her officials have appeared before the Standing Committee on Health some 10 times. She has participated in multiple debates in the House on this issue and has answered all questions put to her by the opposition fully, responsibly, and respectfully. Mr. Speaker, you know that, the membership knows that, and all honourable members of the House know that. And so, rather than debate subjective issues, Mr. Speaker, let's look at some of the hard facts about how extensive our efforts have been to share information with Canadians on the H1N1 virus, on public health measures, and on the benefits of getting vaccinated. Indeed, our comprehensive Citizens Readiness marketing campaign for the H1N1 flu virus was launched in late April, shortly after the significance of early reports of a potential flu pandemic could be assimilated. Our first step was to immediately issue travel advisories in English, French, and Spanish for travelers coming to Canada from Mexico or visiting Mexico from Canada. And since then, our efforts have remained ongoing and multifaceted. Let me give you a few examples. Since the outbreak was first reported in April, the Minister of Health and FAC officials have participated in no less than 48 separate press conferences. 48, Mr. Speaker. Our fightflu.ca website has had 6 million hits. We have posted guidance documents on the site for families, health professionals, for parents, and businesses. We set up a toll-free 1-800 service to respond to questions from Canadians. To date, some 65,000 Canadians have called and they have been received and answered. We have purchased H1N1 advertising in all mainstream media, including radio, television, and in daily and weekly newspapers. We have posted transit ads, posters, and billboards. We have produced material specifically targeted to First Nations and Inuit communities in English, French, and 5 Inuit dialects. We have also demonstrated our respect for new Canadians by purchasing advertisements in over 300 ethnic newspapers and 500 ethnic radio stations. Mr. Speaker, I want to add, these are impressive efforts, and they've been delivered in close partnership with our provincial and territorial counterparts. We've been working hard to coordinate core messages for H1N1 outreach activities with the provinces and the territories. Senior public health officials and senior public communications experts from all jurisdictions have been meeting on almost a daily basis to get that right and ensure our outreach is mutually reinforcing. Thank you very much, Mr. Speaker.
The Honourable Member for Etobicoke North.
Mr. Speaker, the low uptake of the vaccine among pregnant women today in Manitoba is a tremendous concern. 6% of deaths in the U.S. have been among expectant women, who make up a tiny percentage of the population. Mr. Speaker, confusion also led to the initial ambivalence about the vaccine. When federal officials declared that Canada was in its second wave of the H1N1 pandemic, the poll revealed that almost half of Canadians did not plan on getting the vaccine created to stop it. Mr. Speaker, simply having a vaccine isn't enough to have a successful program. As a result, the Minister and Dr. Butler-Jones were then forced to make a plea to Canadians. There is a very real risk of the flu. Even in its mildest form, it's miserable, and at its worst, it kills. The choice is simple: a safe and effective preventive vaccine or a very real risk of disease. This message, the real facts about immunization, needed to be given during the summer. I call on the government to increase its efforts in order to achieve the target of greater vaccination come January.
The Honourable Parliamentary Secretary.
Mr. Speaker, recent public opinion research underscores the success of the Government of Canada's efforts to keep Canadians informed about H1N1 flu outbreak. For example, a significant part of our citizens' readiness efforts have focused on hand washing and the importance of coughing on one's sleeve. Not surprisingly, in all of our public opinion surveys, unprompted, Canadians name hand washing as an effective way to reduce the risk of getting and spreading the H1N1. Knowledge of cough and sneeze etiquette has also been on the rise sharply. But more to the point, recent polls make it clear that the majority of Canadians are feeling well informed about the H1N1 and are satisfied with the Government of Canada's response to the outbreak. Mr. Speaker, this is likely the last debate of the decade, and I wanted to take a minute to thank my constituents of Oshawa, my colleagues, my staff, for allowing me to be part of this wonderful institution. And I want to wish you and everyone a very Merry Christmas, and God bless Canada. Looking forward to 2010. Thank you, Mr. Speaker.
It being 8:03, pursuant to an order made earlier today, the House stands adjourned until Monday, January 25th, 2010 at 11 a.m., pursuant to Standing Orders 28.2 and 24.1.